Hello, everyone, and welcome to Immigration Talk Show. I'm your host, and I'm going to be with you for this next hour, this session, which is lined up for you, a very interesting one and a topic which you would love. So stay with us. And before we head on with the discussion of the day and also have our guests join us, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, I hope that you've kept that in mind and welcome once again to Immigration Talk Show. And today's lined up discussion is going to be a very interesting one. The topic of discussion is, can H1B visa holders be detained? And we're going to try to understand the immigration policies and also the risks involved. But yes, there is increasing immigration enforcement, evolving policies, high scrutiny, and so much happening, right? Especially with this new administration coming into the picture. Well, we also have many H1B visa holders and employers who are very concerned about the potential risks, and especially when it comes to compliance, legal pitfalls, and even detention for that matter. So, today we're going to discuss with none other than this very distinguished guest who's going to join us today. And she's none other than Isadora Velasquez. Yes, please help me welcome her. Hi, Isa. How are you doing today?
Join you. Well, very happy to join you. I'm doing very well today, and I'm sorry we have to discuss this topic, but I think it's really relevant, as you mentioned in the introduction. There are detentions going on today. It is a bit of a promise that we had from the administration that took over. So it's good to know our rights and what we can do to protect ourselves and whether we can run the risk of detention under this current precedent that we have. So I'll let any of you ask me questions, including, of course, of you, Nipasa. So take it away.
Thank you so much. And folks out there, we have attorney Isadora, who has dedicated over 15 years to immigration law, fighting for individuals and families, in a wide range of cases. So please feel free to join us with your questions. And yes, we also have a phone number actually where you can phone call to ask the questions yourself and maybe even get onto a short discussion. And the number is 425-436-6335, and the access code is 988-888. So, yes, Isa, like you said, this is a very timely topic, and it's crazy because it's not like earlier, when you talk about H1B this year. And there have been changes, of course, since fiscal year 2025, we saw that. And now the fee hike. And so many things are, governing what is happening to H1B right now. So, where should we start? What can people out there expect from today's discussion?
Okay, so when it comes to detention, I want to point out that it's not that the law itself has changed. Nothing has actually changed when it comes to detention. The elements, the requirements to detain anyone in the United States are the same. What has changed is the intensity in which these detentions are occurring. During the campaign, we heard a lot from the Trump or current president about conducting mass deportations. In order to get to the level promised, detentions had to occur. What we've noticed in the first 100 days of this presidency is a large volume of detentions. Most of them have not led to the deportations promised because there are due process and steps that need to be taken for these deportations to occur. People have rights and can present your case before a judge. But we have noticed that many cases that normally wouldn't lead to a detention, that would normally lead to a case maybe let go or just overlooked, are now being processed in detention. So that's why I appreciate having the opportunity to explain when a case, particularly an H1B visa, could be subject to detention, so that we know it's not a change in the law. It's just something that we need to be on the lookout. Obviously, the most common way is we need to understand that a visa can be revoked in all candor for any reason. The US, the same way they issue the visas, they have the authority to revoke said visas. The most common way to revoke a visa is when we are accused of a crime. This is an important distinction because we don't necessarily need to be actually convicted of a crime. The simple accusation is enough. And this is also important because the government recently passed significant law, a new law called the Laken-Riley Act, that also encourages the government to actually seek forward detention of anyone accused of certain crimes, particularly violent crimes or crimes of theft. So keep that in mind, that if you are accused of a crime, of course, that will lead to the revocation of your visa, but it would definitely lead to your detention, but based on this new law. If you're coming into the airport, that is typically the most common way for H1B holders to be detained, because that's typically the most common way in which they tend to find out whether or not their visa has been revoked. Based on past experiences, the Muslim ban was very controversial back during the prior Trump administration. And it was a very controversial way in which people found out their visas being revoked. And it actually led not so much to detentions, but to people not being allowed into the US, even when they had a valid H1B visa. So far, we haven't received any announcements of any potential bans. We have received potential travel bans for particular countries such as Cuba and Haiti. They have yet to go into effect, and we don't know if they will affect visas such as the H1B visa already issued. We will keep you informed if that were to happen. But revocation of visas, to answer the broad question, would be the main way that H1B holders would be detained if they're already in the US. And now, if they're coming into the US and they seek to come in, they could be detained seeking to come in, if they're either to be returned or to simply not allowed into the country.
And when you talk about the Muslim ban, I'm sure you know there are folks already in the United States from maybe few from those countries. What's going to happen to them?
Well, the Muslim ban, although it was upheld by the Supreme Court, what was interesting about that particular section is that it only affected individuals who were already out. So if you were in the US when the Muslim ban went into effect back then in the prior Trump administration, it didn't revoke your visa in the US. It simply meant that when you were trying to come in, you were not allowed into the country. It did force many attorneys like myself back then to make sure that the visa that you had, that the status that you had was being enforced, because there's a difference between seeking admission. When you're coming into the airport, you're seeking admission, and that's where people found that their valid visas were not eligible to come into the US. But for people who were already in the Muslim ban, they were already admitted, they already had a valid I-94. And although their visas may have been revoked based on the Muslim ban, meaning they couldn't no longer travel, their I-94, which is the document we received letting us know how long we could stay in the US, allowed the individuals to stay in the country for the amount of time allowed. So for the individuals who are already here from the countries listed in the Muslim ban, they're okay as long as their I-94 allows it.
That is very interesting. And I think at this moment, we should just not travel, stay in the United States. And what do you say, Isa?
Yes, I would recommend. I know it sounds sad and extreme, but I agree with you, Nipa. I think if you have your I-94 and it has a set amount of time, very important. I encourage anyone watching, check your I-94. If you don't know where to have it, you lost it, you've never had it, I maybe we should put it on the chat. There's a website where you can find the status of your I-94. And once again, this document is the one that tells you how long you're allowed to stay in the US, and take advantage of it. It will tell you when you're supposed to leave. And as Nipa said, don't travel unless you have to. I know it sounds sad. We want to visit our friends and family, but now is not the time. Things are interesting. There are many changes happening. We wake up every day to a new executive order. Until things settle down and we know exactly what's going on with immigration, let's stay still and not travel for a while.
Yes, good one. Thank you, Isa. And with that said, and what you were just speaking earlier, do you have any cases or examples of recent cases this year, where H1B visa holders were actually stopped and at the airport and even detained for that matter? And what could be the main reasons?
Yes, and I'm actually going to go and take advantage to answer your question and go ahead and answer Vika's question. So Vika's asked about he's been or she has been on an H1B for 3 years and heard about somebody getting detained at the airport after returning from India. Why would this happen? That has actually been a case that I have dealt with recently. People returning with H1B. Why would it happen? And that's why I gave the example of my clients being accused of crimes returning on an H1B and getting detained at the airport, and at the airport finding out that the simple accusation, what we may sometimes may call an arrest warrant, was enough to have that visa revoked. So it's very important that we keep track of our visa the same way I mentioned before, keeping track of our H1B. We need to understand that the US, when it comes to visas, and this is not just for H1B, it can apply to a student visa, it can apply to all visas. They can be revoked unilaterally by the United States government. So if a visa is revoked, you could be detained coming from any country at the airport because you are seeking admission. Now, when you're detained at the airport, one of two things could happen. The government can ask you to withdraw your admission, which would mean that you're simply choosing to go back, or you can state the reasons. You can try to fight your admission. Understand that if it is that your visa is revoked, they have to state the reasons, but they also can, coming into the US is the analogy of coming into the club. If I don't like your outfit, I can tell you no sneakers allowed, and I'm not going to let you in, and I'm not going to let you in. The only people who are allowed into the club all the time, no matter what, would be US citizens. Not even residents have the privilege of going into the VIP room all the time. So because of that reason, keep in mind that even if you want to fight for your right to get in, you might not have the right to do so. The only way to fight all the way to get in is if you're seeking asylum. So the only way to actually push for your entry would be to seek asylum, argue that you are afraid to go back home, have a credible fear interview. Be very cautious with this, as they would close your door to go back home. Personally, I would not encourage anyone to seek asylum, to have what they call the credible fear interview, unless it is absolutely necessary. Coming into the US seeking asylum solely to continue working, I do not believe it's the best choice if in case a visa has been revoked and for any reason they're not letting you in. The,
Well, yeah.
the question continues to worst case scenario, if you get detained, how long could you be held in the process to get released? And I kind of hinted as to the worst case scenario. The worst case scenario is when they're not giving you a chance to explain, when you haven't been allowed visas at the airport in particularly. It's not a place where you can appeal a decision. Once a visa is revoked, there's not an appeal process. It's not when a visa is denied at the embassy where you can apply again. It is revoked at the airport. There's not an appeal process. You could be detained up to 24 hours until they send you back. So the worst case scenario would be just that you have no other choice but to seek a credible fear interview in order to come to the US. Understand that, for example, if your visa were to be revoked, as one extreme example, because they think your employer is not real, or because if they're a student and they think you're not studying full time, or the example I gave because of any criminal history, you don't
Mhm.
have the right to appeal the particular circumstances of the revocation of your visa at the airport. You can only fight to come to the US to seek asylum. So that's worst case scenario. You can only either go back home or seek asylum to come to the US. Sorry about
Okay.
that.
I know it doesn't sound really pretty, but also when you talk about, crime, I mean, for a person under H1B, crime, whether you're talking about the home country or in the US or both ways, it's still
Both,
a crime.
both. Keep that in mind as well. Sometimes it's a very interesting question because we are asked, have you committed a crime? And we tend to respond, where? I understand that when US asks the question, it means anywhere. And technically, they do have access to all the records anywhere. So we may think, oh, but I have never committed a crime in the United States. But what about that DUI or that minor marijuana charge that I have back in Canada? Well, the US may be aware of it, and maybe it was legal over there, but it's not legal here in the United States. We need to be very conscious of that. And sadly, these are minor things that they can use against us. And again, these are minor things that you can fight and appeal to reapply for your visa, but there might not be things that you can fight and appeal to enter the US in case you're stopped. And there might not be things that you can fight or appeal if you're in the US and you are detained to seek your deportation. And we need to make that distinction. There's a big difference if you're detained coming into the US at the airport, in which your only choice would be to, like I said, seek asylum or get kicked out,
Hmm.
Or if you're in the US and you have an encounter with ICE officers and you are detained in the US in an encounter with ICE officers and you are detained, you do have certain rights. Only an immigration officer can remove you. I'm sorry, an immigration judge can remove you. If you have been in the US for more than 2 years, and this goes back to the individual who mentioned that they have been in the H1B for 3 years, if you have an encounter with ICE and you are detained not at the airport, but in the US, you have the right to appear before a judge, even if your visa is revoked. And there you may have the right to fight for why your visa may be revoked. So that's the big difference between at the airport, where your rights are very limited. You may only have the right to go back home or to fight for asylum, while in the US, where you can fight for why is your visa being revoked. Is it because they're alleging that your job is not real? Is it they're alleging you're not really a student? You can fight for it if you are detained in the US, while it's different if you are detained at the airport.
Okay. Thank you, Isa, for taking that up. And it relates me to this question from Chandra asking, if I get arrested for something minor while on H1B, does that automatically put me at risk of detention?
Yes, because and I'm sorry to answer so quickly and so adamantly, but yes, because technically the Department of State can automatically revoke your H1B. We see that this used to seldomly happen. If it was something minor, shoplifting, smoking a joint, we noticed that H1B wouldn't be affected by it. But lately, or in certain administrations, H1Bs could be affected by a minor DUI. So keep that in mind. Because the H1B could be affected by minor crimes, any visa could be revoked by minor crimes, leaving you without status. Yes, you could be detained by being without status. If a visa is revoked, you lose your I-94 status. The argument here would be that you remain legal until your I-94 expires, which is why I encourage everyone to keep checking your I-94 regularly, because the defense for anyone whose visa is revoked while in the US is that you're still allowed in the US for the time allowed when you came in on your I-94, which once again is a document you that allows you to stay in the US for the time mentioned in it.
Mhm, mhm. Right. And, before we really started this program, we were talking about scrutiny, social media. So, of course, there has been a lot of changes, especially with the new administration coming into the picture. It's President Trump now. And how has these, latest immigration policies changed things for H1B visa holders? You're saying that there's not real change in law, but there are changes happening and it's governing. Even it's affecting H1B visa holders for sure. So, are they facing more scrutiny now?
Correct. You will notice that your applications will get a lot longer. They will include a lot more information that are already there, but in greater detail about your social media. You may notice the lines at the airport also getting a little bit longer, maybe because of shorter staff, but also because this already started before, but now it has been announced that it will be done with greater scrutiny, as Nipa mentioned. The going through your phone, the checking your social media, and by the way, this is also going to be done allegedly to U.S. citizens, and it's not just with this administration. It was announced with the prior administration as well. But it has been emphasized that for all visas, not just H1Bs, there will be greater scrutiny placed on social media. And now, once again, your phone, your WhatsApp messages. I personally encourage my clients, all of them, to delete social media when you're coming in through the airport. Then again, I must confess, officers do ask you. They find it rather suspicious that you don't have TikTok or WhatsApp or Instagram on your phone, especially depending on our age when we show up. So they will ask you about it. So just be ready to answer. Maybe you're a very healthy individual who has no need for social media. If you're an individual working on tech, it might be kind of interesting if you don't have any of it on your phone. So just be ready to explain it, because yes, there will be a lot more scrutiny on it. And we do expect the visa applications and renewals to include many more questions and to get a lot longer. They keep growing every year and they might be getting longer. If we have any repetition of the 4 years before that we had with prior President Trump, we know that a lot of money was spent investigating people, and this is probably going to be another year, another 4 years of more investigations, just to make sure that when visas are approved, your background check is very clean.
So true, so true. And I think we would just have to say goodbye to side businesses, whether it's even selling a small thing or making a small amount of dollars. But I think, yes, high scrutiny is just going to be there, not just now or just for the next month, but I think it's going to prevail for the whole of Trump's 2.0. So let's get ready for all of that.
Yes.
And yeah. So also, Isa, if you could also tell me about the the talk about fairness for high skilled immigrants act. There has been this talk, and could this really help H1B visa holders feel more secure, or does it not really affect detention risks?
It depends who you ask, because the focus of the act has been more on the caps, and but the caps on country conditions, on certain countries, and saying that some countries, particularly India, would be more delayed because there are certain visas issued per country. That this is the most you can get. That has been the focus, to make it fair for everyone. No caps. We're just going to apply blindly for everyone. Some people say that's not fair, because for example, the visa lottery, which is a separate visa, is based on people who can't come to the U.S. On other visas, and they apply to the visa lottery because there's not enough diversity of certain countries inside the US. So that's the balancing. There's a lot of debate on it. Personally, the President Trump recently issued an address to Congress in which one of his few remarks on immigration said that the government didn't need immigration reform. It just needed a new president, and he was it. So I do not believe that this act will actually be approved, at least this year, for or in the near future, as long as Mr. Trump is president. I do think that if it is tweaked in certain areas, it would be beneficial, but the focus so far has been on the caps for visas, not really on ensuring that protections such as not revoking visas unilaterally are taken seriously. I do hope language is included, because I do think revoking without letting the person know it's not fair. But so far, that has not been the main focus of the government.
I know it's all surprising whether you talk about raids, you talk about anything that the Trump administration is doing just to catch hold and let you off the country.
Yeah.
So that is there. And also, I'd just like to say hi, once again to Chandra, Vikas, and folks out there who have joined us with your questions. Please don't forget to like, share, and also subscribe to our channel if you haven't as yet already. It is Immigration Talk Show on YouTube, and you can also check us out on LinkedIn, Facebook, Instagram, and also on X. I mean, it's just because we were talking about social media. I remember that I have to do this too. So connect with us and stay connected, friends. And yeah, we have Ayush. I also was reading this news yesterday. So DHS has really introduced this new app where migrants can share their intention to self-deport. So if I
Yeah.
do so, will this ban me from coming to the US forever?
Okay, so let me explain. If for individuals, if you leave the U.S. and you have been in the United States without status, or you enter the country illegally to the border, or where you've been in the U.S. for more than 180 days without status, you may think you're leaving and everything's okay, but in reality, you are deporting yourself, and which is really important. So this app, I actually think, is helpful for people who have been in the U.S. for less than 180 days without status, meaning your H1B expired, you didn't renew it, and you've been in the US for less than 6 months without status and you want to leave, it would be helpful to put it in the app, because that way the US will know, okay, you left, and there wouldn't be actual any negative consequences to you, because you didn't accumulate enough time illegally in the US to have these negative consequences. However, if you were in the US illegally for more than 6 months, the app doesn't really clarify if there will be consequences or not. It will simply say that you will be letting them know that you left. You will be helping the government because they won't have to look for you to deport you. But it doesn't really clarify. It says that maybe later on you could apply for the visa, but the government hasn't really guaranteed that it won't have any negative effect. So what I've been telling my clients is to use it only if they are sure 100%, I know I'm going to leave. There's no way I'm going to stay. I'm leaving, I want to let the government know, then yes, go ahead and use it. Might as well do it because you're leaving. You want to let the government know, but don't use it expecting that by doing so or by reporting yourself, you're going to be able to later apply for a visa and come in with a problems. The reality is that if you stayed in the US illegally for more than 6 months, you
Mhm.
cannot return for 3 years. And if you stayed illegally for over a year, you cannot return for 10 years. And you must apply for a new visa. And it may be that even after the 10 years, you might not be allowed back. So the app is a bit tricky. I think it's lacking some language that clarifies. But if you know you're leaving and you really want to go, might as well report. But don't assume that simply by reporting, you will be okay. There's another important app that I think you guys should know about, and it applies for anyone who comes in. Interestingly, for H1B in particularly, it wouldn't apply immediately. It applies mainly to tourists. Canadians, for example, are very upset over it. And the government has always requested that all immigrants keep the government informed when they're here for more than 30 days.
Mhm.
This is an auto report app, I guess you could call it, or a system, or now all immigrants must report to the government. It's mandatory. It has always been mandatory, but now there's a specific website that we must use. I mentioned Canadians because they have always been allowed into the US without visas for up to 6 months, and now they're being forced to report, which they're not big fans of. But
Mhm.
it has specific exceptions. For example, asylum seekers don't have to report. H1Bs, because you report at the airport, technically don't have to report. But it's important to be on the lookout because the government keeps changing who has to report, who doesn't have to report. I wouldn't want any of you to have to report and miss it and then have your visa revoked over a simple technicality. So keep on the lookout to these executive orders and memorandums that come out, maybe in case you have to put your information in another website, something simple that you may have to do depending on what the news say tomorrow.
Just like an attendance register or maybe like a biometric system. So different ways, but you still have to sign and let the authority know that you're in the country. So treat it like that. And it's always best to do your research properly and play safe. So I'd always say, if you are confused about anything, or just like Ayush has asked about this new app, I mean, consider consulting with an attorney or an expert who knows all these things at the tip of their hands, and they will guide you in the best possible way. So why not also you can choose to consult with attorney Isadora, and you can do so by calling her on her number as well. Her number is 305-938-0676. And you can also email attorney Isadora at isalawyers.com, and go visit www.isalawyers.com. So thank you for that. And thank you, Isa, for telling us about this other app as well. So,
By the
so
way,
much
the
out
app is
there, right? Yeah.
called CVP Home. It used to be CVP1. Now it's called
Yeah.
CVP Home. It's not just a self-deport. You can also use it if you're coming to the US, maybe through the border, and you want to get your I-94 ahead of time to make it faster. You can get it up to 7 days before, and it will make your process easier. So it has other tools besides just self-deporting. Just check it out.
Yes. Thank you. Thank you. That was really a good one. And also, we have Neha who's joined in with a question. We'll quickly take that. So, Neha is asking, are there specific warning signs that an H1B visa holder might be at risk of detention? And what should we watch out for? Interesting.
Well, I recommend all my clients, and this is not just in the Trump administration, all my visa holders, when they travel, I always recommend before they come back, check your emails. The Department of State typically announces any revocations, and if they have any issues with your visas via email. Check your status of your visa online prior to coming in, just in case. I do so as the attorney, but just in case, you can be proactive and do so yourself. Check your I-94 prior to leaving, the one that you had prior to leaving the country, if you had one. So it's good to know that you never overstayed. Just in case you're asked, when was the last time you were in the US? How long did you stay? You will feel comfortable answering those questions. Those tend to be the triggers that may lead to an uncomfortable detention. You stayed more than you had to. Your visa was revoked, you didn't know. You did something or committed a crime, or were accused of a crime you didn't know. Sometimes we leave and there's an arrest after the fact, something we didn't know, somebody with a similar name to us gets in trouble and we are accused. So it's just good to check what we can check. When we're traveling, it's also good to have that conversation. All my clients always have my card. The airport is very tricky because it is, well, I call it no man's land, the same way before I compared it to a club and they have discretion to allow you in or out. You don't have the right to an attorney like we see on TV. You have the right to no, that doesn't apply at the airport. So when you want say you want to call your lawyer, you don't, that doesn't really apply. But if you have somebody's card, which is why I always tell my clients travel with my card, they can call me even if it's at 5 a.m. You can call the attorney, and they tend to have the courtesy. Customs and Border Patrol officers tend to have the courtesy, so that would be a good idea to have with you, the attorney's card, or at least somebody's card. For example, your employer, if you're comfortable with your employer and you think there might be any issue with your job, it's good to have your employer's card. If they don't know where you work, it's a new place of business, it's good to have your employer's information. Those are warning signs, as you had asked, that you can have with you. Show this is where I work, it's a new place of business. You may not be able to Google it because it's brand new, or because understand Customs and Border Patrol, they're not immigration attorneys and they're not even embassy officers. They're not as sophisticated as we may want them to be, so we can educate them. So anything you can bring with you, as annoying as it may be, to make their life easier, to show how good you are, and that's why you got your H1B, bring it with you, even if your bag is a little bit, your carry-on is a little bit heavier than you would have liked. That would be my advice.
That's a good one. And thank you so much, Isa, for taking that up. And Neha has another question to follow. So, is there any bifurcated data available of people who are detained or are at risk of being detained?
So let me see if I understand your question. You mean like know your rights, or um,
I think she means like where can she see how many people are detained? Is there a website or somewhere where they can check out the numbers of
yeah.
people who are detained or who are at risk of being detained?
So ICE, ICE.gov, ICE, baby, yeah, like ICE, the ICE. GOV will give you the number of detentions, and it will also give you the number of deportations. And you'll see there's a big discrepancy. And it should have it. But until recently, they were very criticized, the numbers, because they're big. There's a big difference. The reason there's a big difference is because, as I mentioned at the beginning, it's rather easy to detain somebody. You may detain somebody because when a visa is revoked, they're out of status, or they're accused of a crime, but it's something different to deport someone. It's easy to do at the airport, to deport someone because they're seeking admission. So you can tell them, no, I'm not letting you in, and that's different. But when you're already in the US, for people who have been here over 2 years, you can't send them away. They have the right to appear before a judge. And that's where the Trump administration has face a lot of difficulty. They've noticed a lot of increased detentions, and it's been very difficult in detention centers. So you guys know there's overcrowding in many detention centers. That's why they're using other facilities, like even Guantanamo. But there's not a lot of deportations actually happening because people know their rights. They know they have the right to appear before an immigration judge, and these rights apply to all of you as well.
All right. Well, thank you so much. And Neha, yes, we've already answered that. That's correct. I would like to see the list of people detained. I hope you can find that. But thank you,
Yeah, you
Neha,
won't be
for
able to see,
joining us.
yeah,
Yeah, sorry.
you won't be able to see their names, but you will get an idea of how many numbers. And there's a lot
Mhm.
in ice.gov.
Okay. Well, I wonder why does Neha want to see that? I really hope that you are safe and you haven't done anything that you you would like to see or check if you are in the list. But anyway, jokes apart, thank you, Isa, for that. And also, I have another question about this. The rule for visa interview waivers, which recently changed from 48 months to 12 months. So, how might this also impact H1B holders, especially when traveling internationally?
So what we expect is that it's going to be delays. So before, particularly for any renewals, I'm telling all my clients, if you have to renew, don't wait to apply quickly. Don't any renewals, don't wait. And basically that's the main concern. Renewals are going to take longer because now they're now waiving, and like I said last time, the prior Trump administration cases were going to be taking longer. Because they're going to take longer, that's what we're expecting. Their waivers being shorter, cases are going to take longer. So expect delays, expect that your case might take longer. So if you were planning to apply when your case was going to expire on this day, maybe talk to your immigration attorney and see if you could apply earlier. I emphasize see if you could apply, because sometimes applying too early might not be the best choice, or you might not be even be allowed to apply that early. But check it out. We do. That's what we expect. That's typically what happens when they take away the waiver and interviews. We notice embassies are also saturated. There have been significant layoffs in the Department of State thanks to the Dutch program. So yeah, things are gonna get slower. Be patient. Be really patient, but don't give up. Keep applying. Keep applying. Just be patient and be. We expect things to be slower. Apply earlier, sooner, quicker, and be patient.
Yes. Thank you for that, Isa. Great tips, I would say. And I think we should just not expect too much, but also at the same time, not lose hope, but keep trying. So, also, when you talk about H1B, it's all about big tech companies mostly, especially, and they sponsor so many H1B visas also. So, do you think their employees also have been facing more issues at the border this year?
I think it's a balancing act. In a way, I think the involvement of Elon Musk and how vocal he was of H1B and his support during the campaign, I am hoping it will reflect in how H1Bs, particularly in the tech industry, will be processed. At the same time, as Nipa has mentioned regularly, I do think there will be higher scrutiny overall, not just in H1B, in all visas. So I expect higher scrutiny, particularly in startups. We've noticed many questions on companies, whether they're new, whether they're going to succeed, whether they are stable, whether they can afford it. And that's where we expect it's going to get a little bit tougher. But at the same time, like I said, Elon Musk was very vocal in saying that he was here in the US and Tesla is successful because of the H1B program. So that's where we're hoping it will balance out. So be ready to fully understand your company, fully understand your role. So I think interviews are going to get tougher, but at the same time, I do hope that either that the numbers will get higher, that will be the effect of Elon Musk. It hasn't been announced yet, but I'm hopeful that that will happen, or that in the alternative that it will be more understanding of how we need the tech, because once again, that's how we got Elon into the country. So expect tougher interviews, but at the same time, um, that they said it was good for the economy. So hopefully they'll keep their word in that sense.
Yes, me too. And well, news has it, especially from India, that there has been a very huge drop, when it comes to H1B applications. So I don't know what's going to happen. Will there be enough applicants also registration? What do you say, Isa?
I think with India in particular, the issue has been not so much the tech industry, but the relation between the governments. And if Trump can work better with the Indian government, that hopefully work would lead to an increase not only in applicants but also in approvals. That distance between the relationships in the government has also, not only in the H1B area, but it has affected other visas. The lack of reciprocity and treaties between the governments, I mean, in India and the US, has affected severely the applications, and it's something that we need. Once it starts affecting the economy, I hope that Trump will extend the arm until it starts affecting the economy. I think we'll see that this will continue. But there is an employee shortage at the moment. Once the numbers start coming down, we'll see the visas increase. That's my hope as well.
Right, right. I mean, so much is happening, and like you said, every day we wake up to new news, new changes, and new rules coming up. So a lot to grasp right now, and we'll just have to wait for things and all this dust to settle in. I think after that,
Yeah.
we will be people to know.
Yeah, remember, I'm sure I've seen your videos, so I know you guys are very aware that the lottery is coming up. I think also once that lottery happens and we see the numbers, that we'll get new memorandum, which goes back to our prior points as to don't travel, stay still, see what happens. We'll get new memorandums how we see how many people apply, how many people we get in the lottery. It will lead to new decisions that will severely affect the H1B, the scrutiny, how people, how many visas may be affected by revocations. So we have a lot that may be happening in the next couple of weeks. So we have to wait and see.
We will, we will. We have no other option right now but to just be patient and still keep trying. So, all right, then. Well, Isa, Neha says, thanks for the information given. This helps. So, I'm sure. Thank you so much also to Neha, for your questions. Very interesting and all the best. So, Isa, we also have more questions from our Facebook groups, and I would really want, Control to display some of them. And meanwhile, if you could also tell us, because if an H1B visa holder gets detained or denied at entry, what are their legal options? Can they really fight the decision? We already touched on this, but what should be their next step?
Entry is very complicated because in entry you're not giving many options, if any at all. At entry, individuals who are you're called an arriving alien. Horrible name, I hate it. But as an arriving alien, you have very minimal rights. You have the right to either withdraw your admission. If they're not allowing you in, you can withdraw your admission and they'll gladly send you back home. That might be best because sometimes when we withdraw our admission, we're simply sent back home without a deportation order. And we may want that if we want to reapply for your H1B visa or for any visa, tourist visa, student visa. For example, if they were to tell us we can't find your employer, so we're not going to let you in because we're revoking your H1 visa because we think your employer's fake. That might not be the time to start arguing, oh, it's real. Like I mentioned before, I encourage you to maybe travel with documents already if you know your employer's new or not as easy to find, to show them otherwise so that you can fight it there. But if you have already tried and you haven't had success, the only other remedy, if you can withdraw and you won't be able to fight the case, will be to seek asylum, which would be to request a credible fear interview, which will actually happen or might actually happen at the airport. Or you may get called back to something called deferred inspection, meaning they call you the next day to conduct this credible fear interview. They're incredibly uncomfortable. You have to show that you have suffered past persecution by the government or an agent that the government cannot control in your country. And that's why you cannot go back, because you will suffer future persecution if you go back. By the way, if you show this, then you'll have an asylum claim and you cannot go back home. So personally, I would not recommend it. If your visa is revoked and you know you can fight this, it would be best to simply withdraw your admission, go back home, and try to fix it there. And that way you avoid a deportation order. Sometimes when we fight this and we start saying, no, you're wrong, I can prove to you that my job is real, that I didn't commit that crime, that is not me, and we are fighting it, we end up with what is called an expulsion order. And that is an actual deportation order. And we're not allowed in the US for 5 years. So you could have fixed your visa, maybe applied again for the visa at the embassy, but we can't because now we're deported for 5 years. So knowing that those are the only two choices at the airport, choose wisely unless you're really afraid to go back home and then seek asylum. By the way, warning, arriving aliens do not qualify for bond. So if you are seeking asylum at the airport, you will be detained and placed in jail until your final trial date. So another one of the many reasons why I do not recommend it.
So I like the first option. It sounded better at least.
Yeah, yes, I always tell I get sadly during this current administration. I must warn you guys that I have been receiving phone calls of people that tell me they can't find. They're telling me I get many students who tell me they're accusing me of not going to school, and I don't have my school records. And I've told them it's best to withdraw your admission, I'll work on finding your school records. I will work with your school and will reapply for your student visa, for example. I would prefer for my client to go back home and for me to apply for their student visa again, as an example, instead of them having a deportation order. It's an uncomfortable conversation to have. I know my client doesn't want to go back home. They want to go back to school. They want to go back to work. They want to go on their vacation, but I would much rather not have the deportation order because that's just not a good option. And I really don't want them to not be able to ever go back home by seeking asylum.
There you go. Thank you so much, Isa. I mean, those were really helpful. And yes, I'm sure it is the same for folks out there. So I would say please do not forget to like, share, and also subscribe to our channel. Our handle is at Immigration Talk Show. So check us out, subscribe to us, and hit that bell icon. And it's been great so far with Isa. So, Isa, are you ready for more questions?
Always.
All right, so let's take this one. This is from our Facebook group, I guess. And yes, this is from Priyanka. Being an Indian citizen, if a person got stamped her first H1B visa in a country other than India, will she be eligible for Dropbox in India, provided she has visa expired in the last 12 months?
Yes, that is part of the waiver, this the instructions that they're providing. Each embassy is not, it's providing their instructions online, but all the waiver instructions should be there. And yes, if it's less than the 12 months, you should be able to do it in the Dropbox. So yeah, take advantage of it. I am encouraging all my clients to do the waiver. I mean, before I would always tell them to do it 48, but now 12 months, do it now. And that goes back to the prior question as to what we can expect. There's going to be delays. So don't wait. Do it now. You're a month 10. You think you have time. Do it now. But yes, you should be able to do it in India under the Dropbox. Not an issue.
Okay.
Check the
Kudos,
instructions,
Priyanka.
though. Check the embassy instructions online.
Right, right. Thank you, Isa, for taking that up, and all the best, Priyanka. Now, this next one is from an anonymous participant. This question was also put up 5 hours back. I work as a remote full time in a company as architect, and I'm planning for stamping next week where I have to go through interview. My company said I don't need client letters since I'm full time working as a consultant, and they gave a letter with all my details for counselor appointment. But I work as a consultant for client where they have SOW with us, so I help them customize the product. In this case, do I need a client letter, or since I'm a full time in my company, is the company's recommendation letter enough?
The company's recommendation letter is enough because you're a full-time employee of your company. However, the client recommendation, the client letter would be excellent if you can get it. However, I know that it's not that easy to sometimes go to our boss or to the client. If you can get it, excellent. It would be an amazing benefit to have. However, the company's recommendation letter should be enough. You're a full-time employee. That's all that is required. The client letter would be like the icing on the cake to make sure that the officer fully understands what you do. Because, as you said, you are the consultant for the client, but you're technically working for the company. If we just help put the full picture of what you do, help answer all their questions. So I understand why you want it. I would want it too. But I also understand that sometimes it's difficult to get clients to give us what we want. So know that what you have is enough. If you can get more, that will be better.
Okay. Thank you, Isa. And now let's go on to our next one. This is from Mushhak Musthak. I'm planning to go to India for visa stamping for first time since I moved to US. In the sorry, is this the right time? Am I
No.
eligible for interview? No. Okay. All right. Should I go on then or
Yes, yes, yes. Go. I'll answer everything. I'm sorry.
no, it's cool. Am I eligible for interviews? So my question is, my company says they will give all supporting documents for the interview, but they said I don't need client letter because we have SOW with client and I work in remote and not in client location. Does it seem justifiable for counselor? Is there any case like me?
I have many cases like yours. And what I've been telling my client is, why do we need to go? Like, why do we need the stamp? Is it something that you really need to go home? Is it somebody elderly that you need to visit? Are you feeling really homesick? Why do we need to leave? Because the reality is, to answer your first question, as you heard me abruptly say, no, right now it's not the best time. It's just the embassy right now, and it's not just, it's everywhere. Embassies are being, they're not the most welcoming environment at this point. So if you can avoid it, if it's not really necessary, but I understand there's some things that may be out of our hands. There may be some family responsibilities that we need. So if you to answer the second part of your question, if you have to, it seems to me the documents you have, it seems related to the prior question, there may be sufficient, but the more you have, the better. The bigger picture, the full picture that we can show of what we do, that's best. Sometimes it's difficult to get documents from clients. I understand, because of course the H1B may be your visa, but I have to work as your attorney directly with your employer to get records. And I understand how difficult it may be for employer to get records from clients, how uncomfortable it is to sometimes ask letter from clients. So the more you can get, the better it is. But it seems to me, to answer your question, that what you have is enough for the interview. Make sure you understand it. Make sure you're comfortable with it. Once again, if you have to, because if you don't have to, if you're okay here and you don't have to travel, now it's not the best time to travel if you don't have to. If your time is up and you have to, it's okay. But if not, stay here. We're good here. Spring break. Enjoy the time. I'll take another question. H1B. Okay, so H1B stamping in May. It's 160. Oh, it's submitted within 30 days to that appointment. How do I get? It's not able to retrieve since I didn't submit it within 30 days. But same 160 attached to that appointment. How did I get rid of this to go for same appointment? Oh, I'm not understanding this. Okay, this is what I recommend. If you are using the wrong DS160 and that's the concern, go to your appointment with what you have. I know how difficult it is to get appointment. I wouldn't want to reschedule. The reality is, there's not, rescheduling might be a lot more complicated. So I am failing to fully understand if the issue is that you have the wrong DS160 and your concern is that you're processing the wrong DS160 application. Take with you the correct application and explain it to the officer. Because once again, I understand how difficult it is to get these correct, to get an appointment. It may take a long time. Take the correct application with you, because it may be difficult, if not impossible, to change it. Also, I understand there's an online system. I'm sure you've already emailed them and contacted them a million times to correct this. Keep doing so up until the day of your interview, but make sure you have the correct information and the correct form with you when you go to your interview.
Thank you so much, Isa, for taking that up as well. I was facing it.
It
I'm glad
happens.
to be
Don't
back.
worry.
So
I just hope I
thank you
answered
for
it
taking that
correctly,
up.
because it seems like if he has the wrong application, but I think if you take the correct one, you should be okay, especially if it's just for stamping. If this is your first time, they'll keep your passport.
All right. Thank you, Isa. Thank you for being so awesome too. So patiently taking up all our questions. So next one is also from an anonymous participant asking, I started filing out my DS160 a few days ago and have already booked a Dropbox appointment for my H1B stamping. I had a quick question. Does a DS160 application expire if it remains unsubmitted for too long? I'm holding off on submitting mine because I'm waiting for my updated I-797 and I wanted to ensure that my DS160 reflects the correct details.
So yes, it may expire, but at the same time, you're doing the right thing, because you do want the DS160 to be as fully complete and as accurate as possible. You don't want it to be wrong or to have any mistakes or to have any issues like the prior question where you have the wrong application, the wrong information. They may hold on to, especially now with embassies being so picky, they may hold on to something minor just to either delay your processing or to even deny. So it's annoying, but it's best to hold off to make sure the application is correct. Worst that could happen is that when you go back to try to submit it, it may tell you it's expired and you may have to do it again. And I know that's annoying. I know I'm minimizing it here, being like, oh, you have to do it again. But it would be best to make sure the application is as accurate as it possibly can be. Also, I know you guys know this because you watch this, but make sure you print it, have it with you, bring it with you. So I know it says don't bring it to the appointment, but review it because that's what it will. That's what they will ask you. That's what they will go through during the 10 minutes you'll be there. And that's what they will use for all others. So make sure you're always consistent every time you renew it, because we just talked about how waiver time got shorter. So you want to make sure you're always consistent. So every time, every waiver, you never have any issue and the process is always easy breezy every single time.
Yes, absolutely. Thank you so much, Isa, for doing that. And I think we will move on to our next question now, or have we covered? I think we have covered most of our viewer questions. But,
Good.
we were also talking about legal options, if an H1B visa gets detained or denied. So, what are the legal options? And we've already discussed this. So, what are some key H1B visa holders they should know before they're traveling internationally to avoid these issues when they return?
So the main thing when traveling, like we already mentioned, like checking before, checking your time you've been here, checking how much time you have left. That's the main issue I see with H1, that maybe that 6, 7 years, like you're already up and you didn't realize it. So check how much time you have left, check how much time you've been here. Be so that way the questions they'll ask you at the entry you can feel comfortable answering. The questions about your employer. Where is it located? It may seem, especially now with remote work and CBP officers can be really sneaky and they will ask you, so where's your office? And you're like, I don't know, it's over here. And that's where they tend to question whether you're really working and really doing the H1B. And you may say, but I work remote and I only go to the office once. So it's, keep that in mind and bring evidence with you. It's a brand new office, a brand new place. Here's my card. Here's my boss's information. That's to check. Now, here in the US, like I said, if you have that encounter, it's good for your employer to know not only your rights, but the rights of your employees, your coworkers. What we notice with ICE is because of the desire to meet the numbers and the quotas that President Trump has promoted and has promised to the U.S., there may be not really ICE raids; it's more like ICE encounters, we may call it. And know that here in the U.S., like I said, you have greater rights. So if your encounter with ICE is at your place of employment, they need to have signed warrants by actual judges. So it's good for your employer to know that if they're coming and saying, "Oh, we need to check the H1Bs in this area," it's different from the Department of Labor going to see if employees here are rightly are actual employees than to actually start arresting people. There are certain requirements. So it's good for your employer to know. And if you're for any reason detained or stopped or have any immigration encounter in the US, that's actually the place where you can fight the revocation of your visa. If their visa is revoked because they don't think your employer is real, you can fight that here before an immigration judge. If they're fighting because they don't think you work, you can fight that here before an immigration judge. You have that remedy here, but that's only if you're already, meaning you're not seeking, the legal term is not seeking admission. It's at the
Mhm.
airport where the remedies that you may have are very limited. So it's good, as we've been suggesting, to plan ahead to make sure that you have evidence of always being here legally, evidence of where you work, evidence of the time that you've been here, of what you're going to do, or of where your work is located. Minor details that we normally don't think about. And now might be a good time to keep in mind just in case.
Thank you so much, Isa. Thank you, really. It's been such a great discussion. I don't want this to end, but we've already covered an hour, so I might have to let you go for now. But if you still have a couple more minutes, I would still have more questions. What do you say?
I will take the minutes. I'll gladly answer any questions.
All right. So this next one is actually a case study where I was reading more about it. So there was a software engineer working in Silicon Valley and went to India for a work trip. But when he came back, CBP detained him over an old traffic related misdemeanor. So his visa was revoked and he was placed in expedited removal. So how could he challenge this, and what options does he have to fix his status?
And that's where I mentioned the importance of checking your visa status before. And that's where you can check your email. The DS-160 that we've been mentioning continuously, we put our email address there where they would communicate if our status, if our visa has been revoked for any reason. This individual maybe use their email address from 1998, and that's where they emailed us. Although the Department of State sometimes is notorious for not even emailing us or simply thinking that we're going to know our visas revoked by magic. So we'll give him the benefit of the doubt that maybe he didn't get the email and that's why he didn't know. But if you have your DS-160, make sure you check the email address that you used in that form. So that's where you would know what's the status of your visa, number one. Number two, for him, it would be relevant to see, understand that anyone who is in the US for less than 2 years could be subject to, as Nipa mentioned, expedited removal. So if you are seeking admission, if you're coming into the US, you obviously been in the US less than 2 years, you just got here. So they can kick you out right away. So in that particular case, if he would had emphasized, as we had a prior somebody else previously asked, they had been working on an H1B for 3 years, it would have been helpful for him to argue, oh, I've been working on this visa for a certain amount of time. This was a very brief trip that I took. There are many circumstances that may have helped him fight his case at the airport. But remember that we have discussed that at the airport, your options are very limited. You can withdraw your admission and that way avoid the expedited removal, because expedited removal is a deportation. That's the deportation that I was mentioning that bars you from the US for 5 years from the airport. Or you can seek asylum, which will keep you in jail until you can prove that you can't go back to your country due to persecution from the government or an agent the government can't control. So in his case, it would have been best to, if it is a traffic charge, once again, sadly, the US can revoke your visa for any reason. And a traffic misdemeanor can include driving without a license, it can include a DUI, and these reasons are very difficult to fight. So while we can later on argue if they were to revoke your visa because they argue your employer is not real, you can apply and prove that your employer is real. Or if they revoke your visa because they argue you're not working, and you can apply later on saying you are working indeed. When it's something criminal like a traffic misdemeanor, because it is a decision from the Department of State, it is very difficult to have that visa reinstated later on, and even more difficult if you already have an expedited removal order because of the 5 year bar that I mentioned. So for him, he would have to either fight the traffic charge, either argue that it's not him, or it will have to be that it's not him, because if it is him, there's nothing he can do. He would have to wait the 5 years, and after 5 years, try to reapply for the visa. If he has any family in the US, it would have to be a qualifying relative, a spouse or a child, or maybe a parent. He can ask for a waiver. Sorry, long answer for a sad response.
No, but I mean, totally makes sense, and I think you'll just have to play safe with all your time out there under a visa. So, I mean, try not to fall into, even though they may look small to you, but it's not really small. It could be getting more
Yes.
complicated a little later. So, thank you so much, Isa, for taking that up. You wanted to add something?
Well, the main point I wanted to ask that to add is that right now, sadly, visas can be revoked being only on based on the accusation. That's why the Lake and Riley Act is so controversial, because it is allowing people to be placed on removal proceedings, which was what we call deportation proceedings, and technically to be detained only by being accused. So that would also mean that even if, and that's also why I keep emphasizing to check your visa before coming,
Mhm.
because you may have this traffic infraction that you think you paid and it's old, and because it spent so long that you didn't pay it, or I don't know, nothing happened with it, now it turns into a misdemeanor, and it just gives the government the authority to revoke it. So just check ahead of time, play it safe.
Absolutely. Thank you, Isa, for taking that up. And maybe before we leave, if you could, Tell what should employers be doing to make sure their H1B workers don't run into legal trouble, especially with all the policy changes that are happening so fast and every day.
First, I'm going to answer the whether traffic infractions affect the B1, B2 visa applicants as well. It affects everyone. Traffic infractions, they sound silly, and I never thought before during the Obama administration, for example. I've been practicing for a while. I'm rather old. I would tell no, no, no effect. But I noticed, maybe because I live in Miami where people drive very well, they accumulate and they do have an effect. And they, because visas are issued, particularly B1, B2, which are tourist visas, are issued at the discretion of the consular officer. An officer might, at their discretion, and the Department of State, the Attorney General, who are the ones that monitor these visas, may, are at their discretion, determine that you have way too many traffic tickets, and they can withdraw, they can revoke your visa. So be careful. Don't drive like me. They may have an effect. These regulations, the decisions to revoke a visa, are fully discretionary. So because of that, there may not be written black and white in our laws and regulations. So keep that in mind. So yes, traffic infractions could affect even a B1, B2 tourist visa. As to employers, what we can do to protect our employees, I'll tell you my latest case. My employer, I don't know why, I don't know what they were thinking. They were a little bit too laid back with my employee and decided to, I guess, make them partner. I don't know, give them an interest in the company, which is great. But when you make somebody partner, when you include them in the company, you must continue payroll. H1B, one of the main requirements is continue payroll. So make sure your employers keep paying you. And by paying you, I mean that you remain a W-2 employee. Because you are now a partner, or because you are now an essential employee, because there maybe later on will petition for your green card or whatever, you're growing in the company, the tech startup is now a tech big boy, whatever, you're growing, great. It doesn't mean that now because you have the credit card in the company and you're taking the money directly from the bank account, that may happen, that's okay. But you must remember, you must remain a W-2 employee. You must remain in payroll. I've noticed many employers that as they grow, they feel comfortable with the employees, they give them more responsibilities, and by giving them access to the company, they I guess relax with the payroll and HR requirements. I don't know what's going on, but it has led to a lot of questions when now the waiver and the renewals. I also noticed, I think this had to do with, because of the waivers, people were a little bit more relaxed when it came to reapplying. And now that the waiver is the less time, I am preparing more applications, and I've noticed these mistakes from employers. And I am very worried about whether these visas will be renewed and many issues that may come up. So make sure your employers keep paying you W-2 always. Also, for ICE raids, which have been, I live in Miami, Florida. I practice all over the world, but I live in Miami, Florida. And here in Miami, Florida, there have been ICE raids. None of the ICE raids have occurred fully under the law, meaning that the warrants that the officers have used, none of them have been signed by actual judges. They have been administrative warrants. And so I mention this to all of you because it was not until after that employers realized, wait a minute, an administrative warrant, meaning a warrant that is signed by another officer. If I, as your friend, sign a warrant, has no effect. I don't have to let you in. So keep that in mind. It's something minor, but it's huge, because if I am working and I don't know if maybe your visa was revoked because you had a DUI yesterday and maybe you are now here illegally, I don't know. And somebody shows up saying they want to uh, have a raid at my job, it's good for me to know, is this signed by a judge? I don't know this person. Maybe call an attorney, and I'm not going to let you in into my place of business because I don't know this warrant. And that way protect the person who maybe was accused of a crime and doesn't even know it, from detention. So let your boss know that, just in case. They should know. I don't know how comfortable you may feel with your boss having this conversation, but if you know it, and if you are the boss, you can also let them know, hey, no, my boss has instructed me not to let you in because this is not signed by a judge. So those are the two main things I've been telling all my employers: pay your employees by W-2, and check that all warrants are signed by judges before you let anyone into your premises.
Absolutely. Play safe, but also play smart. So, no everything well, do your research properly, and I'm sure that nothing is going to scare you when that happens. Knowledge is
True.
power, at least in this matter. So do that. And thank you so much, Isa, for spending this time with us, full of energy, and for patiently answering and taking up all of our questions from our viewers, not just on YouTube, but also from those who are watching on Twitter as well, and also from our Facebook groups. It was really lovely having you, and I wish this wouldn't end so soon, but yes, we'll have to at this point. Yes, so I'm really hoping already to see you again soon. Please tell me
Whenever
about
you
your
want.
yeah. Yeah, but before we go, do you have any end notes, anything more you want to add, and we can.
I know things are scary right now. Every day we wake up and we have different news and different memorandum and something different going on. But don't get overwhelmed. Just stay informed. I know that sometimes that might be overwhelming too, but it's good to stay informed and know that you guys are doing everything right. You're staying informed. You have your visas. You're applying correctly. As long as you keep doing everything right, you'll have the law on your side. And if I can help you in any way, I'm always here.
Thank you so much. And yes, you can contact Attorney Isa, and that you can do so by calling her on her number, and also by emailing her. You can call her on 305-938-0676, and you can email Attorney Isadora at isadora@isalawyers.com. Check out the spelling, it's there on the screen, and go visit www.isalawyers.com. Thank you, Isa, once again. It was lovely having you, and you have a great day ahead.
You too. Thank you guys.
Thank you. And folks, you can also email me or call me or WhatsApp me on my number. My number is 408-335-6444, and my email address is nipa@staffingly.com. And once again, do not forget to subscribe to our channel and also hit that bell icon so that whenever we have discussions like these, you are notified. And absolutely, it was so amazing having you, Isadora. I'm already looking forward to having you back again. So, yes, and friends, also follow us, not just on YouTube, but we are also there on LinkedIn, Facebook, X, and Instagram. So, check us out, follow us, and connect with us. So, bye, y'all. Have a wonderful day ahead and watch out our space. Stay tuned on Immigration Talk Show.
Hello, everyone, and welcome to Immigration Talk Show. I'm your host, Sam, and I'm so happy to back you all here again. As today, again, we are going to have a very exciting discussion with our very familiar face, none other than Attorney Uma Mantravadi. But before also inviting her to the session and diving into the topic, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, friends, once again, welcome back to Immigration Talk Show. I'm your host, Sam. And today the topic is again very timely and very, very important. That is about H1B Lottery 2026. What happens next? So, of course, the results are out and it's 3rd of April. So many news are there. And we definitely make sure that our viewers are updated with recent news updates that's happening in the world of immigration. And in case, friends, if you haven't subscribed to our channel yet, then make sure to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. We are live on YouTube, available on LinkedIn, Facebook, X, and on Instagram as well. So, without any further ado, let me welcome our today's very special guest and very honorable one, Attorney Uma Mantrawadi, who is a leading immigration attorney and an expert in US immigration policies. So, hi Uma, it's so good to be here again, and we are really honored to have a show with you again. Thanks for joining us.
Thank you, Sam. It's always my pleasure to be back with the Immigration Talk Show. Thank you very much.
All right, that's lovely. And I can see a bright shine is on your face, and you're looking as bright as the sun is shining. So that's really great. And Uma, before diving into the topic, any update that you would like our viewers to know about?
Sure, Sam. It's something that is pretty unusual and alarming news. This is about students. I'm pretty sure many of you have heard a lot of students are being picked up at different universities and being asked to self deport themselves if they have been a political activist or created any kind of anti Semitism against Israel or exhibited any support for Hamas or any other terrorist groups. They've been sent emails by the Department of State
Mhm.
asking them either to self deport themselves or there will be a deportation process against them. My understanding is at least 300 students from India have received such emails. They're checking their criminal backgrounds, they're checking their social media status. For example, even if they did not actually participate in any kind of rally or any kind of political party, they just put a like or a share on Facebook, Instagram, or any social platforms, then
Mhm.
the State Department is investigating them and actually sending them emails that they should self-deport themselves. A lot of people are thinking this is a spam or a scam. So, if you feel you've received an email as a student, they should check it out if they are one of those students who are really getting an email from the State Department asking them if they feel they've done something wrong in a similar fashion when I say that. And of course, a lot of students are questioning attorneys like us, stating, "What about our freedom of speech? Why can't we express ourselves?" Well, there is a First
Mhm.
Amendment, but when it comes to political issues or anything to do with Israel, I think things are very, very, very sensitive matters. And the government had last year asked the students not to get involved in these rallies. The Biden administration also clearly warned students to stay away from rallies, whether it is supporting any group, it doesn't matter. So, students, some of them heeded
Mhm.
to their request, some of them did not. So now they're facing this, and it is pretty alarming for the students because they've invested a lot of money, and now in the middle of the semester, they're having to leave.
Mhm.
So, my advice to whether it's a student, whether it's an H1, whether it's an L1, TN, doesn't matter what your visa category is. You're coming here for a purpose. Your purpose as a student is to study, not to get involved in the politics of any country, doesn't matter. So from now onwards, at least the students should be very wary of this. Stay away from politics, stay away from any kind of display of your likes or dislikes publicly. You know, if you have something, sit at your home and discuss, but I wouldn't publicly put anything out there. This is, it doesn't matter what visa category you are in. I would advise
Mhm.
this to someone. Focus on what you're coming here for. You're coming here on an H1 to work, focus on that. You're coming on an L1, improve your skills, whatever you need to do, but don't get involved in any political involvement. Stay away from that. Believe it or not, Columbia University uh, was taken away a grant of $500 million because Columbia University was highly involved in the rallies and they did not instruct their students to keep away. So
Mhm.
even Columbia lost that money. So you can see they're not sparing anyone. So, best advice is seal your lips, um, don't talk, don't get involved in politics because you're not a citizen of this country to get involved in all that. You cannot claim rights because you're not a citizen. So, best thing, my advice is stay away from everything that involves supporting a political group of any country.
Mhm.
This is
That's
something
right.
I just wanted to give as a generic advice.
That was really needed. Thank you so much, Uma, for bringing up this very important news also. And I'm sure there are so many people, there are so many students who are watching our session and who are like regularly following our webinars. So, friends, I think this news was for you. And in case if you have any question or would like to know more about the topic, then please go ahead and put your questions on the comment section. This is the time to be ask more and more questions from attorney and get in touch with attorney, as this will be the best advice. And also don't keep these information to yourself. Make sure that you like, share, and subscribe to our channel, because we come up with these amazing webinars with top immigration attorneys for you all friends, to make sure that you guys are informed and aware about the changes that's happening in the world of immigration. So make sure that your friends are informed too with yourself. All right, with that, Uma, I think now it's time to jump into our topic.
Yeah.
And with here, my first question to you is about the results. So, results are out, and how do you think? I mean, how was the result for the H1B visa lottery this year?
I think this year, the percentages for many of us as attorneys and employers was definitely a welcome surprise. There were more pickups in the lotteries. I think that's also because this year the USCIS was very, very focused and making sure there are no duplicates, there is no fraud,
Yeah.
and also the fee went up to $215. So that was kind of
Hmm.
discouraging a lot of people from filing duplicates. So we saw I had almost a 48 percentage pickup on my H1s that I filed for the lottery selection. So, talking to many of my colleagues who are attorneys, some of them saw 50 to 60%, some of them saw 36%. So, everybody was expressing happiness that they did see a better percentage on this year's lottery selections as compared to last year.
All right, that's a good news.
And
And also, Uma, yeah, and also, Uma, we got this news from like some of the news article that in fiscal year 2026, the lottery had a record low number of entries. So is it true? I mean, what do you think about it?
we haven't got the actual numbers yet from USCIS. Last year,
Hmm.
for the fiscal year 2025, there were 470,342 registrations. So the selection rate was rated at approximately 23%. 2024, there was 759,756, I would say, thousand registrations and a 16.6% of selection rate. So definitely, I think this year we may estimate the selection rate to be more at 30 or 35%, you know. So it's definitely a better
Hmm.
what we have seen. But because USCIS has implemented stricter rules to prevent duplicate or fraudulent registrations, so we've seen that the selection odds are going to be much higher.
All right. Okay. And also for the applicants, who got the selection in this year, what do you have to say for those? What should selected applicants do immediately after seeing their selection notice?
Well, congratulations to those all those who got selected. And this is your one, almost like saying a golden or a platinum chance that you've got. So both the employer and employee should make sure that they comply with the regulations, make sure they provide all the documentation, particularly the LCA, wage selections. Lot of times employers try to cut corners with going with the level one as opposed to level two or three. So that's something they have to be careful depending on the job title, and the job description, whether you should be selecting wage level one, two, three, or four. And also make sure that you have a bona fide job, whether it's going to be at a third party location or you're going to be working from your employer's location. Whatever the issue may be, make sure that you provide the accurate and proper documentation. Of course, consulting an attorney will always help, and make sure you follow through
Yeah.
with the law.
Wow, that's great. And guys, if you need more information regarding these very great, conversation that we are having right now, please make sure to like, share, and subscribe. And I'm pausing this session for a second so that you guys can hit the subscribe button. And also, it's a very hectic day. It's a very, you guys are busy with your daily routine. So make sure that you press the bell icon also so that whenever on every Thursday we have these shows with Attorney Uma Mantravadi, you guys directly get the notification and you can join this webinar. Okay, with that, I would also like to move ahead with my next question, Uma, that is about the RFE. So, how can an employer ensure a strong petition to avoid
Like I
RFEs?
just mentioned a minute ago, Sam, one has to comply with all the requirements that the USCIS is requesting, ensure if your employee is going to be working at a third party location, make sure that they give either the third party employer's letter, end client's letter, or an MSA, or a statement of work. Providing all of these documents will definitely ensure that you will not get an RFE. Description of the job duties in detail will help. Also, describing the employee's achievements, whether it's a certification or a degree
Hmm.
or courses, focus on all these points to make sure that the USCIS officer clearly understands that this is a specialty occupation and the employee is qualified to perform the specialty occupation duties.
All right. Okay, that's wonderfully explained. And friends, I hope you guys are, watching these sessions and understanding what we are discussing here. In case if you are having any questions or queries that you would like to know, then please post them in the comment section. And after the first half and the second session, we are definitely going to a second section of this webinar. We are going to have viewers' question, and there we will definitely take up your questions. So till then, please post as many questions as possible as this topic is very important and very timely. And also don't forget to like, share, and subscribe to our channel as we always come up with these amazing shows, amazing webinars, and these information are really important for each one of you to know. Okay, let me go with my next question, and that if we talk about the common mistakes. So, Uma, please let us know, like, what are the common mistakes that applicants make while filing their
Well,
H-1B petition?
applicants are basically the employers who are filing. And, the biggest mistake is selecting the right job that fits the employee's background, and also compliance with the
Hmm.
vendor or the third party. You have to make sure if the vendor is asking for a software developer in their letter and then you're hiring them as a database manager, that's a completely a conflict. So those are things you need to check,
Hmm.
make sure that you're complying with what you have, as far as the third party client is requesting. Because sometimes USCIS actually goes to the third party client's website to look up what is the job title they're putting up over there, what are the jobs that they are
Hmm.
looking for. And if they don't find that particular job,
Hmm.
then they definitely, definitely will have an RFE, saying, we don't see this. Did they put it externally or just was it an internal posting? What are their job requirements? Is there a
Hmm.
letter from them? So these are something one has to be wary about. And as I said, the salary, the wage level is something very, very that important that an employer has to comply with. I don't think it's a good idea to cut costs and try to uh,
Hmm.
employ a person on level one when you're calling this a specialty occupation and trying to hire them in a entry level position. But however, if it is truly an entry level position, it's fine. You can always put them on a level one. So you have to look at all the options whether you're doing the right things. So again, consulting an attorney to go through
That's
this
right.
process would be the right thing to do, because H1B is a complicated area of law, and a lot of people don't understand the intricate requirements. Even employers, even though they do this day in after day, the rules are changing, the policies
Hmm.
are changing, the enforcement is going to be more stricter this year as compared to what we saw in the last 4 years. So I wouldn't take a chance. You got a golden opportunity of getting picked up in the lottery. So
Hmm.
don't lose this by merely just filing something.
That's right. That's absolutely correct. And also, Uma, if we take a random case study that I have in my mind about the F1 student who was an OPT, and his name was Amit. So what happened with him that he was selected in the H1B lottery, but his work permit was expiring on July 15th, 2025, before his H1B start date on 1st of October. So, to stay employed, his company filed the H1B petition before his OPT ended. So, this made him eligible for a cap gap extension, right? And his university also gave him an updated I-20, allowing him to keep working until October 1. So, my question to you is that in these types of situation, what happens if an F1 student on OPT is selected, but their work authorization expires before
Good
October 1st?
question. And I don't know if you remember, we talked about this particular aspect when we talked about the H1B modernization rule that was brought in on Jan 17th, 2025. One of the good news that the
Hmm.
modernization rule stated was particularly in favor of students, stating that normally they get a cap gap until September 30th of that year. Now, in this case, it can be September, even though his OPT is expiring, let's say July 21st, just as a random date. So he gets, typically, he should have
Right.
gotten a
Hmm.
cap gap until September 30th, 2025, because H1B begins October 1st, 2025. But the H1B modernization rule
Hmm.
states that starting this year, students will get until the April of next year, which is until April 2026, uh, uh, you know, a cap gap so that they are not placed out of status. You may say, why until April 2026? That's because, Sam, sometimes students can get an
Hmm.
RFE, and if they're not filing it as a premium processing, the process can take sometimes beyond October, beyond November, beyond December. So typically in 2024, for the fiscal year 2025, a lot of students had to go back to student visa status if their OPT was expiring, or
Hmm.
their STEM OPT was expiring, or their F1 was expiring. They had to go back to school to get an admission and keep their status intact. But now the government is saying you don't have to do that. We're going to give you until the following year, April of, to give an example, for now, it's going to be until April of 2026. So, among all these things, at least that is the good news for the students, that they don't have to worry about it. They're getting this prolonged period of stay automatically.
Yeah, that's great. That's great. Okay, and also, Uma, if we talk about the one, those who got
Mhm.
rejection this year. So, is it that that's being rejected this year may impact applicants' chance for the next year's lottery? Is it going
No,
to happen that
that's
way?
not true. We've had somebody we filed last year and they didn't get picked up, and this year they got picked up. So, I mean, the lottery is a lottery, it's
Okay,
just your odds against getting selected. So we just keep fingers crossed
right.
and, hope for the best for next year for those who were not selected this year. And we'll talk about what are your options if you're not selected. You know, sometimes you can go work for a cap exempt
That's
company
right.
or an educational
Hmm.
institution, or it could be like a university, nonprofit, research institutions. These are all exempt from the lottery.
Hmm.
So I know a lot of teachers
Yeah.
who were filing for H1s under the cap, and now that they are not getting picked up, I
Hmm.
am actually filing for the teachers in several states and several school districts where they're going for the cap exempt H1B.
That's really great.
So that is an
Okay.
option. And if somebody's got extraordinary abilities, they have a very
Yeah.
strong portfolio and have exceptional skills in their field, they can also apply for an O1 visa. The
Hmm.
other option is if they don't want to wait, and they don't qualify for cap exempt and O1, I also suggest that they can go to work for a multinational company for 1 year outside the
Hmm.
US and come back on an L1A. And of course, they can get a green card faster under EB1C.
That's right.
And for
I was,
students, if
yeah.
they are qualified for a STEM, they can apply for the STEM. Some universities also offer CPT. So if they are eligible for a CPT, they can apply for that. So everybody's case
It's
situation is
different.
going to be different, Sam. So we'll have to see who qualifies for what.
That's right. And I was about to ask for the visa categories, for the visa alternatives, and that you already mentioned. So I think that's great.
I
And thank you. Yeah. Thank you so much, Uma, for putting up these great pointers in a very simple way, in a very detailed way. I'm sure our viewers are getting to know and understanding more and more. I can see lot of viewers have joined us. Sanjay is here, Nayan is here. Hi, Sanjay, and hi, Nayan. I will definitely take up these questions, but in the second part of this webinar after the break. So, in case, if you want to know more about the topic or any question that you have in your mind till that time that we have discussed right now, please go ahead and put them in the comment section. Until then, friends, don't go anywhere. We will be just right back after a short break. And also, don't forget to like, share, and subscribe to our channel as we are working hard to bring these great shows just for you so that our friends are informed and aware about the immigration news that's happening in the world. So please go ahead and don't miss any update regarding our session, our channel. And if you haven't subscribed yet, then please do it right now. Okay, so friends, thank you so much for being here, and we'll be right back, so don't go anywhere. Hello, everyone, and once again, welcome back to Immigration Talk Show. I'm your host, Sam, and today we are having a great discussion with none other than Attorney Uma Mantravadi on the topic H1B Lottery 2026. What happens next? So till now, we have covered a lot of questions, a lot of doubts that most of our people have in their own mind. But now, I think in the second part of this session, I will directly jump into our viewers' comments and the questions that we got from our viewers. So I think let me quickly take up some of our viewers' questions. Okay, so I think Nayan is here, and Nayan is asking a question about like if my H1B petition. Okay, let me take Sanjay one. So Sanjay is asking if my H1B petition is selected in the fiscal year 2026 lottery, but subsequently denied due to issues with the LCA or other technicalities, then what are my options for appealing or refiling, and how can I overcome the risk of visa denial or possible deportation?
I wouldn't know why it's being denied. Only when it is denied, you will know once you get a decision letter whether you have a chance to appeal or file a motion to reopen. So that's something you'll have to talk to your employer and the employer's attorney to make
Hmm.
sure that you don't get a denial. You know, I cannot
Right.
predict what can be the reasons for the denial.
Okay. All right. All right, Sanjay, thank you so much for being here and asking up this question. In case if you have any follow-up question or would you like to know more about the topic, then please post your follow-up question and we will definitely take them up. Meanwhile, I would also like to take up Nayan's comment, and Nayan is asking, Hello, Uma and Sam. Thanks for these great shows, really helpful. I'm having two questions. Yes, Nayan, for sure. Firstly, could you elaborate on how the importance of specialty occupation criteria and how it affects the H1B approvals? Yes, Uma.
Absolutely very, very important because the entire H1B visa is the premise is based on a specialty occupation. So one
Mhm,
has to define the job duties that it is a specialty occupation and that the employee qualifies for this specialty occupation. So in order to, hope for an approval, you need to
mhm.
make sure that your employer is defining this absolutely clearly. You get a lot of RFEs only based on specialty occupation.
All right. Okay. And I think let me go with Fawad's question next. So Fawad is also here and he's asking like what recourse is available to selected applicants if their H1B petition is denied due to USCIS scrutiny.
I wouldn't know the options or recourse unless I know why it's denied. Again, it's the
Okay.
same answer. Each
Hmm.
denial will be different, and we won't know until we get the notice or the decision from the USCIS why they are denied. They will specify exactly why they denied. So you get one chance at the RFE, and that's why it's very important to respond to the RFE properly. And if you've done it, there shouldn't be a denial. But if
Hmm.
the attorney or the employer is unable to, attempt to answer the RFE properly, then they're going to have a denial.
All right. Hopefully, Fawad, you got your answer. And in case if you have any follow-up, then please post them on the comment section and we will try to provide you the best answer. Till then,
Let
I
me
have just
continue with an answer with for that.
sure.
Sorry to stop you, Sam.
No, that's okay.
It's very difficult to predict what the decision could be, why the denials come. And this is
Hmm.
similar to asking a stockbroker, is Microsoft, stock going to go up or come down? It's very difficult to
That's right.
predict that. So similarly, as attorneys, when we prepare a package, we pretty much do it in compliance with the rules, the policies that are currently in place. But
Hmm.
each individual officer is going to adjudicate it in their own way. There may
Yeah.
be more, there may be more intense scrutiny with one officer as opposed to another officer. So that's why you see that difference. Some are getting approved, some are
Hmm.
getting RFEs, so we don't know what scrutiny level they are going with. But we can
That's
only
right.
say, hey, follow the rules, follow the policy that is currently in place, and provide them the documents. So once we get a denial, we know why
Hmm.
it's denied,
Yeah.
and then we file a motion to reopen because most of the times you cannot appeal it.
Hmm. That's right. That's absolutely correct. And I think, Fawad, this was the answer from our attorney side. Hopefully, you got your answer. And once again, thank you so much for putting up this question and participating in this webinar. Also, I can see some of our viewers have just, subscribed to our channel and don't be the one, friends, who misses out. It takes less time than sipping up a hot coffee. So subscribe it now, do it right now. And this, of course, we will definitely provide more and more information and will be grateful if you could subscribe to our channel. Okay, let me take up Cynthia's comment here. Cynthia is here and she's asking if I'm a beneficiary of an H1B petition filed by a US employer, but I'm currently outside the US and my home country has a US visa ban or travel restrictions in place, then what are the possibilities of obtaining an H1B visa through a third country embassy or consulate? Okay, let's answer
What
this one
country?
first.
What country is she from?
Okay, let me read the whole comment. And what are the potential risks and consequences of attempting to do so? I think she haven't mentioned that. Cynthia, if you could please let us
Okay.
know from where you are speaking us, then we can help this out. Yeah.
First of all, let me say the travel ban has not yet been, executed. The president has not yet signed the travel ban, and they
Hmm.
haven't given a timeline when the travel ban or the travel restriction would be placed. As of right now, they have not yet placed the travel ban. And the travel ban will fall under the executive order, which is titled as Protecting the United States from Foreign Terrorists and Others. So that's what it will be titled under. So we don't know when it'll happen, but they haven't yet put it in place. So we don't know
Hmm.
when that's going to happen. So if she doesn't have a consulate in her country, she has to look for a third country where they allow them. So typically, she'll have to reach out to the neighboring countries where they can actually go get a visa.
Yeah, that's right. Okay, so Cynthia, I hope that you got your answer. And in case if you have any follow-up question, then please post them in the comment section and we will take that up. Ganesh is here, and Ganesh is asking if an H1B petition is denied due to a perceived mismatch between education and job duties, then what are the chances of successful AAO appeal? And the second part of the question is what additional evidence can be presented to demonstrate the qualifications?
When first of all, I wouldn't know why you got denied. So again, without knowing the decision, it's difficult for me to say that. So the
Yeah.
employer has to make sure there's no mismatch when they're filing for the H1. So when you file an appeal, you cannot provide any new evidence that you couldn't have given at the time of filing. Only if that evidence was unavailable to you, you can bring that up. But you cannot say, I didn't give the transcripts then, so now I'll give it to you and go ahead
Mhm.
and approve this. That's not going to
Yeah,
work.
that's
So
right.
we'll have to again read the decision, why the denial was given, and then based on that, typically we try to file a motion to reopen.
Mhm. All right. And now I think till Ganesh, we have covered all our viewers' questions and comments. And now, Uma, with your permission, I would like to go ahead with the Facebook questions also, because
Sure,
there also are viewers who are sharing the questions. Okay, that's great. So,
sure.
Control, if you could please share the Facebook questions so that we can take those up. Okay, so this is the comment that we got from anonymous participant. I am selected in lottery. What are the next steps? Currently, I'm on student visa and based in UK, but I'm a Pakistani national. What do you have to say, Uma?
Well, it all depends on your employer. Congratulations, you got picked up in the lottery. So you'll
Mhm.
have to reach out to the employer and they will tell you what are the next steps, whether they're going to go forward, file the H1, not file it. Then they are the ones to reach out to you to ask for the proper documentation in order
Yeah.
to move forward with the H1B filing. So reach out to your employer or your employer's attorney.
Okay, so let's move ahead with our next question, and that is about a student visa second attempt. I got rejected in 2024, and now my uncle wants to sponsor me financially. He has a good position in USA. I'm showing his bank accounts and statements. So, what is my chance?
What is his chance for H1B? H1B is already
Yeah.
done. So if you're looking at H1, you've
Mhm.
already, passed the deadline. So you'll have to wait till next
I think
year.
he's asking for the F1 student
F1,
visa.
yeah, but he's saying his uncle wants to sponsor.
I think this
So it's
is
kind of confusing.
quite, yeah, this is quite confusing, but I think, okay, let's skip this question and
You know,
it will be easier if we get more information regarding it. but not to worry. Let's take this next one. So, next is hello guys, I have few questions to ask. My H1B is getting expired in October 2027, and my passport is getting expired in July 2027. On being asked, my lawyer suggested not to travel now. First, renew your passport and then go. My questions are, I'll be able to renew my passport after July 2026. Then what's the probability of getting visa dates? And will you suggest me to get the stamp first and then renew passport here in USA? If I get stamp on my current passport, my I-94 will get shot to passport expiry date, and then again I need to travel back to India to get it match with visa expiry date.
There is no stamping at the moment right now in the US. They launched it as a pilot program, but they haven't announced any stamping for this year. We haven't seen anything. So if you have to
Mhm.
get a stamping, you'll have to travel outside the United States to get it, whether it's going to be India or a third country like Mexico. So that's something you'll have to see. And yes, they will limit the date on the visa based on your expiration of the passport. If your passport is expiring in July, they'll give it only up to July. So the better option would be to get your passport renewed and then go for
Mhm.
the stamping so that you have it all in one place.
All right.
And
Okay.
what will be the rules in 2027 or
Mhm.
26? We don't know. We discussed about the Dropbox options, which was 48 months. It's now brought back to 12 months.
12
So
months.
if you are in that visa category in the last 12 months, you're eligible for the Dropbox based on the current rule. Now, that can also change. We don't know that.
All right. Okay. Let's move ahead with the next comment. And this is we got from anonymous participant. Hello all, I completed my DS 160 form on November 23, 2024, and I scheduled my visa interview appointment in May 2025. So I want to postpone my trip due to personal reasons and would like to reschedule the visa interview. So my question is, can I postpone until November 2025 or May 2026? Thanks in advance.
He'll have to reach out to the consulate to ask that question, or to the third party that assists the U.S. consulate. He can email them, and if they allow that, that's something they're going to tell him. Or if they tell him you have to refile your application, the DS 160, and pay the fees again, if they're not going to postpone it that far out, they may ask him to
Mhm.
do that.
Okay. All right. Here's a next comment, and this we already have taken. Okay, so I think these were the comments that we got from Facebook. And Uma, I think we have covered questions from our viewers and we have covered some questions from our Facebook groups as well. But here I have some questions, and I think let's continue with those.
Sure,
Like if
sure.
we talk about the special cases and compliance. So here's another case study, and that's about like there was a IT professional who got selected in the H1B lottery and whose name was Raj. And he also received the approval. The great thing was that he received the approval. But however, before his start date, his employer withdrew the petition. And of course, this left him in a very uncertain situation about his options also. And since he had not started working, his new employer had to file a fresh petition rather than a direct transfer. So, in these types of situation, what happens if an employer withdraws the petition after selection? And can the applicant transfer to another sponsor? Is that possible?
No, it's not. They have to work for that employer who filed a petition, especially if it's a cap case. They had to have worked for the employer through whom the registration was selected, you know,
Mhm.
and until they work for that employer, they cannot transfer it to another employer.
Okay, that's a bit sad. But Uma, does this happen that that
Many a
employer
times,
suddenly withdrew?
many a times, or they don't want to file it. Many employers say we're not going to file your H1. You got picked, but we are not filing because we don't have a project. Market is bad, especially as you know right now. The
Hmm.
job market is very, very bad.
That's sad.
The
So
stock
this
market
time,
had a crash
mhm,
of some thousand
it
plus
did.
points. I think
Hmm.
yesterday that's what I saw. So could that have an impact on the job market? Surely. And if that has an impact on the job market, 1400 points, thank you. And, if that would have a lasting impact on the job market, surely it will. And if that happens, then, we're not going to see many projects. And that could again have an impact on a lot of H1B employees and the employers to get
Hmm.
projects.
That's right. That's sad. But is there any other way that the employees or the applicants who have been selected, I mean, they can do anything or they have not no option when their visa get renewed? I mean, the petition get renewed.
Unfortunately, not other than the options that I talked about earlier, if they qualify for an O1,
Hmm.
or if not, leave the country, work for a multinational company and come back on an L1, or go back to student, or if you qualify for STEM OPT, apply for that. Those are the only options. And if you're a Canadian citizen, you have TN
Yeah.
option.
Hmm.
So
Okay,
those are the things.
that's right. Okay, and with that, Uma, I would just like to ask one more question from you, one last question. That is there
Sure.
any case study about, of course, you are attorney, you have so many people who are coming to you for those problems. So, any case study that you would like to share with us, one of your clients who got successfully selected in the H1B lottery. So please let us know what strategies, they did, I mean, they used to improve their chances and also what lessons can others learn from their experiences.
Well, last year, a lot of people were applying not from the same employer, but for example, if the employer is Microsoft, then they also applied through IBM, who are not connected in any way. So they improved their chances of filing. But this year,
Hmm.
we did not see too many people doing that. One, because the fee went up, and
Yeah.
two, a lot of employers were discouraged in filing for H1s because of the
Hmm.
job market.
Yeah,
They didn't have projects, so many people did not.
that's
So
right.
unfortunately, a lot of people got left out because of that. And also, I
Hmm.
wanted to say for those who did not get selected, in case a lot of employers don't file the H1s, which we've seen last year as well, we had a second round of the lottery in July, and we are expecting something similar to that to happen in July.
Hmm. That's right.
This is all again because of the job market.
That's right. Okay, so I think, Uma, now we are almost done, and all the information, all the questions that we have prepared and we have covered. I think it's almost done. And any last message or any last tip or strategy that you would like to share with our viewers before wrapping up the session?
I would like to, but I'm just seeing some news that just popped up on my screen that the Trump administration is making some changes for people who file green cards based on marriages. I haven't got the full information. This just
Hmm.
happened an hour ago. So I
Okay.
don't have all the information on that, but there are
Hmm.
some changes that are coming about by the Trump administration due to the changes they made for green card based on marriage. So we'll have to see what those changes are. So there's going to be changes every day, Sam, from this administration. I can expect
Yeah.
something or the other to be coming about, some changes, some good, some not so good. Uh, so we have to watch out. And we'll keep doing these seminars, webinars for people so
Yeah.
that they can come and find out all that information here on Immigration Talk Show. So, this is the platform I would advise people to, like you rightly said, subscribe so that you know that the next session is coming and what is the topic we'll be discussing about. So, being alert, keeping your eyes open, finding out what are the changes is the most
Mhm.
important thing under this administration right now.
That's right.
And I'm not sure, but I've heard about a news in Houston yesterday, but I can't
Please go
verify
ahead.
this for a fact.
Hmm.
But I've heard that ICE went to a Walmart and shut down the Walmart. They didn't allow anyone to leave the Walmart, and they were checking on immigrants' paperwork, like
Hmm.
if they had a work permit or what is their status. This is what I was told by another attorney that it was happening in Houston yesterday. So I don't know how many people are going to carry their document. So it's a good advice that you need to carry copies of your documents on your phone or at least a
Yeah.
copy of your I-797 approval. If you're on an
Hmm.
H1, I would keep it in your wallet, your purse, so that if you encounter anything similar like this, at least you can show them the document and, you know, be
Hmm.
protected. But if they have any questions, I would ask people to call me directly or email me
Yeah.
and get all their questions answered because I can't particularly talk about individual cases here,
Hmm.
but I'll be glad to talk to people if they have any questions.
Of course, of course. And for that, Uma, you don't have to worry. We're definitely going to share the contact details of yours with our viewers. And friends, these insights, these efforts are all for you. And the only way to keep it coming is if you subscribe to our channel. Right now, don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And also to help you, by I mean, you can share your personal case or any case that you want to get in touch with the attorney. Then here's the contact details. You can directly give a call to Uma on the number 713-787-5297 with the email ID uma@mantralaw.com, and the website is www.mantralaw.com. So this is the contact details, and please get in touch with the immigration attorney. This is really high time, and this will be really beneficial for all of you because, of course, it's not possible to have a chit chat of each one of your case in this platform. So it will be more comfortable for you also to go ahead and directly, share your cases in the email ID, or you can directly give her a call, and she will definitely be there to help you guys, to provide the best solution. So, all right, Uma, and with that, it's almost the end of our session. So, thank you so much for being here. It was really great and wonderful experience to have a show with you again. And really looking forward to next Thursday and waiting for the next show. So, thank you so much for being here.
Thank you. And I'm off to Oklahoma for this weekend.
Oh,
As I've told you, Sam, that I sing. I'm a professional singer. So I'm
that's
going to
right.
be performing in Oklahoma. So I'm off for a concert this weekend.
Oh God, that's lovely, and all the very best, Uma, from our end. Please share your, video link or your audio link to our viewers. We will definitely have that great, I would say, episode with our viewers. Also, they should also know how good you are in singing.
We'll do that. I possibly would be singing with Mika Singh and
Oh,
Shafqat
wow.
Amanat Ali, one of the legendary singers from Pakistan.
That's right. That's right. How, of course, we all know them, and that too, you are here, Uma. I think that's really great and best wishes from our end. Please share the link with us, and we will definitely share that with our viewers.
Absolutely.
And it will
Absolutely.
be really interesting to watch that. Okay,
Thank you so much. Have a good one.
same here. Thank you, Uma. Thank you so much.
Thank
All
you.
right, friends. So, with that, it was the end of our session. And of course, we have taken a lot of comments, a lot of questions from our viewers. In case, if you want to know more about the topic and of course the live stream ends, then also you can put up the questions on the comments and we will definitely try to provide you the answer even after the stream ends. And with that, it's almost the end. So take care, everyone. And it's really good to have you all here. Stay connected and keep watching Immigration Talk Show. It's me, Sam, and I'm signing off for now. So goodbye, everyone, and take care.
Hello, everyone, and welcome back to Immigration Talk Show. Thank you so much for joining us. I'm Nipasa, and I'm going to be your host for this session that's lined up. And let me tell you that it's going to be a very insightful and an interesting one because we got a lot of new updates that you wouldn't want to miss out. And of course, we're going to continue discussing about the topic of discussion since it's going to be the second episode. And I will tell you who our guest is going to be. But before that, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, I hope that you keep that in mind. And thank you once again for joining us. Today's discussion is going to be on this topic that you can see facing H1B hurdles. Could 221G, RFEs, or port of entry issues lead to deportation? And this is going to be our second episode on this topic with none other than our guest of today, Attorney Chand Pravathaneni from SPB Law Firm, Dallas, Texas. So, Chand, thank you so much for joining us today as well. And I'm really happy to have you here.
Thank you, Nipasa, and hopefully we'll have a very insightful session today. And a lot of new things are happening. We are seeing a lot of new changes coming out in the last few days.
Right.
Hopefully we'll have a very productive session today.
Yes, and I think we should get to know, what is happening and what are the new things that you should be. I know every day we're waking up to new updates and new, policy changes, but I think the latest ones are something that we really need to keep in mind. So, Chand, maybe you could tell us about the major updates, that folks out there should not miss out on.
Sure. So, in terms of the major news, what is happening is in the last 2 days, especially starting from April 1st, we are seeing the consulates send a couple of emails to people. I mean, again, people who have had any kind of minor infractions with law, maybe they had a traffic, maybe they had a DUI ticket, maybe they have some kind of a shoplifting on their record, some kind of a criminal offense infraction on their record. So if people have had any of these issues in the last couple of years, what we are seeing is all of a sudden various Indian consulates. We have seen emails from Chennai consulate, Mumbai consulate, Delhi consulate, and the people, especially the F1 visa holders, they're getting these emails, and these people are in US, and the emails are saying that their visa has been revoked and they have to either self-deport, if not, they'll be deported. And this is a recent thing that is happening. And the source for all of this is so last month, the Secretary of State Marco Rubio, so he announced that there'll be very, very strong vetting. They'll be looking at social media. And there was a cable sent out to the consulates. And the cable, basically, what it says is it says that even if somebody's visa has been issued, or even if somebody's visa is about to be issued, there needs to be more vetting of social media. And they're going to scrutinize whether somebody has some political activism or somebody supporting a cause that is against United States, that is against the the traditions and the culture of United States. And what they're doing is because of this vetting, if they find somebody's real intention is not to just come here and be a student, but their intention is maybe to be a political activist or something else, their visas are being reconsidered. A lot of visas are being cancelled. And the major issue that we are seeing is if somebody had even a minor infraction, not a major criminal offense, but it's still a criminal offense. So those are the kind of people I think are being targeted. Their visas are getting revoked. So I think so. The message for everybody is be very, very cautious. Always comply with the law. Even a small criminal infraction, you might think it's a very small infraction, but it is still an infraction. It's still a criminal offense. So these things could jeopardize your career. And so this is something that is very, very recent. And previously, what used to happen is we used to see prudential revocation of visas. So we used to get emails even in the past for offenses, but it used to be prudential revocation of visas. The tone has changed, and we are seeing more and more people getting these kind of emails. And apart from that, another major update that we are seeing is to do with the green card process. Some kind of green cards. So USCIS has been told to stop the processing of certain green cards, and the cases that we are seeing impacted right now are asylum cases. So anybody that has been granted asylum, we've been asked. I mean, USCIS has been asked to put those cases on hold. So anybody that is going through the asylum process, even if they have an approval for asylum, their green cards are going to be delayed based on the new rule. And we don't know if it will be expanded to other green card categories in the future. But as of today, the asylum categories is getting impacted. And the last update that we have is the gender. So this week we had a notification from USCIS. Again, this rule was actually implemented last month, but they came up with a formal announcement this month. And this is in conjunction with President Trump's executive order in January. And what it says is there can only be two genders, either a male or a female. And people have to select either a male or a female because immigration documents require the gender, and only two genders are accepted. So somebody cannot say other and not disclose their gender. Gender is important, and as per the latest USCIS memo, only two genders are acceptable under law, and that is either a male or a female. And people have to select their gender. If people forget or decline to put their gender, their cases will be delayed. The adjudication of such cases where gender is not disclosed will be delayed. So the bottom line is people are assigned gender at birth as per the current regulations, and that gender has to be disclosed as a part of immigration filings. So overall, I think this is what I think we have been seeing in the last couple of days in terms of updates.
Thank you so much, Chand. I mean, yes, these are very important updates and we cannot miss out on. And I hope, friends out there, you are enjoying this discussion already. Not just, I mean, let me tell you, the discussion hasn't as yet started. These are just updates. And I would just like to remind you that if you haven't as yet, subscribe to our channel, subscribe and also hit that bell icon because you don't want to miss out on these latest updates. And our handle is at Immigration Talk Show. Go check out our channel. There's so much content you don't want to miss. But for now, stick with us because we have Attorney Chand Parvatineni from SPB Law Firm who's going to be here very happily to discuss about, yes, our topic of discussion. So, yes, I'd also like to say hi to Rag. Thank you so much for joining us on YouTube. He's saying hello, Nipa and Chand. So, hi, Rag. Always really nice to have you. I know he's a very frequent viewer. So, Rag, thank you and stay with us. And also, I see Saju. Any chance to second lottery? So, Chand, anything before we start off?
Sure. So again, in terms of the percentage of selections, it was a lot better than last year. That being said, the percentage of selections is still under 50%. So we thought that we will probably reach at least 50% this year. It is probably a lot more than last year, but again, we are at our law firm, we are looking at around 40% selection rate. So that means that still even this year the demand has still been pretty high. And but again, in terms of a second lottery, this is what's going to happen. Everybody that has been selected right now, their companies have until June 30th to file the H1s. And normally what happens is most of the companies file, but again, there are a lot of filings that are not done for various reasons. A lot would depend on how the economy behaves for the next 3 months. If the economy turns bad, a lot of companies will drop off. If the economy is strong, companies will want to file for these guys because there is demand and there is a requirement for these employees. So if the market goes bad, definitely we will not see all the filings. That being said, the rules have changed from last year. Compared to last year versus this year, evidence of bona fide job offer, that is mandatory as a part of the filing. And what that means is previously contracts, client letters, vendor letters, these were not mandatory. This year they have to be included as a part of the filing. And what that means is some companies might realize that their purchase orders are not getting extended, or they don't have contracts to support employment from October 1st. And these reasons could cause a lot of people to drop out. So because of these reasons, I think there is a potential for a second lottery, looking at how things are going on and looking at the new rule changes that have happened for H1. So at least some companies might realize that rules are not same as last year in terms of filings. There is a lot more additional burden in terms of filing. We think that people might drop off for that reason. The other reason is the economy, and economy is something that we cannot predict. Maybe things will be very good in terms of economy in the next 3 months, people will file. But if economy is bad, because today if you look at the stock market crashed like anything today. We don't know if it is going to be a long term thing, whether the market will pick up or not. But if the market is weak, I definitely see more chances for a second lottery. And by end of June, because I think reasonably, I think we will know how many cases are getting filed, at least uh, based on what we do in our law firm, because we know what kind of selections we have, and then how many people are dropping off and so on. So end of June, I think reasonably, I think we will have a better idea. That being said, from the USCIS perspective, normally by end of July, they normally take about a month to process all the intake. And then probably by end of July, normally USCIS will make an announcement, either this way or the other way. And my guess is we more than likely will have a second lottery.
Interesting. Thank you so much, Chand, for that update. I'm sure many people are being very hopeful. And, when we had the news that all the results are out for the lottery, all the trickling is done. So many of them were commenting on our channel also, asking if that's it, if anything else is going to happen. But you never know, friends, because right now is what we can expect is more RFEs, right? I mean, we will see that everybody is being able to submit all their documents and everything correctly, but even then, there are chances of a lot of vetting, sorry, a lot of RFEs and a lot of obstacles to come in. So they will be throwing at us, and yes, we will be seeing like who will be able to prove that they have all the evidence that USCIS requires. So we'll see to that, and only after that we'll get to know, right, Chand?
Right. And the thing is, at least at this point of time, we are not really seeing any bad RFEs for H1. And the administration, I think they're supporting the H1B program. And yesterday, President Trump,
Mhm.
he announced tariffs because eventually the hope is eventually the tariffs will help the country. So that is the goal. So even though it is painful at this point of time, tariffs were announced. And unfortunately, today, if you look at the stock market, stock market is reacting a little bit differently. The stocks crashed. It's a historical drop today. So we
Mhm.
don't know how things will be. But again, yesterday when President Trump was announcing the tariffs, he was again talking about how he supports legal migration, how he understands that the country requires specialized workers in general, foreign workers in general. He just wants people to use the legal ways, legal migration. And what that means from a H1B perspective is H1B program. It is one of the legal ways for people to come and contribute to the US economy. So for those reasons, it looks like the administration at this point of time, they are in favor of H1B program, and looking at what kind of adjudications are happening in the last 2 months since President Trump has taken office. We do see that the H1B program is not impacted at this point of time. At this point of time, we're not really seeing any bad RFEs, and cases are getting approved. And at least as long as the companies are complying with the LCA requirements, companies have a job offer. We are not really seeing any drastic change in the way RFEs are issued. That being said, we don't know, because a lot will depend on how the markets behave, what kind of a requirement the country has for foreign workers, and all these things will play a part.
Right, Chand, right. And Saju, thank you so much once again for joining us with your question. But, we are really working hard to bring this to all you folks out there, not just Saju. So I really hope that you can see this, because week after week, question after question, I mean, you're getting your answers. And I really, really hope that you are subscribing to us. So if you haven't as yet, hit that subscribe button. And yes, I saw many just did. So thank you so much also. But you don't be the one who misses out. All right. So hit that subscribe button and also the bell icon so that you will be notified, and let me tell you, it really takes just a few seconds or maybe just 1 second to do that. And thank you. So, Chand, I'm really, really excited about today's session. I know it's a continuation of what we discussed the previous week, last week. And yeah, the discussion is on facing H1B hurdles. So, what do you think is going to happen? I mean, a week has passed on, and the results are already out. So, these few days, what do you have to say with all the changes? Do you see what we were discussing last week that is coming true?
So, in terms of USCIS adjudications, I don't think we are going to see like any major problems in the next 1 2 months. That being said, we are occasionally hearing issues at the port of entry, and at the port of entry, what's happening is I think there is definitely additional vetting, and if people are not able to explain why they're coming into United States, what kind of company they're going to work for, what kind of a project assignment they have. If the CBP officer feels that they're going to get benched and this company is not a genuine company and there is no project, those are the extreme kind of cases that we are actually seeing issues. And again, the number of people that we are hearing are getting sent back at the port of entry, it is extremely minuscule. The number is very small. That being said, once in a while we are seeing issues. And the common pattern that we are seeing is, if somebody has got an H1B approval a long time back and they have not entered the country and they're entering the country for the first time, and they're not really able to convince the officer that they really have a genuine project, or if the officer suspects there's something going on, those are the kind of cases that I typically see get pulled over for secondary inspection. And then there is more digging. And in secondary inspection, most common thing that normally happens is the phones, the electronic devices, they are taken and they are scrutinized. And if something incriminating is found on their cell phones or their mobile devices, or the information on the cell phone device contradicts with what the employee is telling the officer, and the officer proves that the employee is misrepresenting something, those are the extreme kind of cases that we are seeing issues and people getting deported back. But again, in terms of the H1B folks or the F1 folks getting sent back, the numbers are still very small. The only thing we tell everybody is just be prepared to answer. And the main thing is, if one is coming to United States, they're required to follow the rules of uh, their visa status. If somebody is on H1, they're only supposed to work for that employer, only in that occupation, in that metro area, for example. So they have to convince the officer, and their intent should be to work for that company. The cases that, for example, I've seen an issue is that their phones got taken, and the officer found that the intention of that employee was to come and immediately convert and change employment to another employer. So they're already discussing with another employer. So the officer suspects that your intention is not to work for this company, and you're making a misrepresentation. So unless misrepresentations are found, I don't think people will have issues at the port of entry. And that being said, everybody's intention should be to follow the rules. Secondary inspections are possible, and if secondary inspections happen, the officers will definitely scrutinize their admission request, and based on that, they will take a decision. That's one thing we are seeing. And the other thing that we always tell people is always make sure that you're working for a legitimate company. And what that means is always get referrals. Always talk to multiple people that you already know are working for that company. Don't work for a company that nobody has heard of, or nobody you don't even have any references that know about that company. So at least do your groundwork, and as long as companies are legitimate, companies are actually paying their employees on time, most of the time the companies will not have an issue. It does not matter the company is small. The company can be a very small company, only have one or two employees. But if that company is following the rules, paying the employees on time, following the rules of the H1B program, whether it's a small company or a big company, I don't think that will make any difference. It is if the company is not complying with the rules and regulations, even if it's a big company, we are seeing issues. So always get referrals, make sure you're working for a bona fide and a genuine company.
All right. Thank you so much, Chand, for that, latest update on these hurdles that are coming up for H1B. And well, I see a lot of folks joining us. Bhargav, Papa Ki Pari, very interesting. Rag has a question for us. Saju, thank you. She says, she or he, I'm so sorry. Thank you, Saju, also for joining us. Fawad, Shashi Kumar. So stay with us, folks out there. We are going to take up each of your comments. That said, Chand, I do have my first question. And if you could tell us, if an H1B applicant receives an RFE, what are the key factors that determine approval or denial, and how much time this person can have, this applicant can have to respond to this RFE?
Sure. So RFE means a request for evidence, and all it means is it's a simple notice from United USCIS, and they just want some additional information. So RFE does not by itself mean that the case is getting denied, and majority of the cases, I mean, in high 90%, the cases get approved even after an RFE. So RFE does not mean something is really wrong. All it means is the officer is doing his job, which means they're looking through the petition and they just want some additional information before they can make a final decision. And sometimes even if everything is good, the company is a very big company, even companies like big companies like Amazon, Google, even those companies can get an RFE. So getting an RFE does not mean anything. It just means that we need to look through the RFE, look through the notice, see what exactly the officer wants, provide that documentation. That is all it means. And in terms of the timelines, normally what happens is the majority of the H1B RFEs have 87 days. That is close to 3 months. So 3 months is the time that people have, the companies have, to provide the documents back to USCIS. So again, sometimes you need to take a lot of time because sometimes they ask for a lot of documentation, and you want to make sure you provide thorough documentation back to USCIS. So what that means is take your time and provide exhaustive list of documents back to USCIS. Very rarely what happens is they issue the RFE as a notice of intent to either deny or revoke, for example. If it comes as a notice of intent to deny, in those cases, people have only 30 days to respond back. So majority of the time it is 87 days. Very rarely it is 30 days. And that is the first thing that people have to keep in mind. The deadline is super important. If you cross the deadline, USCIS will deny the case for abandonment. So the timeline is very important. The timeline is on the notice. So the notice will clearly say what is the deadline. So the first and the foremost thing is comply with the deadline. The deadline is super important. You cannot not meet the deadline. And then what they're also looking for is compliance. So whether it's an H1B RFE or an F1 change of status RFE or some other kind of an application, they want to make sure one is complying with the requirements of that particular visa status. So for H1B, what USCIS wants to know is they want to assess and make sure that the applicant qualifies and the sponsoring employer has met all the requirements. So what they want to make sure is they want to make sure the job qualifies as a specialty occupation. So in the face of the petition, if they feel that the job is a specialty occupation RFE, they will not even ask in the RFE. Some cases, what happens is USCIS is not really satisfied that that particular position is a specialty occupation RFE. So they might issue an RFE and say, hey, now you prove that it is a specialty occupation RFE. So if the RFE requires that, provide that information. And most commonly for H1B, the RFEs talk about the educational and experience qualifications of the beneficiary. So it is very common to see an RFE where it says, prove that your beneficiary qualifies. And it's a very common RFE. And what that means is you just have to prove maybe get some evaluations, or maybe talk about the coursework that the employee has done, maybe talk about the experience that the employee has, and prove the beneficiary qualifies. And again, if suppose the employee does not have a proper degree, maybe somebody has a mechanical engineering degree, but they have a lot of IT experience, but they're applying for IT job. These kind of RFEs are pretty common. So simply they come back and say, your employee does not have the right degree. How does he qualify? So these are the kind of things that could come out. Or sometimes they might simply say, you, the petitioner, the employer, prove that you are a legitimate employer. So prove and show us all your company documents, maybe your lease documents, maybe your tax returns, and so on. So the bottom line is, look very closely at the notice, see what documents they're asking. Every document is crucial. No document is not important. If the officer has asked for a particular document, there is a reason for it. So it has to be explained. In case you do not have the document, that is okay. You just have to explain and provide some alternate documents. So completeness and accuracy is super important. Timing is super important, and the way you document is super important. And most of the time, the employers, when they get an RFE, they're very cautious. They try to provide all these documents, and doing so and ensuring that you provide these documents before the deadline is the only way to guarantee that USCIS properly adjudicates the RFE. And at least on a high level, majority of the RFEs do get approved. So nothing to panic. The only thing is, worry about the deadline, worry about making sure that all the documents are provided. And doing so, most of the H1B RFEs typically end up in an approval.
That is very nice. Thank you so much for that hopeful note, Chand. And we do have a lot of questions from our audience. We are going to quickly take them, but you were also talking about the stock market crash. I mean, sometime back when you gave the update. What do you think is the major cause, and how is it affecting immigrants or going to affect more immigrants? If you can relate it to that also.
Sure. So when we talk about H1B program in general, H1B program is something where the corporations, the US corporations, hire foreign workers. So when we talk about corporations, the corporations are very, very integrated with the stock market, because if the stock market is good, the big companies, for example, if the stock market is good, their board will let them like open up more projects, do more hiring, and so on. And if the big companies open up projects, the smaller IT companies who do staffing, who do IT services, consulting, and contracting, those companies will get more projects. So the bottom line is, since H1B program is entirely dependent on uh, US corporations, and then US corporations, especially the big corporations, drive, like for example, what kind of technology hiring is required to be done. And H1B program is mostly into technology hiring. So so all these things are interconnected. And what that means is, if the stock markets don't do good, you can expect a lot of the big companies freezing their projects, freezing their hiring, and they will not initiate new IT projects. So IT projects will be put on hold. So this could have a ripple effect on the H1B program. This could have a ripple effect, because only if there is market demand, only if there is a need to do new IT projects, people need to hire, the companies need to hire the H1B employees. So we are just hoping that whatever happened today. So today the stock market crashed, historical levels of crash, and right now, a couple of minutes when I checked the market, I think it was down 1,500 points. That was down 1,500 points, and again, the stock market sometimes are very erratic. It could be a temporary blip. If it's a temporary blip, that's what we all hope for. I don't think it is going to impact us bad. But again, if it continues and it is going to drag us down, a recession is possible. And if there is a recession, obviously, a lot of the IT companies, big companies, will immediately freeze all the new IT projects. They will not. They'll probably put a lot of projects into support mode, and they will cut a lot of contractors. So the big companies, they will stop their own hiring. They will stop contracting, and that in turn will impact the lower companies. Companies, even like big companies like TCS, Accenture, Infosys, which depend on these other big companies for IT services, and that in turn will impact even smaller companies, smaller IT services companies. So in a whole, if there is recession, or if there is a continued impact on the stock market, I would think it would impact the stock market, because if you look at last 4 years, and even President Trump's market was not really impacted. The stock market always did good during President Trump's first term. during Biden's 4 years, the stock market was not impacted. And what that meant was there was a lot of demand for people. The companies were doing good. So we just hope that the stock market comes back up, because if the stock market continues to do bad, I can definitely see a big problem for H1B program.
Right, Chand. I mean, it's intense. I mean, all this, how would I say, the crash, 15 points, 1500 points down, even till now. So it's going to take some time. Let's see how it goes. But I'm so happy, like, that we have so many viewers and we're going to take them up quickly. But yes, the ripple effect is going to be on, not just on the H1B applicants, visas, everybody. I think everything is going to be affected by this. So we'll just have to wait for now and watch. And we don't know what is the reason really, right, Chand?
Yeah, I
Let's
think
pick up.
because of tariffs, I think what has happened is now we know that the tariffs that the country has levied. Now, what's going to
Mhm.
happen is we don't know how the other countries are going to react, because China already said that they're going to retaliate, and European Union, they're talking about retaliation. So I think at a certain point, I mean, again, if these tariffs cause other countries to negotiate and lower their tariffs, maybe it will help the country in the short term and also in the long term. But if the countries start retaliating, like some countries have been coming back, what's going to happen is we don't know the impact, because the market reacts to short term news. So the market immediately is going to look at China is going to retaliate. They're going to see that news, and it's going to crash the market on a short term basis. But long term, we don't know how it is going to impact. Maybe the countries are going to come back and negotiate. So we don't know. So I think it is definitely something that all of us will be watching in the next couple of days, because clearly, like you said, it will be a ripple effect, because stock market is where things start, and based on the stock market, we will have a ripple effect into the entire economy. So hopefully, if things stabilize, I think it's good for the country. But if things don't stabilize, stock market starts having a prolonged impact, I mean, prolonged decrease, and the markets don't come back up, I think it is bad for everybody involved. So let's hope for the best and hope that this, whatever we are seeing today, is a short term impact.
Yes, Chand, we really hope so. And, I would like to tell you that we actually have a caller who's joined in, and it's none other than Shashi Kumar Reddy. Actually, I was just going to take up his comments, but happy that he joined. So, hi, Shashi. Thank you so much for joining us. Tell us where you're joining us from.
Sure. I'm joining from Seattle, Washington.
Okay, so Shashi, why don't you ask your question yourself? Tony Chand is here. Go on.
Okay, sure. Sure, sir. I'm on STEM OPT with I-797 consular approved with my old employer. Recently, I got an offer with other employer and filed for H1 transfer with change of status. So I see the case was approved in case tracker app, and also my employer received an email for premium processing saying like H1 was approved, and it says consulate port of entry was unknown facility with I-94 number. So just want to confirm, like it's gonna take some more time to get the I-797 document to my employer. So just want to check how can I know by that email whether it was approved with I-797A or again the consular processing.
Sure. So in your case, if the employer has applied with change of status, more than likely they got change of status. I mean, I'm pretty positive they got it as change of status. That being said, what happens is the case gets approved. Within a day or two, you get that email, and that email normally will have the consulate. Even if it is change of status, they put consulate. And I think what has happened in your case is you just got that email, so you saw that email. And next, what's going to happen is in next 5 to 7 days, the company will get a hard copy, and they should get it. The hard copy will have the I-94 information, and that is the best place to confirm. And another place to confirm is ask your employer if they have done e-filing. If they have done e-filing, that approval copy will show up on the website probably within a day max. So if they have done e-filing, you can ask your employer to go to my.uscis.gov, immediately download the hard copy of the approval. So if you have e-filing, you can probably verify it today itself. If you do not have, if your company has not done e-filing, wait for about a week. Week is probably the max. And in a week, they will get the hard copy in USPS mail, regular mail, and then you'll immediately be able to see the I-94. And if you see the I-94 and you see a wording that says change of status has been approved, you're good. And more than likely, you should get change of status.
Okay, Sure. But based on the email what I have received, they mentioned I-94 number from premium processing USCIS email. So can we confirm like from this email, sir?
No,
Like
no,
I know
no.
this
From the email, you cannot confirm. Yeah, yeah. From the email, you can never confirm because we had seen multiple things. So email is just to confirm that your H1B part has got approved. For the change of status part, you have to see your notice, the actual notice that comes in the mail. The only good thing is if your company has done e-filing, they should be able to get it immediately. So they can just log into the USCIS website, uh, get that copy immediately. If they have not done e-filing, wait for a max about 5 to 7 days from the day you got your email. That hard copy will have it. Email, you cannot really confirm at all.
Okay, sure. Good. Thank you, sir.
Well, thank you so much, Shashi, for joining us. And, I'm so glad that Attorney Chand was able to give you answers. All we really need from you is for you to subscribe to our channel. So if you haven't as yet already, subscribe to our channel. It is at Immigration Talk Show. And yes, go check us out. We are also not just on YouTube, but also on LinkedIn, Facebook, X, and Instagram. So follow us, stay connected with us. And thank you, Shashi, for joining us. I hope you have more questions and can join us again sometime later.
Okay. Thank you very much.
Thank you. So, thank you, Chant, for taking that up. And with that, friends, I really hope that you're enjoying this conversation we are having, this discussion we are having. So much important updates, and you don't want to miss out on all of these updates. So stay with us, and also you can contact Attorney Chant Parvataneni yourself if you do want to have a one-on-one consultation. In fact, even Shashi, if you still want to continue to ask your questions, why don't you call him up? And his number is 817-523-8247. And his email address is law@spblawfirm.com. And go visit www.spblawfirm.com to get to know more about Attorney Chand Parvataneni. So that said, Chand, I know it's been so much to say. I feel like sometimes 1 hour is very less with us. So I think we will go on to talk more. But once again, friends, don't forget to subscribe. All right. Yes. So coming back to our questions, Chand, if you can also tell us if an H1B visa is revoked by USCIS on the Department of State, so does the visa holder have to leave the country immediately, or what are the next steps that they can take to challenge the revocation?
Sure. So again, we have two different departments. One is USCIS under the Department of Homeland Security, and then we have Department of State, which is the consulates. And normally, we do see two things happen. Sometimes somebody's in United States, they're working on a visa, maybe on H1, or maybe they're a student on F1. And if they have any criminal infractions, what happens is Department of State, which is the consulate that issued the visa, they suddenly come back and say that their visa is getting revoked. So that is something that has recently started happening on a larger scale. So even if the approval that USCIS has given, the H1B approval, it is still valid, the consulate will come and say your visa is cancelled. And people should understand the difference between a visa and the H1B approval. So the H1B petition approval is issued by USCIS. The visa, on the other hand, is issued by the consulate. Anytime you hear the word visa, it is the consulate, Department of State. So sometimes even if Department of State revokes the visa for some reason, what that means is they cannot use the visa again. So if they travel out of the country, they cannot utilize that visa because the visa is cancelled, or something is wrong with the visa. So if somebody gets a notification that Department of State has revoked their visa, all that confirms is that their visa is not valid. And now the next thing that people have to see is their status in the country legal? So when we talk about, say, the visa got cancelled, but the H1B petition, the H1B approval given by USCIS, if that approval is still valid, their status is still valid in the country. So they can stay in the country until the date their I-94 is valid. So if somebody's I-94 is still valid, H1B petition, the actual H1B petition approved by USCIS, that is still valid, they are good to stay in the country. The only thing is, at a certain point of time, whenever they go out of the country, they have to approach the consulate and go fix the visa problem. So that is the easier one. The part where it gets very complex is if the H1B petition itself is revoked by USCIS. So we also have some cases where USCIS does a site visit, or USCIS finds out that their employer has misrepresented, maybe something like a multiple registration fraud in the past. Or maybe USCIS did a site visit, FDN a site visit, and USCIS found the employer is not paying the employee. The employer is not following the rules of H1B program. So in those kind of cases, what happens is if USCIS finds an issue, what they do is they issue a notice of intent to revoke. So they don't just directly revoke the H1B petition; they give a notice. So that is where the embassy is different from USCIS. The Department of State embassy, it is immediate. They immediately revoke the visa. USCIS on the other side, they don't immediately revoke the H1B petition. What they do is they give a notice. They tell the company that these are all the issues with the H1B. They give 30 days to respond back because there is due process in the country. So USCIS lets the company answer back and respond back to the allegations. And if the company is not able to satisfy USCIS, they get the 30 days, they answer the H1B notice of intent to revoke. USCIS is not satisfied. That is the time USCIS will come back and say the H1B petition, not the visa, the H1B petition is revoked. And when the H1B petition is revoked, what that means is the employee's status is terminated. If that happens, they have to leave the country immediately or change their status to another valid status before the H1B petition is revoked. So, so the important thing is if USCIS gets into the picture, revokes somebody's status, that is the time when somebody has to immediately leave the country if they're not able to change their status. If Department of State on the other side cancels the visa, just make sure you don't use that visa again. You approach the consulate whenever you have to travel out of the country. So two different departments are out there, and depending on what the issue is, the rules are a little bit different. And if USCIS revokes somebody's H1B petition, there is no grace period. Their status terminates as of that date. So that is one thing that people have to be very, very cautious. If the H1B petition itself is terminated, there is no 60-day grace period. They have to stop working and they might have to depart United States. Otherwise, they will start accruing unlawful presence. And so the main thing is if the H1B holder believes the revocation or the notice of intent to revoke is wrongful or unfair, that has to be challenged. And what that means is, unfortunately, in the current rules, only the employer, the H1B petitioner, they are the ones that can respond back to a notice of intent to revoke. So if a H1B petition has a problem, the employer gets that notification, employer has to respond back. So it is very important that employer does that. And for some unfortunate reason, if the H1B petition gets revoked by USCIS, the companies have to immediately see if they have a solid case to file a motion to reopen or file a motion to reconsider, or maybe sometimes appeal that revocation. And action has to be taken. And if not, that whole problem of unlawful presence being accrued is involved. So just people have to be cautious. And if there is any kind of a challenge from USCIS, it is highly important that the company responds before the deadline.
Deadlines are always important. So, friends, I really hope that you keep track and don't miss out on any, and don't ever leave anything for the last date. I know sometimes we have this habit that we'll do, we keep procrastinating, and by the time we do, it's already the last day. And if at all we had to make any changes, it just becomes too late. So, thank you so much, Chand, for that, and for taking up each of our questions also. Very, very insightful. And I would just like to tell our folks out there that we're doing this, right, Chan? We make it a point to meet up every week. And why do we do this? It's so that anybody watching us can benefit from this. So I really hope that you folks are enjoying these sessions that we have, and you do subscribe and don't keep it for later. No more procrastination for nothing. I just subscribe now if possible, and share our content with your friends, your folks out there who are going to benefit, because the more the merrier. Why not? Everybody should benefit, right? It's free after all. Share our links and subscribe to our channel. Our handle is at Immigration Talk Show. And yeah, check us out. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. So, yes, that said, I think we should now take up Rag's comment. So, Rag, hi, I hope you're there. And Rag is saying, can a compelling circumstances, H4EAD, be possible without an I-140 filing?
So in the current rules for H1B, the compelling circumstances H4EAD, the compelling circumstances, because we're talking about H4EAD. So one of the primary requirements is the I-140 filing is required, and without the I-140 filing, I don't think you can file H4EAD even if it's under compelling circumstances. I mean, I've not done that before. I don't think it can be done. Maybe warrants a little bit more research on my side, but I think based on my experience, I do not think that is possible.
Okay. Rag, I hope you got your answer, and I know Rag has already subscribed. So I really like it when we have these familiar names and familiar users join us every week. So thank you, Rag, for your question. Now let's take up another one, and this is from Vishal. Hi, Vishal. Thank you so much for joining us on YouTube. And let's take up his question. If there is any possibility to confirm that my employer is applied H1B for me, has applied H1B for me, and also I want to know that when applying H1B, educational transcript is mandatory when applying time.
Sure. And again, we hear this a lot because sometimes the employers, I mean, tell people that they have filed the H1 and sometimes they do not file. And sometimes employers file and they don't share any documents with the employees. So these kind of things keep happening. And again, in terms of the rules, this is what the rules are. The rules are very clear. If a company is applying for a H1B, the company has to share a document called LCA. It's called Labor Condition Application. It will define what the role is. And every company, any company that is involved in H1B program, they do not have a choice because this is by law. By regulations, they are supposed to share the copy of the LCA before first day of employment, and this is mandatory. So LCA copy is something that every employee should ask their employers, and if employers are not sharing it, it is a violation of H1B program. So employers have to share it, and if some employer says no, I will not share the copy of the LCA, it is a violation that if DOL finds out or USCIS finds out, it is going to be an issue. That is one thing. And the second thing is the easiest way for you to confirm is ask for a copy of your receipt. And if you have a copy of your receipt, that is the easiest way to figure out that the company has applied for a H1B for you, because you will see your name, you will see your receipt number, and you can like go online, type in that receipt number, and you can see the status of that case. So that is very important. And if the company gives you the receipt number, it is pretty easy. If the company does not give you the receipt number, or say the company has applied and you got an approval, you have not received the approval, the only way you can get a copy of that is you can reach out to USCIS. And if you normally call them, they will not share any information because they will say your employer has to be on the call. But there is something called Freedom of Information Act. So if you do a FOIA request, Freedom of Information Act request, and it is pretty easy, you can just go online and do it. If you do a Freedom of Information Act, that is another way. USCIS normally will come back. Normally we see 30 days to 60 days, and they come back. They will give you a record of your immigration file. So if some employer is not sharing a copy of some approval, the easiest way is approach USCIS and approach them through a FOIA request. If you do it through the FOIA request, you might be able to get a copy. And in terms of educational transcripts, educational documents are mandatory at the time of filing. If you do not file it, you might get a very bad RFE. And proving that the beneficiary qualifies, that means you qualify for that position, that is mandatory. And just showing the degree is not enough, because the degrees come in multiple names. Sometimes it is called information system, sometimes it is called information engineering, sometimes it is called computer science, sometimes it is software engineering. So the names of the degrees could vary, but if you do not provide your educational transcripts, when you say transcripts, we are talking about the mark sheets, the coursework, that show what kind of courses you have done and so on. So the transcripts are super important, and if they are not provided, you will get an RFE. Sometimes the RFE could be pretty bad. I mean, you might not get a direct denial, but you probably will get a very nasty RFE sometimes. So to avoid it, I mean, the best thing is just provide the education transcripts upfront. These are super mandatory. You don't have to provide the originals. You can just provide the copy, because you don't submit originals with your filing. You submit copies. So definitely educational transcripts are super important. And I mean, you can skip an evaluation. Again, if you think that evaluation is not required, you might skip an evaluation, but do not skip the transcripts. The transcripts are super important.
Absolutely. Thank you so much, Chant, for taking that up for Vishal. And Vishal, I really hope that, because we see your questions, I would tell you, so sorry, Papa Kipari. Yes, we are going to pick your question. I'm going to take it up next. So I just want to tell you folks that yes, we really see your questions and we bring you experts and attorneys. Thank you so much, Chand, for joining us today. So now is the moment, for you to subscribe to us and share our content, like if you haven't already. And our handle is at Immigration Talk Show. So click, confirm, contribute, I would say, and that's how we grow together, right? So all in all, that's all we need from you. So
Yeah.
stay with us and Papa Ke Pari now. Let's take your question. So sorry to keep you waiting for so long. Let's go on with the question. Pratibha here. Okay, hi Pratibha once again. Employers submitted 221G RFE in February, I guess, waiting since January 2025. Case updated, date changed 4 times till now. No further update. In-house project, consulting company. Okay, that is what she says. That is the information she shared.
Sure. So, so the good thing is, looks like your employer has submitted the 221G response. So normally, what happens when you get a 221G is the employer gets email. So the employer gets contacted by Department of State. They send a bunch of questions and they try to validate some information. So the fastest way to speed up things from the company perspective is answer that 221G response, that email as quickly as possible. And once that information goes back to Department of State also initiates other background checks. Sometimes they contact the landlord. In your case, since it's an in-house project, there is no client. The landlord, the whoever who is the landlord that leases the space to this company, they might have got contacted. And sometimes if they do not respond back on time, cases get held up. And sometimes even if the company has responded and the landlord has responded, they keep doing their background checks. And what recently happened is in the month of February, just the last week of February, there was a DOS cable instructions to the consulates where the consular officers were asked to do some more additional vetting, social media vetting, and so on. So, because of extreme vetting that is going on and the rule changes that are happening since 2025 January, the burden on the consular officers also has increased. They have to do more vetting. Department of State is doing more vetting. So since it is December and the company has responded, and normally what we see is about 8 weeks nowadays, about 2 months. So 60 days is probably something that could be taken. And the very fact that you see your date updated 4 times, what that means is they are actually not sitting on. I mean, the file is not sitting on the table, but work is actually being done. I mean, I think there are background checks happening on the company, on the lease, various other things. So I think they are in the process of completing your file. And this is what I suggest: wait for about 60 days because you do have to give them the time. Once you cross that 60 days, the employer should contact the consulate. They should probably contact the consulate probably once every week and go back to the consulate and in an email ask them if they need any other additional documents. If not, justify the business reasons and request them to speed it up. Okay, so wait for 60 days, have your employer reach out to the consulate, have them send out an email, and see what's going on.
Okay. Thank you so much, Pratibha, for joining us. And well, I hope you got your answer and all the best. Looks like it's good because it's not sitting and they're working on it. So you should get your answer soon. Thank you so much. And don't forget to subscribe if you haven't already and share our content, Pratibha. Thank you. And quickly, we will take up Rag's question, the another question he joined us with. So Rag is asking, part-time H1B can get through USCIS, but what are the chances of the consulates?
Yeah. So part-time H1Bs are completely legitimate, and companies can apply for part-time H1B. There are a couple of ways they have to do it. On the LCA, they have to say it is a part-time H1B. On the I-129, they have to say it's a part-time H1B and specify the number of hours. And that being said, when you go, I mean, like you said, USCIS does not have any problem with it, with part-time employment, with part-time H1Bs, because it's completely legitimate. You get an approval here. You go back to the consulate. So at the consulate, the main thing they're going to scrutinize is, are you going to United States to comply with the terms of your visa? So the part-time, when you say part-time, it can be 5 hours, it can be 20 hours, it can be 25 hours. So what they say is they also see how much money you are making through this employment. So the thing is, if it's employment where you're reasonably making decent amount of money to survive in the country, even if it is part time, they don't have a problem. But again, you can expect a little bit more vetting because they want to make sure that you are going to work part time, but you're not really spending the other time that you have to do a job, an unauthorized job. So maybe working at a restaurant, maybe working as a Uber driver, for example. So these are the kind of things they want to focus on. So what that means is, yes, there will be a little bit more additional vetting. They want to make sure, yes, you're going there to do only this part-time H1B job, but you're not going to do something else, something that will violate your H1B status. So there will be some questions around it. And also they want to make sure, because it's part-time, because the salary is going to be less, is that enough for you to sustain? So you might have some additional questions, but again, every case is different. I mean, if the salary is decent enough, even with part-time, you're able to make a living, and it makes sense for them, I don't see a problem. It's completely legitimate. uh, I mean, all you have to convince the Department of State consular officer is that yes, you will comply with the regulations, and yes, the company also has a real, genuine, bona fide job, and there's a really a good reason for them to do it as a part time. Because some companies misuse part time. They say it is part time, they make people work for full time because they feel that they can escape by paying for part time salary. So there have been issues in the past. So the main thing is, you can expect additional vetting. They just want to confirm that the company is not exploiting you by marking this job as a part time and making you work as a full time. So questions surrounding it is what you can expect, but just by itself, I don't think you'll have a problem because it's a part time H1B employment.
Okay. Okay. Very interesting. Thank you so much, Chand, for taking that up. And also, Rag, for joining us with your question. So, okay, Pratibha is back with another follow up asking 60 days after RFE submission? Question mark. Thanks for answering. I think yes.
Yeah. So in your case, I think since we are referring to 221G, so it is a 221G response. So normally, once, I mean, I would say if it is 60 days from the date that you attended interview and everything is sent to the Department of State, the
Mhm.
consulate, I think it's a good time to reach out. So I think at least definitely 60 days after your initial interview date, I think the company should reach out to Department of State, the consulate, and also after 60 days after your document submission. So I think definitely there's no harm if the company contacts the consulate right when you reach the 60-day mark of your interview date. That is the first time they should contact the consulate. And then again, if they don't get a proper response, definitely 60 days after the response was sent out to the consulate.
Okay. Thank you, Chand, again for taking that up. And Pratibha, I hope now you've gotten your answers. And Control, if you can, get our questions ready from our Facebook groups, it'll be very good to take them up right now. So, also, friends, I would just like to tell you that we are doing this not just for us, but for all of us to benefit. So, why not give us also, let's make it a win win for all sides. So, follow us, subscribe to us. Our handle is at Immigration Talk Show. And you can also check us out. We are not just on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. And of course, we have Chance Parvataneni, who you can also contact in case you want to know more or discuss more about your case. His number is 817-523-8247. And you can go email Attorney Chand Parvataneni by emailing him at uh, law@spblawfirm.com and go visit www.spblawfirm to get to know more about Attorney Chand Parvataneni, of course. And I see more folks joining us. Just stay with us. We will quickly take up this question first from Facebook. So, yes, this is from an anonymous participant saying, I'm selected in lottery. What are the next steps? Currently, I'm on a student visa and based in UK, but I am Pakistani national.
Sure. So the next steps are, so the good thing is it's good news. The lottery selection has happened and you have been selected. So the next thing is your employer has to file the H1B petition before June 30th. So that is a sharp deadline. So before June 30th, the company should file for the H1. And since even though you're a Pakistani national, you're based in UK, what your company will do is they will ask for consular processing, and they can select UK consulate because you're residing in UK right now. they can ask for the consulate in UK to be notified, and you can attend your stamping, your H1B visa stamping in UK once the H1B is approved. So the main thing is follow up with your employer, make sure they do the filing before end of June, and let them know the consulate that you will be attending your interview in. So if you're going to attend it in UK, just let them know the consulate name so they can make sure at the time of their filing they can put the proper consulate name in their I-129.
So, Chand, okay, thank you so much, Chand, for taking that up. And I think we do have more viewers who will quickly take these first. This one is from Charles. Hi, Charles. Thank you so much for joining us. I hope that you have subscribed to our channel. If not, do subscribe. Our handle is at Immigration Talk Show. You can already see. So, Charles is asking, please, my employer is an H1B cap exempt. How does he apply to prove it is a cap exempt?
Sure. So I think normally it is pretty straightforward. So for example, so there are requirements on when a company is cap exempt. For example, a company is a not-for-profit organization. It is it is affiliated with an academic institution. For example, they're cap exempt. So what the company will have to do is they'll have to look at the cap exempt requirements, and they have to prove through those documents. For example, if it is like a hospital that is affiliated with a university, what they will do is they will show that, for example, they're not for profit, and next thing they will show is they'll show evidence that they're affiliated with a particular, for example, a medical school, for example, and they prove that they're cap exempt. For example, if it's an educational institution, they will show their IRS documents to show that they're not for profit, and then argue why they are cap exempt. So in general, it should be pretty easy. So just there are requirements on what kind of entities are cap exempt, and they just have to prove evidence, maybe through IRS documents that prove that they're not for profit, their profile that they are exempt organization, and then they should be able to move ahead. In general, most of the time, universities, research organizations, or hospitals affiliated with other universities, these are the kind of entities that are cap exempt. And the attorney that's working on the case, they should be able to figure it out pretty quickly. And the documents are not very hard. I mean, most of the time, the employers, if they're already a cap exempt organization, because very select few entities are cap exempt, and it is pretty easy to figure it out, because if the company is a research organization, educational institution, or a hospital affiliated with another university, etc., it is very easy to prove that kind of evidence.
Right, right. Thank you, Chand, for taking this up for Charles. And Chand, if you don't mind me asking you, I really hope you have some more time to stick with us because I see a lot of viewer questions and I don't want to disappoint any
Sure,
one of
sure,
them.
sure.
Okay, so this is Ayush asking, hi, I got my petition approved in December 2024, but the employer is not sharing the documents to schedule my interview as previous candidates got 221G. So it seems waiting for their case result. So it seems waiting for their case result. Please suggest. Can I transfer the petition with some other employer?
Sure, sure. So I mean, again, there are two options. One, you talk to your employer and ask him if they still have a job and if they're in the plan of sending you for stamping, because the company will need to have a bona fide offer still valid when you go for the visa interview. So tomorrow, if they do not have a bona fide offer and you go for the interview, tomorrow you can run into an issue with misrepresentation. So the first thing is check with the company, check with the current employer, the current H1B petitioner, and see if they're going to send you for stamping. Uh, the bottom line is, if they are not able to show genuine bona fide employment, the next thing that you should look for is transfer. Yes, you should be able to transfer, because once you got an approval, if that approval is still valid, not revoked, what that means is you can actually, if you have another offer from another employer, your petition is a cap exempt petition. The reason is you have an approval in the past, you have been counted in the lottery in the past, and based on that, you can do a transfer. And that is what we see with a lot of people, because the employers, they have a project at the time of filing, and later on, for some reason, they're not comfortable in because they feel that they're getting more 221Gs, or sometimes maybe because that project is over, the project is terminated, for whatever reason. And in your case, because you cannot keep waiting forever, and your recourse is, if you have a better offer, if you have a different offer from another legitimate company for a bona fide offer, that company can do a transfer. And we have seen that happen a lot of times. I've seen people, they are like fed up with the current H1B approved company, and they just get a better offer. And since they get a better offer, it is a legitimate way of transferring your employment to another employer.
Okay, okay. Well, thank you so much, Chand. I mean, those were very important updates, and I really hope that Ayush, you too, you got your answer. And I see that Charles is saying, thank you so much, attorney. So, Charles, also, thank you so much for joining us with your question. I would just appeal to you to also contribute to us by just subscribing to our channel. You just have to do it quickly and hit that bell icon, so that whenever we have discussions like these, you are notified, and you can always join us, to ask any questions about immigration, or yes, tell us about your story as well. So thank you so much, Chand. And also Rag says, thanks, Chand, appreciate your inputs. Thank you, Rag, always a pleasure to have you watch us. And I think with that, we have taken up most of our comments from our folks here on YouTube. So I hope that everyone out there has enjoyed this conversation so far. In fact, I really had a few more questions, Chand, from our Facebook group. Do you have 5 more minutes?
Sure, sure. Yeah, let's go
Okay,
ahead.
let's do
Yeah.
this then. Well, let's have it on our screen. This is from an anonymous participant. Student visa second attempt. I got rejected in 2024. Now my uncle wants to sponsor me financially. He has a good position in USA. I'm showing his bank accounts and statements. What is my chance?
Sure. So whenever circumstances change, people can always go back for another interview for student visas. So the only thing is, when somebody is going for a student visa, the consulate is looking for two things. One, the intent, which is to go and study, and whether financially does he have the resources. The second thing is, they're also looking to make sure the student, after completing their studies, has enough ties to come back to their home country. So, in terms of financially, if in case the finances were a problem the last time, definitely somebody who's in US can sponsor him, can show financial support. However, the next thing is ties back to the home country. So, if somebody in US is sponsoring somebody's tuition, again, if the consular officer is not satisfied that there is enough ties back to the home country, because financially does not have enough assets back in the home country, the consular officer might deny that student visa. So theoretically, yes, it is possible, and because circumstances have changed, he can go for a visa stamping again. But most of the successful cases that we see are cases where somebody has strong financial ties back to their home country. If there are no strong financial ties back to the home country, typically it's always hit or miss, because a lot depends on how the officer feels on the intent of that particular visa applicant.
All right. Thank you, Chand, for taking this up. And now let's go on to our next one. This is also from an anonymous participant. Will it be an issue if I go to another state or visit and then to my university address after a few weeks of visit? Will it be an issue in port of entry?
Theoretically, it should not cause any issue. But that being said, what normally happens is, at the port of entry, the officers are asking for the intent. They're asking for, like, they ask about various things about somebody's travel and travel plans. And again, it depends on the officer. If the officer feels that something is not right, they'll be called for secondary. But if the officer is convinced, they see the travel plans and they understand, yes, okay, he's going for a visit and then he's going back to his university, it might be okay. So what that means is, a lot depends on the CBP officer, and how that message is conveyed back to them and what they feel, because they are looking for any kind of pointers, any kind of red flags. And again, it's very common that people go visit like family before starting their school, and people have legitimate reasons to travel to some other place, then join the university. So upfront, I don't think there is a problem. But again, be prepared for questions, and if they question you, just convince the officer on your real intent to visit temporarily, and all those other things. So again, it just depends on the officer. I mean, most of the time people are okay, because even if they go to secondary, and again, if that is what they find as the intent, there should not be any problem.
Okay. Yes, absolutely. And We do have more questions, and I see Anand asking questions. So that's if that's a question, then yes, we are taking up questions. If you have any questions, please ask your question. We will take your question. That was a lot of questions. Okay. Anyway, so anonymous participant is asking if I call for my I-20 from a particular university, but later don't go to it. Is it possible to email them and let them know about a change in my decision? Will they allow? Will they charge any penalty? Or this has any legal implications?
Again, if somebody gets an I-20 and they have change in plans, the legal way to do it is make sure you're working with the school DSO, make sure your service is transferred properly. So if the service gets transferred appropriately, the service is not terminated, normally it should not be an issue because people have change in plans and they have genuine reasons. So if somebody is doing it, I mean, changing their university, transferring to a different university, they got an I-20, they don't join that university, that is probably okay from immigration perspective. Just make sure that you're notifying the school DSO and doing it in an appropriate way. And they should not charge any penalty or any of that sort.
Okay. Thank you, Chand, for taking that up. And I think we will take this as one of our last questions from our Facebook group. But Anand, if you have any question, please quickly tell us what is your question because we are going to wind up very quickly. And this anonymous participant is asking on our Facebook group. Hello, all. I completed my DS 160 form on November 23rd, 2024, and I scheduled my visa interview appointment in May 2025. I want to postpone my trip due to personal reasons and would like to reschedule the visa interview. So, my question is can I postpone until November 2025 or May 2026? Thanks in advance.
So the consulates, they're currently giving one chance to reschedule, so they should be able to reschedule. So you might have to reach out and reschedule your appointment. So one time, people are able to reschedule their appointments currently. More than once, they have to again pay and again redo their entire appointment again.
Okay. Okay, thank you so much, Chan, for taking all of our questions so patiently. I mean, it was simply amazing to have so many folks out there ask their questions as well. I was actually waiting for Anand's question. And Anand, if you can hear me on LinkedIn, I'll be really happy to receive what question you have because we have Attorney Chand here who will be happy to answer. But also, Chand, before we say bye for today, would you like to, leave us with an end note, especially on the topic of discussion we had today, and maybe a few updates or
Sure,
some
sure.
things to keep in mind?
Sure. So one thing I definitely want to kind of emphasize is uh, last week of February, the Secretary of State Marco Rubio has like publicly stated that 300 visas for people who are already in the United States have been cancelled. He has stated that. And on top of it, this week we are actually seeing. I mean, this is like first-hand information. We have seen emails from our clients, emails where the consulates. I mean, I've seen three consulates so far. I've seen Chennai, I've seen Mumbai, I've seen Delhi. Three consulates where people got emails, and those people are in United States. They got emails and said their visas have been cancelled, and they have to like go out of the country. If not, if they don't self-deport, they could be deported. So it's a very, very threatening kind of an email that we saw. And again, the common pattern is these people had some infractions, maybe minor, but again, end of the day, they had some criminal record. Maybe things like shoplifting, drunk driving, DUI, driving under influence. So these kind of things. So what that means is because the focus is so much on criminal offenses, no criminal offense is small. Even a small offense is still an offense. So the bottom line and the suggestion for everybody is be extremely cautious. Always follow the rule of the land. I mean, sometimes you have peer pressure. Don't get influenced, especially with drunk driving. You have a party in the weekend and like your friends influence you and you think it's only a little bit, you only have a block to drive, but that could kind of jeopardize your career. So always follow the rules. Don't take any chances. Even minor infractions are getting running into major issues. So always be cautious. And so these kind of things we have just started seeing. So even a small infraction will jeopardize your career. So don't do anything that could hurt your US career. And 99% of the people, I would say more than 99% of the people, don't have to worry about these things. But it's this 1% that sometimes get influenced by their friends and accidentally they do mistakes. Okay, so just always pay attention. Don't get influenced by your friends. Be extra cautious.
Absolutely. So I think with that, I would just say be good, do good, and do what you're there for. So don't get distracted by other things. Focus on what you're there for. If you're a student, go do it, and if you're working, work hard. All the best to all folks out there. Thank you so much, each one of you, for joining us. And yes, don't take too much risk. That's also bad. That's from our controller here. He's also giving out. So thank you once again, everybody, and yes, love it that you joined us today with all your questions. Please do not forget to subscribe to our channel. And if you have already, also share our content with your friends and family, whoever can benefit, because this is free content and many can benefit. We don't want to miss out on that too. And all we need from you is some support, and that you can do by following us, connecting with us, and subscribing to our channel. So, once again, thank you so much, Chand. And it was lovely having you. It was such an insightful session. I wish we could keep continuing, talking and learning so much from you every time you visit us is always great. So thank you, Chand.
Thank you,
See you
Dipasa.
soon. So, friends, do check out Attorney Chand Parvatineni, and you can go check him out in his website. His website is www.spblawfirm.com, and definitely you can contact him or get a one on one consultation about your case. His number is 817-523-8247, and go email him at law@spblawfirm.com. And that's it. Well, once again, have a great day, Chan. Thank you once again for joining us. And folks, you can also email me. My email address is nipa@staffingly.com. And you can also WhatsApp me or call me on my number. My number is 408-335-6444. And yeah, have a great day. But stay tuned here on Immigration Talk Show, because there's more coming. We also have another webinar lined up with none other than Attorney Uma Mantravadi from Mantra Law. And my host Sam is going to be there for that session. So stay tuned to our channel. And we are also going to join you, both me and Sam. We are going to join you for on daily immigration doors with another very interesting content. Interesting topic of discussion to discuss about. So, yes, bye bye for now, but don't go anywhere. Keep watching Immigration Talk Show. Hello, everyone, and welcome to another very insightful episode on immigration and jobs on Immigration Talk Show. And I'm really happy that you are able to join us and stay with us because a very insightful webinar is lined up for you. Of course, I'm your host Napasa, and today we will be diving into another very important topic and very timely, I would say. And before I tell you what the topic is, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, with that in mind, friends, thank you so much once again for joining us. Our topic of discussion for today is H1B season is here, and will rising deportations affect your chances? So, we are going to find out in today's webinar because, yes, there has been a lot of changes recently and immigration policy shifts, stricter compliance measures, and so on and so forth. So, yes, H1B applicants also and current visa holders are asking, what does this mean for me, right? And will it affect their chances? And how can they prepare for this season with confidence? So to help us prepare and discuss and know further about how to prepare ourselves, well, I'm really honored to welcome a very special guest, none other than Charles Cook, a leading immigration attorney with over 35 years of experience and the author of In Pursuit of a Better Future, a comprehensive guide to navigating the US immigration system. And he has definitely helped countless individuals and businesses, to successfully manage their immigration process. And today he's here to share his expertise again, once again with us. So, yes. Hi, Charles. How are you doing? Thank you so much for joining us
It's great to be with you. I love being on with you.
today. We too. We love having you, and it's exciting that you made it here. In spite of your busy schedule, that you are here to speak
Yeah,
with us for an hour.
my travel schedule's been a little crazy recently, that's for sure. Just got back from Peru last weekend, but we are in the midst of the H1B season and the literal utter nuttiness that is the Trump administration. I don't know if nuttiness is a word they use in India, but you should learn it if you're coming to America.
Tell us more about nuttiness then.
So one thing that's important everybody to realize, today is the very first day that your company can register for the H1B visa lottery, but today's not the only day. The boss and I were talking earlier, is how's the day going? Well, today's easy because these are the cases we filed today that we've ready for, that we spent weeks getting ready and all our ducks in a row and we get our lottery entries in. But it's the ones that call us on the last day at 4 o'clock, say, "Oh my gosh, I've got to get my lottery application in." Those are the ones that are kind of always kind of a little iffy. But these are the easy ones. And honestly,
So,
Napasa, this is
yeah.
way better than preparing an entire H1B application. I mean, this is just so much better.
I'm glad. So, every year, I mean, 35 years of experience, do you, face a lot of last minute, like you just said, people on the last day who are going to call you and say, how many numbers was the highest maybe for you?
Well, we probably do. We are not an H1B shop. There's a lot of law firms that's literally all they do. That's not us. We're actually a full service law firm. We do everything from H1Bs to labor certs to EB1s to deportation defense, employer sanctions. We defend employers in H1B audits. We do the whole gamut of work at our firm. We've got 50 folks who do this stuff. And most of them have a lot of experience like I do. So for us, this is just another trip around the block. But I think this year might be a little different, honestly. First of all, it's more expensive. It's not $10 anymore. I think that will dissuade some people. I do. I think we will not get the number that I was surprised with last year, honestly. I thought it was going to be a little bit lower. I think, and especially with Trump basically about to start a recession, I think the numbers might be a little lower than last year, which is great for people that enter the lottery because it'll increase their chance of course, getting selected.
So, yes, folks, do join us in conversation. All you can do, what you can do is participate by commenting wherever you're watching. We are streaming live right now on YouTube, and our handle is at Immigration Talk Show. Well, you can also call us up. You can have a word with Attorney Charles here himself by calling us on this number 425-436-6335, and the access code is 988-888, displayed right on top of the screen. So call us. And so, Charles, what can we expect? I mean, of course, there's rising deportations every day. We have, especially before the season, I think all we were hearing is deportations, a lot of it. So, what do you have to say
You,
about that?
pass the question. Would you be surprised if I told you that Trump has deported fewer people than Biden did during the same exact time 4 years ago? You'd probably be surprised by that because it's true, but it's true. See, here's the difference now versus Biden. Biden never talked about it. He never talked about it because I think he felt politically it wasn't a good thing. But the ICE machinery that Trump set up the first time, that kind of petered off during the first parts of COVID, that came roaring back. And Biden had his best year ever deporting people in 2024. He deported over 300,000 people. Trump will get to that number, but the difference now is you're hearing about it every single day in every newscast and every newspaper. And that's because Trump is a marketer, right? He's marketing it. He's selling it. He's trying to make it look like he's doing something more or better, when in fact, he's doing the exact same thing as the last guy. Now, one difference, of course, is the people running the immigration service are now tasked with not necessarily approving cases. If you go to the USCIS website, it says, keeping America secure. I didn't notice the word secure in the name of the USCIS. I thought there'd be service. That's what the S stands for, not security. But they literally got the head of Homeland Security riding a horse on their website. It's so take that for what it's worth. Take that to mean that applications will be denied at a higher rate. Remember, Trump last time, denial rates for H1Bs, 30%. During Biden, 3%. So we're going to see, again, a reapproachment to these adjudications, and not just at CIS. So this rising tide of deportation, this is going to carry over to the consulate as well. The consulates are going to get harder and make it more difficult to get visas to come to the United States. We're going to see a lot of decisions that don't make any sense. And of course, as we learned yesterday, you better not say anything about Palestine because you're not getting a visa if you do. I don't know if you saw that yesterday, but they will be revoking visas and denying student visas, and I imagine others, if your social media suggests that you're pro-Palestinian. How about that? That seems a little crazy, don't you? Don't you think?
It is, it is.
The country of free speech isn't so free anymore, is it?
And travel ban is what I also heard.
Oh, that travel ban is going to come either today or Monday. So I would suspect that it'll be the usual suspects. He'll ban travel from Afghanistan, Iran, Yemen, all the bad actors. But I suspect that we're going to see a broadening of those countries as well. One country that will not be on the list is India, because Modi's done a really great job of sucking up to Trump. And whether you like Modi or not, I mean, the reality is he plays Trump like a violin, and so that's good, and that's really good for Indian nationals. Very, very good.
Good negotiations, I would say. So yes, and deportations happening, and how directly or indirectly is it impacting H1B applicants this year?
That's a really great question. The systems that they're putting into place right now, like the registration system, for example, these things are designed to make ICE and USCIS, one, work closer together, and two, be more active as opposed to reactive. So if ICE, let's say somebody's H1B is terminated, the employer sends a letter to the immigration service. That person has 60 days. That ICE is not going to come visit you on day 1. Will ICE come on day 61? Quite possible. At this stage, they're very focused on the undocumented. They're very focused on that. But they're in this for the long game. If my math is right, there's 201 more weeks while Trump is president. I would suspect by week 100, we will see a shift to really doing active enforcement against visa holders who violate their status or overstay their visas. Because the information they're gathering now and their incredibly active use of AI, very active use of AI at ICE and USCIS, is designed to let ICE have their job easier. So yeah, I think you got to be very careful. If you're in H status and you violate it and it comes to the government's attention, I think you got a problem. And if you're terminated, that's the piece of advice. Everybody wants to wait till day 60 to see if they can change to the H1B, get a new employer. I would suggest filing a visitor visa, change of status right away. And then, and while you're doing the H1 search, and if you get the H1 new employer before the 60 days, just file it. And then you can withdraw the visitor visa. But this way, you're protected by the visitor visa for 6 months. So it's a much better protection, and it should avoid individuals being caught up in any ICE enforcement actions.
Well, great points. Thank you so much, Charles. And you're talking about, termination also. So, what about H1B holders, where they at high risk of deportation if their employment is terminated by any chance? And maybe what legal options do they have?
Well, I think I kind of already answered that. And the answer is file a B1 change of status, B2 change of status, change to a visitor and protect yourself. And if you do that, you're fine. You're not at risk. If you don't do anything and 60 days lapse, I think you're at exceptionally high risk. Because remember, the government knows where you are, right? They know exactly where you live. They know who your employer was. And ICE is inherently lazy. They're not going to spend weeks looking for one person. But if they can take a drive down the street and pick up somebody in 30 minutes, they're going to do it because they all have quotas. And an H1B who's been terminated, who's out of status after 60 days, is just as good as somebody.
Okay, so friends out there, you can also join us. Thank you so much, Neha, for joining us with your comments. We are going to take them up. Just stay with us. And also Monali Thakur, thank you for joining us with your questions and comments. I would really suggest and appeal folks out there to join us on call as well. And our number is 425-436-6335, and the access code is 988-888. So I think, yes, we are here back again with Charles. So Charles, thank you for telling us about termination of employment under H1B, and there are consequences, of course. So now I would really like you to highlight what measures or what can applicants under H1B take to ensure compliance with immigration laws and avoid potential deportation risks.
Well, first, it's really important to remember you are hired for a very specific job. You need to be doing that specific job. You should have your H1B job description memorized. And if you're doing something different than that, you need to change employers, because ICE is ramping up their audits from the FDNS, which is the Fraud Detection National Security folks. They're adding people to that. They're changing adjudicators to fraud people and visiting employers. And they'll show up out of the blue and they'll want to talk to you. And you should be conversant. You should know your H1B job back and forward. You should have your pay stubs in your desk so you can show them. You should, if you're not going to be there that day, leave a note with the receptionist at your building. Hey, if anybody comes and visits, here's where I am. Because if you're not there, they'll just think you're not working and they'll just move to revoke your H1B. So one, being in compliance with your job. Don't get an H1B as a software engineer and be working at a cashier at a 7-Eleven. That's not a good thing. It's really not a good thing. One, two, don't work outside your job. You have no legal right to work outside the H-1B employer. None. That includes remotely. You can't work remotely for a company outside the United States, in the United States, on an H-1B visa for U.S. employer. That is illegal. That will violate your status. And of course, one of the most common errors we see happen to people is they travel on their H-1B, they come back from vacation, and CBP, Customs and Border Protection, the friendly people at the airport in the black uniforms and the guns, they make a mistake on your I-94 card and they don't give you the full time. So every time you travel, you should be checking cbp.gov I-94 to make sure that your status dates are equal to the dates you believe they are, so you don't accidentally overstay. 3 or 4 times a year, we're trying to retroactively fix somebody who wasn't paying attention when they traveled and returned to the United States.
Okay. But, Charles, I also heard that it's going to be a little relaxed now that people who are probably under cap exempt, they can also work, say, for example, a professor for a university. They can also work part time or be a guest lecturer somewhere else or maybe take tuition. Does that
With
work?
another H-1B. You can have 2 H-1Bs at the same time. So you can have a
Okay.
cap exempt and work cap subject, but you can't work there without an H-1B. You have to file that H-1B. So really, really important. Don't be caught with your pants down on this. I can promise you it will not be a pleasant experience. And they will charge you with fraud, which will essentially bar you for life from coming to the United States.
That's going to be sad, really. But thank you so much for highlighting that. And yeah, now what about USCIS? How does USCIS verify the H-1B employer's compliance, especially with wage and work site requirements as well? And what really happens if violations are found?
Well, USAS sends out their FDNS folks. They are generally contractors. They don't show up with a badge, but they have a little permission from immigration, the USCIS, to do these audits. And as they do these audits, what they're doing is they're making sure that, one, you're doing the job that you said you were going to, immigration was told you were going to do. 2, you're getting paid the wage that you're supposed to be getting paid. Now, here's a great example. Let's say you hired as a software engineer, but after a year, you get promoted to software engineer 2. Your employer needs to change your H-1B. They need to update that H-1B, because if FDNS shows up and say, well, you had a different job? Well, it's kind of the same job. No, it's different, and you're getting paid more. I think this is a violation. And then they send out a notice of intent to revoke your H-1B. Now you've got to deal with that problem. And if they end up revoking it, then you're out of status, possibly with a fraud finding. So again, you are now in a day and age in which exact, strict compliance is 100% necessary. There is no room for errors in the immigration sphere.
That's very interesting, Charles. And what if it was all written in the job description that maybe after 6 months you're going to be getting an increment, or after a year you're getting an increment? Even then, you'll have to file a new H-1B, like when your job role gets upgraded.
If you're getting a change in your job duties and your job requirements, you should be updating your H-1B. It was, if we go back 10 years, I would say, don't worry about it. You're fine. In 2025, 100% you should be doing this. 100%. You cannot play games with this. You cannot, more importantly, you cannot trust anybody else with your immigration status other than you. You need to take ownership of this. So that means you need to be a pain in the butt to HR. Hey, you changed my job. The lawyer started this. I haven't heard from them yet. What do they need from me to file the update? I mean, you need to be proactive in dealing with your employers on this.
Very interesting. Thank you so much, Charles. Very important update, folks. I hope you're taking notes. And now let's quickly take up a couple of comments from our audience. Let's take up Neha. Neha saying, I'm currently on an H-1B and I heard that deportations are increasing. If my visa expires while waiting for an extension, am I at risk of removal, even
No.
if my employer has filed for an extension on time?
No, your status is automatically extended for 8 months once you file an extension. That's the law. Your lawyer should give you a copy of the law so you can take it with you wherever you go. Do make sure to carry that extension receipt notice with you. Ask your employer for it, because that's one way. Most states you get a driver's license extended, but it's your status. And in the United States, I hope people are aware of this. You're required to carry with you evidence of your status at all times. That means the I-94 card, not necessarily the passport. So you should have a copy of the I-94 card in your wallet at all times, or the receipt notice in your purse, so that if especially if you live within 100 miles of the border, you can be stopped at any time by an ICE or CBP officer with no warrant. And if you don't produce the documents, they can arrest you and put you in removal proceedings. It is actually a deportable offense to not have evidence of your status with you.
Well, yes, I hope that you are all doing that, folks out there here in the United States who are migrants. And Charles, now we'll take up Monali's comment. And Monali is saying, I was laid off currently, and I'm struggling to find a new employer within the 60 days grace period. If I fail to secure a new job in time, do I automatically get deported, or are there any legal options to stay and transition to another status?
So if you are in the 60 days, obviously you're fine. As I said earlier, you should be filing a change of status to visitor. This extends your status automatically for those 180 days, and you're automatically in status while that's pending. And it also gives you an opportunity to extend your job search. So it's worth filing that extension, that change of status with legal counsel for you and your family. That will protect you during that time frame.
Okay. All the best, Monali.
Now I will tell you, if you don't, then yes, you can be deported. You can be picked up and arrested, put into deportation proceedings. You can't be physically deported without going through a court hearing, which means you could be in jail for months waiting for a court hearing.
And that's going to be ugly.
Not a pleasant experience.
Now let's thank you so much, Charles, for taking that up. And now let's go to Kiran. Kiran is asking, how will the recent changes to the H4 visa policy impact the lives of young Indians in the United States who mitigated as minors?
Well, we know, for example, first of all, if people are not aware of this,
Sorry,
if your child came into the country before they were 14 years of age, you are required to register them on their 14th birthday as an adult. And you are in violation of the law if you don't register them. That registration requirement is not active yet, but will be active, I think, in the next few weeks. So really important to remember that. As far as the kids that are going to age out, there is been no other than that. There's been no real change in the immigration laws, because first of all, only Congress can change the immigration laws. The president can't change immigration laws. So what you're seeing here, I think, is a situation where you have thousands of Indian H4 kids who are aging out and either have to leave the country or change to a student visa and begin their own terrible H1B journey in the United States. That's why they need to keep fighting for a change in the law. I will tell you that there will not be a positive change in immigration law, at least for the next 2 years. There is zero chance that's going to happen politically because of who's in charge of Congress.
Right. Okay, thank you so much, Kiran, for participating with your question. And I really hope folks can also join us on call. So the number is 425-436-6335, and the access code is 988-888. Do join us on call. And now let's take up RK. Hi, RK. Thank you so much for joining us with your question. And RK is asking, Charles, do you see scrutiny on level 1 and 2 wages for H1B?
It really depends on the job. We actually had this debate in our office a couple of days ago. We were hired to get a H1B visa for a lawyer, a new lawyer, brand new lawyer. And obviously the company wants to use level 1 wages because level 2 wages are significantly higher for a lawyer, significantly higher for a lawyer. And we concluded that they're going to be okay with a level 1 wage because they are literally, everything about the job is entry level. So the key here is really looking at and making sure that the job itself is one that allows for level one wage. If you put in a detailed job description that is clearly indicative of a non-entry level, that is somebody just out of college to do that job, then you're probably going to get investigated and dinged on that. Level two wages, I'm not so, if you have a job that's generally speaking a level two wage, I don't see a lot of scrutiny on that. But level one wages, 100%. 100%, there's going to be a massive amount of scrutiny.
Thank you. Thank you for taking that up. And RK, thank you for your question. Very interesting. So now let's take up Jitendra. Hi, Jitendra. Thank you for joining us on YouTube. And Jitendra is asking, how do the immigration policies of countries like Canada and the United Kingdom compare to those of the United States, and what makes them more attractive to Indian immigrants?
Well, I am neither a Canadian nor a UK immigration lawyer, so I'm not an expert on them, although I am informed. Canada has recently had a massive change in their immigration policies. They have basically kind of shut the door on a lot of work visas because Canada immigrated about 1 million people a year for several years. There's only 35 million people in Canada. It was an enormous number of people that came in. And Trudeau has now lost his position as prime minister. He was kind of the leading force behind that. So I would suspect that Canadian immigration, while probably more flexible and slightly easier than the United States, is not as easy as what once was. The UK, on the other hand, is a terrible immigration system. Their system is very difficult. It is very hard to use. It requires a great deal of oversight by an employer, and it is designed to not have immigrants. I have a very dear friend who's a UK immigration lawyer, Nick Rollison, and I think he would tell you the same thing. England right now is as tough to immigrate to as any country in the world. Probably more so than most.
Thank you, Jitendra, once again, and thank you, Charles, for taking that up. Now, coming back to my questions, Charles, suppose an H1B employee is laid off and cannot secure a new job within the grace period. So, what can they do, if they want to remain in the United States legally?
Well, I think I kind of answered this 4 times already. File a visitor visa or file a student visa. Go get a master's degree. Go get a PhD. File that change of status. But do not wait to day 59. Really, file that early on in the process so that you can find out what's going on.
How long does it take to shift to maybe another status?
How long is a change of status taking? It's funny, Napasa, you put my phone number up here and people are calling my phone number and that's what's ringing right now. Let me just take a look at USCIS and the great thing about immigration, very few great things, but one of them is you can find the processing times from the Immigration Service. I'm going to go on their website right now and hopefully, if it ever lets me in, tell you how long a visitor visa change of status is taking from an H1B, for example. So right now, immigration is telling me the processing time is 3 months, which is about normal. That's about, sometimes it gets longer, but it gets less, but it's about 3 months. And during that time, you're fine. Now, when you file for a change of status to a visitor, that means you're going to be visiting. You have to explain, I've been working for all these years in the United States. I want to take a few months and drive around the country. I want to go to Yellowstone. I want to go to Disney World. I want to eat lobster in Maine. Here's my bank account that shows I have the money to do this. Here's my return ticket for 5.5 months from now. If you do that, you'll be approved. You don't do that, you're not going to be approved.
Okay. So thank you so much, Charles. And there you go, friends. Before you even hit your 60 days grace period, you have to be filing for your other option. And 90 days, that's what, 3 months is what, you have in hand. So I think you should not wait that long for sure. Thank you, Charles, once again. And yeah. So suppose a tech company sponsoring multiple H1B employees faces a compliance audit. now that audits are a real deal. A lot of it is happening and resulting in revocation for some visas as well. So what legal remedies do affected employees have, and how do they really safeguard their status?
Well, the first thing an employee who is affected by this to do is hire a lawyer, your own lawyer, not the lawyer representing the company. You need to go find your own lawyer, someone who's experienced in these issues. Two, you need to try to figure out what happened. Why is the company facing a problem with the compliance audit? What is going on there? Two, was your job affected? Was it you? Were you one of the people who were affected by this? If you were, frankly, immigration believes that you are complicit in it, that you know about it, and that you allowed it. And if that's the case, it's going to be really hard to get an H-1B visa in the future, which is why you don't work with tech companies that suck. You don't work with these marginal companies that are kind of skirting the law, that are just becoming job shops. You got to stay away from these companies. They are not there to help you. They're there to make money for their owners. So again, go see a lawyer right away. Maybe you can become a witness. If there really was abuse, you may be eligible for a T visa. These are visas for people that are victims of human trafficking. And we've done a couple of these for software engineers who basically were treated like human traffic persons. So again, talk to someone who knows what they're doing, who has experience with this, and from there move forward. But I would say every case is different. So there isn't really a general guideline other than get a lawyer.
Absolutely. It's always best to consult with an expert, and an immigration lawyer would be best. And folks, you can always contact Attorney Charles, and that you can do so. I think it's best to email Charles. So mail him at charles@immigration.net, and go visit www.immigration.net to get to know more about Attorney Charles
I
Carter.
answer all my emails. Yeah, email me. I answer all my emails. So
Yes,
there
he
you go.
does. And he's really prompt, very quick. So I'm sure you'll never be, disheartened with that. But if it is an emergency, definitely call him also on his number, and that is 404-949-8154. So, Charles, I also got a couple of case studies, or scenarios rather, and this first one is, about a visa denied after administrative processing. So, Ravi, who is a software developer from India, has his H-1B petition approved under consular processing. However, after months of administrative processing, 221G, his visa was ultimately denied with no clear reason. So, what are the possible reasons an H1B could be denied after administrative processing? First off.
Well, it depends. Has Ravi ever been in the country before? Does he have this student visa OPT issue? That's something we've seen come up a lot recently, and our good friend John Wasden has been litigating that like crazy, very successfully. First of all, the consulate's required to give you the ground, not the reason itself, but the ground. So within Section 212A of the Immigration Act are the grounds 1 through 10 for which you should be denied. Now, so you're gonna know a general category. Then once we know the general category, then we can figure out what the deal is. What is it? A 212A2, that is a criminal charge. Is it 212A3, which is a security ground? So it really, again, very factually specific case. Usually after a consult with somebody, I can figure out what the problem was. Then we have to determine whether or not that's fixable. Sometimes it's fixable. Sometimes it's not fixable. Did that person apply for a visa before? Did they overstay a prior visa? Again, a lot depends. Maybe it's the employer. Maybe there's something with the employer there, and they're sending the H-1B for revocation. Again, very specifically, we talk about the facts to our clients to see what if anything we can do.
Okay. And, maybe employers could support their employees also in such cases, extended administrative processing delays. What can employers do maybe for them?
Well, same thing. I mean, it's the same approach for a foreign national or the employer. Find out what happens going on. You can always appeal a visa denial to the visa office. If we believe there was an error, we can send an email to the visa office. These are the people that oversee the consulates and give legal advice to them. So if it's a legal issue and the consulate's wrong, we can get that corrected. It might take several months. We can get it corrected. If it's a factual issue, that's it. You're probably toast. Just depends, again, facts.
Okay. And that is very important. A lot of it, right? So, okay, about 221Gs, delays, how can applicants minimize the risk? Maybe you can give out a few tips to those watching.
That's a great question. If I had to answer that, I wouldn't be an immigration lawyer. I would be God because nobody seems to know. Uh, there's a lot of speculation that your religion makes a difference. If you're Muslim, you're almost always going to get a 221G, almost always, anywhere in the world.
Okay.
It could be you had a prior legal incident. It could be you had a prior visa application. There's an endless number of reasons. None of them appear to be legitimate. Virtually all 221Gs are resolved in favor of the applicant. But here's a lesson that we learned from 9/11. Nobody gets fired for saying no. You only get fired for saying yes. And here's what I mean. Everybody knows about 9/11 and the hijackers. People don't know about is March 11th, 2002. On March 11th, 2002, the Immigration Service approved Muhammad Atta's F1 visa extension.
Okay.
6 months after he murdered 2,000 people. People got fired over that. The lesson learned was deny, deny, deny. Only approve when you have clear belief and understanding that you should be approved. Thus, nobody gets fired for saying no. So there's never a downside to saying no. There's never a downside of you waiting.
Thank you so much. I mean, that is very important information. And thank you, Charles, once again.
You're
So
welcome.
I got another, yeah, I got another case study which I was just reading through, and this is about an H1B worker who was facing deportation due to late extension. So Sophia, another H1B worker, was relying on her employer to file her visa, but due to negligence of delay, the petition wasn't filed on time, causing Sophia to fall out of status,
All
and
right.
she's now at risk of remotation. So, what legal options does Sophia have if her visa extension is not filed on time?
I will tell
And
you how
if you
we've
could,
handled that when we've been hired in this situation. We file a retroactive extension, well, a nunc-pro-tunc extension, if the employer was at fault. Now, sometimes it could be something as simple as the FedEx didn't get delivered. I mean, that happens, which is why you never wait to the last week to file. You always file long before that. So you ask for nunc-pro-tunc relief. The simplest thing to do, honestly, is just to leave. Get on a plane, go, wait for the approval, come back. You've solved the problem. Overstaying by a day because there was an error or a week or a month is not going to get your visa denied. You're going to get the visa. Now, the other thing you can do is if it's nunc-pro-tunc, you got to pay premium processing. So you premium process a late filed nunc-pro-tunc relief. And if it's the employer's fault or the lawyer's fault, maybe it's the lawyer's fault. And that's the case. We usually get involved when a lawyer has screwed up. And then we just we file a bar complaint against the lawyer and we throw the lawyer under the bus. We win almost all of those getting reinstatement. We actually, last year, we reinstated somebody who had out of status for 2 years. We reinstated them because the lawyer had screwed up massively and just kept screwing up, like a series of screw ups. And we got them reinstated. So, yeah, it's possible to fix. But again, very fact specific.
it's always safe to leave, that means. And what about, if removal proceedings begin, what legal defenses or appeals are available, maybe?
Well, something depend in removal proceedings. If you've been inside the United States for less than 10 years, you essentially have no defense other than I'm afraid to go back home, which you're not really going to win from India almost all the time, or you can take voluntary departure. That's it. Because the immigration courts have no jurisdiction over visa adjudication. So the immigration judge can't fix a visa error.
Okay. Very interesting. I'm enjoying this conversation, Charles. Thank you so much. And I'll quickly say hi back again to RK, who's back with another question. We'll quickly take that up and, also address some other questions from our Facebook groups after that. So, RK, if the start if they start issuing more NTA for denied COS from F1 to H1B or H1B extension, what happens with the individual authorization while in immigration court?
Well, this is not an if. This is going to happen. It happened during the first Trump administration. It will happen now. The way it works, though, if a change of status is denied, it does not come with a notice to appear or an NTA. You have 30 days to appeal that, or to ask for reconsideration. So it's not automatic. If after a period of time you've lost the decision, you lost the H, you've lost the extension, and you are in removal proceedings, your defenses are limited because the judge can't really do anything about your visa status. So most of the time, for people like this, you're going to be taking voluntary departure and just leaving the United States. My suggestion, however, is that if you are at risk of being served with a notice to appear because you're out of status, then you probably should leave first. There is no work authorization that comes. There is no work authorization just for being in deportation proceedings. The work authorization in deportation proceedings comes from eligibility for cancellation of removal, that is more than 10 years in the United States, and a U.S. citizen spouse or child, or if you're applying for asylum. Those are the only two times you're going to get a work authorization in immigration court.
Okay. Thank you, Charles, for taking that up. And thank you, RK, once again for joining us. So now, Charles, we are going to take up a few questions from our Facebook group. So um, there we go. We have our first one. This is from Anand asking, my visa stamped for company A till 2028, but I left company and went back to India. In India, company B filed my H1B in the year 2026 while me being in India. Then do I need to go for stamping for company B? I heard if our H1B processing happens while being in India, then it has to be consular processing, only for which we have to go for interview. Is that true?
No. You have a valid H-1B stamp in your passport, and you have a valid I-797 for a different employer. You just travel on the old stamp and the new approval notice. You do not need a new visa.
Okay.
You're welcome to get one if you want to. You want to waste the money, but you're not required to.
Okay. That's good news for Anand then. All right. So next question is again on the screen. This is from Sagnik asking, my previous visa was F1. Have scheduled a Dropbox for H1B visa, first time stamping at Chennai for March 7th, that is today. Do I need to cancel and schedule OFC and interview? My hometown is in Kolkata. Can I schedule both OFC and interview in my hometown? And can I reschedule the appointments now, or do I need to wait till March 7th?
Today is March 7th.
Today is March
That
7th.
question is from 2 weeks ago, or we're in a time warp. I haven't figured out which one it is. I'm curious to know what he ended up doing, because clearly I would have just waited till the interview came and seen. But well, I guess we'll see.
Yes, we will. All right. So this is from Navya. Navya, this is also a couple of weeks back and saying, hi, I have a question related to document form Dropbox for H1B stamping. I'm working with consulting company. Can anyone please tell me if I should take EVL, that is employment verification letter from the consulting company with whom my H1B is filed, or the client that I'm working with? Thanks in advance.
We ask our clients to carry both.
Okay. Navya,
Because
that's both.
they're going to ask for it, so you might as well have it.
Okay. All right. Thank you, Charles. Now, this next one is please advise me on this situation. So, I entered USA on H1B and my employer didn't run payroll for nearly 3 months since I didn't have any job from the client side. Then, when I got job from the fourth month onwards, my payroll started running. Will I have any problem because of this during my H1B renewal or stamping? Thank you.
Yes. First of all, you're out of status. You're out of status if you don't get paid within 30 days. That's the law. So either ask your employer to reimburse you for that money, or I would file a complaint with the Department of Labor, Wage and Hour Division, and they will force that employer to pay you back. So yeah, that's a big problem. We see this all the time, Nikasa. It is against the law to do this. And
It's
until
illegal,
people
right? I mean, you
it's very
can't
illegal.
make somebody
Very
work
illegal.
for free. Yeah.
Very illegal. It doesn't
Thank
matter.
you.
You don't have a job. That's irrelevant. You were hired to come in. They let you come in. They are required to pay you within 30 days of your entry.
And America is so expensive. I don't know how did he even survive for the 3 months without pay. Goodness
I
me.
don't understand that.
Yeah. Anyway, so thank you so much, anonymous member. I really hope that you have figured out.
Yeah, me
And
too.
now let's go on to our next one, please. This is also another anonymous member asking for those on H1B who have purchased a home and car are planning a vacation to India, given the current situation, how are you preparing for potential challenges if, God forbid, anything unexpected happens? Okay.
I would suggest that people fill out and have a power of attorney with somebody that's in the United States, so that you have it notarized in the United States that gives somebody else a power of attorney over your things. We also have a power of attorney over children if you leave them here, and you don't give it to the person. But if you can't come back, at least somebody can dispose of your house and your property while you're gone in your name. So, I mean, you might want to consider power of attorney. We have those on our website. And you're welcome to use those for the state of Georgia. Every state's different. Make sure you have one for the state that you live in.
Okay. And once again, that's www.immigration.net. Go check it out. So, yes, let's go on to our next one. Control, if we can display
Same
the
question.
next one.
Same question. But there are some in
I
our
think it's
live
done.
here. There's a couple of great questions here in our live. One from Empire. Maybe you could put that up.
Yes, we should. So Empire is asking, do you expect an increase or decrease selection rate for this year's H1B for both regular and master's cap? And also, do you expect any change to the H1B or next year's fiscal year 2027?
Two great questions. I was wrong last year. I thought there would be a decrease last year in numbers. I think there's going to be a decrease this year. The Trump session is starting. That's the Trump recession is clearly starting. Job gains are rapidly shrinking. Hundreds of thousands of people have been laid off in the government, which means private sector will also follow. So I suspect that we will, and many contracts have been canceled. Many contracts have been canceled by Musk and his minions and Doge. So I would suspect there's going to be a decrease in the number of applicants and thus an increase in the selection rate for both regular and masters. As to the second question, we're going to see massive changes. We already know that they're going to publish a regulation here in the spring, maybe the summer, where they're going to change how the lottery is run, and they want to run the lottery based on salary. Really. The higher you get paid, the greater chance you have of getting picked. Now, is that legal? Does that follow the law? Probably not, but they're probably going to do it. I would also suspect that they mandate a minimum level 2 wage on H1Bs. This administration, there are a lot of people in the administration, not all of them, that hate H1Bs. Musk loves H1Bs because he's using hundreds of them at his companies, and he himself had one at one point. But a lot of people hate it, like Stephen Miller, who's really in charge of this stuff. So yes, we will see massive changes. And I also suspect that the lottery fee will go up dramatically next year, maybe several $1,000s.
Wow. I mean, already there is an increase this year, and again, more increase. I think it's going to get crazy. So, but all the
Yep.
funds that they're going to be accumulating with this. So great. All right, let's take up Nena's questions. This is what are the
That's a good
specific
question.
implications of turning 21 for children of H1B visa holders, particularly if their parent has not yet secured a green card? And what options are available to these young adults to maintain their legal status in the United States?
Well, they need to change their status as student. They can change the visitor too, but that's so temporary. Many of them probably going to be in university anyway. So I wouldn't wait till they were 21 to change their status, because they have to have one full year in their degree program to obtain OPT when they graduate. So if they wait till 21, they may already be in their fourth year. So I'd probably change them when they were 19 or 20 to a student visa. And again, if you become current, they're still going to get a green card through you. But this way they're protected and not waiting to the last minute to change to an F1. And then at that point, they're on the H1B hamster wheel as well, going through the process. Now, of course, depending on, how old they were when you filed the I-140 and how long it was pending, they may be able to recapture some time. That's why you never pay premium processing for I-140s, because you want it pending as long as possible, because it extends the age of your child past 21. So student visa holder is probably the only real option for most people, or to leave the United States.
Okay. Thank you so much, Charles, for taking that up. And Nana, I hope that you have gotten your answers. And if you have more questions, anyone out there, you can keep commenting. Also, I would say if you're resonating with whatever Charles has been giving us, very insightful, really, so far, so great. So do not forget to also subscribe to our channel. It is Immigration Talk Show in YouTube, and also check us out on LinkedIn, Facebook, X, Instagram. And yes, you can call us on this number, which is up there on the screen, 425-436-6335, and the access code is 988888. All right, so Charles, I got more questions actually, and this is another case study which I was reading. So, this H1B worker at risk due to employer fraud. So, Aman and Priya were working for a tech company and which is an IT firm, and later found to have misrepresented visa filings. So, USCIS launched an investigation, blacklisted the company, and now all employees are at risk of losing their status. So, what legal protections exist for H1B employees if their sponsoring employer is flagged for fraud?
None. There are no legal protections for H1B employees. Obviously, if they're terminated for any reason, it's 60 days. If they quit, it's a 60 days. So maybe you immediately begin looking for a job, looking for a school to go to, or change it to a visitor. Those are, and maybe you're experienced enough to be an O1 instead of an H1B. Maybe you're extraordinary, and we've been pretty successful in changing people from H1Bs to O1s. But as far as legal protections, not many. And if you are a witness, perhaps to the employer's abuse, there also may be a T visa. So again, it very fact specific. You want to get your own lawyer right away so you can figure out exactly how to navigate this problem.
Okay. Okay. And, what about this H1B worker? Can they transfer their visa to another employer if the company is under investigation, or they'll just have to be gone from the country?
Well, again, if you transfer, you should be fine unless the investigation involves you or your job. Now, if they're investigating the company for not having real jobs, yeah, they're going to question you on your new employer application because it's all in a database. Now, AI is tracking all this stuff. So, you change the point. Oh, you were with company X. We were investigating company X for not paying its employees. So they might send you a request for evidence on your new employer's application and say, hey, show us you actually got paid the whole entirety with your company. Don't ever throw your pay stubs away.
Okay. Okay. And, what about employees? What can they do to verify an employer's, or maybe how do they report this fraud? Maybe to protect themselves from this in this process.
So there's an agency in the government called the Department of Labor. And if you Google H1B Department of Labor, you will go right to their website and you can report worksite abuse. This includes not getting paid overtime. This includes not getting paid the salary required to be paid, or not getting paid at all. And they can get your money. They are your lawyers. They will get your money back for you.
Okay.
But
All
you will
right,
not get
thank you.
but you will not get visa protection.
Okay.
The Empire had a great follow-up question that I really, really want to answer.
Sure. Let's take it up. So how would that do you expect an increase or decrease? We've taken that. So how would that work? You can't compare a teacher's wage with a software engineer's wage, of course. And will it be top wage based on occupation, which makes a top paid teacher on the same level at a top paid engineer?
Well, Empire, you have hit the nail on the head. This is when you use you, it's not me making this up, right? This is Trump and his minions. They don't care. They literally are looking at the highest paid people, period, not by occupation, because there is no occupation within the H1B. So if there are 65,000 people getting paid over $150,000 a year, then nobody making less than that in any job will get an H1B. This is disastrous for nurses, doctors, accountants, teachers, every kind of profession has entry level people. And yet this, because they keep saying, well, H1B is for the best and the brightest, and it's not. It's never been for the best and the brightest. It's been for the most available worker. And this is the H1B, unfortunately, has been abused by a lot of employers, and as a result, whenever you abuse something like this, you're going to get a slap upside the head that will shake you to your shoes, and it's not going to be pretty. It's not, and
Right.
it's not just going to be IT. There's a lot of IT jobs that are not going to qualify. There's a lot of other jobs out there. Doctors. There's like 5,000 doctors on H1Bs. They all make more than IT guys. So that's 5,000 IT guys not getting it. There you go.
But I mean, great questions, Empire. Thank you so much. Very interesting questions. I'm glad folks out there can join us with their questions. They make this whole session more interesting. So I think with that, we've covered most of our questions, Charles. But before we leave, do you have anything more to add and wrap up and maybe give out tips to whoever is maybe getting into this fiscal year 2026 H1B lottery?
Remember, employer can only enter, one person at a time. You can have multiple employers enter you, but it doesn't make any difference because you're only going to get one shot at the lottery. So pray. I mean, it's truly a lottery. There's no way to enhance your odds. It's just the lottery. It's like going to the store and buying a lottery ticket. May the odds be ever in your favor, as the saying goes. Napas, it's been great being with you this week. Thank you for having me.
Thank you, Charles, for really joining us. I enjoyed this whole conversation and what a session. So I'm really looking forward to having you back. Maybe tell us whenever you get some time again, and it'll be great to have you back.
Love to have you. Have a good day.
You too, Charles. Thank you. Folks, don't forget to maybe contact Attorney Charles, and that you can do so by, email him. His email address is chuck@immigration.net, and go visit www.immigration.net. And also, you can call him up in case it's an emergency. You really need to have a word with him. 404 949 8154. But yes, his email address once again, ckuck, CKUCK, @immigration.net. Sorry earlier. So yes, thank you so much, folks, for joining us, and I'm sure you loved today's session. So do not forget to subscribe to our channel, hit that bell icon if you haven't already subscribed to us. Our handle is @immigration talk show. We are on YouTube, and you can also check us out. We are on LinkedIn, Facebook, X, Instagram, everywhere. Check us out and connect with us. You can also email me. My email address is nipa@staffingly.com, and call me or WhatsApp me on this number, 408-335-6444. Thank you once again for joining, and stay tuned on Immigration Talk Show because we got more awesome webinars lined up. So stay with us. Hello, everyone, and welcome back once again to Immigration Talk Show. And this is where we have another very important webinar lined up for you. And you're going to be very interested because we are going to discuss about the April 2025 Visa Bulletin and also about some of the common frequently asked questions on H1B today. So we have this very interesting webinar lined up with none other than our guest who's going to join us. But before we head on to today's discussion, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. With that said, and that in mind, friends, welcome once again to Immigration Talk Show. I'm going to be your host for today, and I am Napasa. So thank you for joining us. Our handle is at Immigration Talk Show. We are streaming live right now on YouTube. So don't forget to subscribe to us if you haven't as yet already. And also, hit that bell icon so that whenever we have discussions, you are notified and that you can also join us and you can do so by commenting. We are Immigration Talk Show. You can find us not only in YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. So check us out, connect with us, follow us, and yes, you can also join us on call, by the way, if you want to ask your questions yourself with the attorney who's going to join us, to the attorney who's going to join us today. And you can do so by dialing this number 425-436-6335, and the access code is 988888. So, yes, without further ado, please help me welcome our attorney, guest attorney for today, Prashanthi Reddy, who is very frequent on our channel. Thank you so much, Prashanthi, for making time today as well. I hope you're doing great.
I am. Hope you're doing well as well, Ms. Nipasa.
Thank you, Prashanthi. I am. Yes, thank you for asking. So H1B season is on, and I'm sure that it's busy for you and for, the law offices of Prashanthi Reddy. Would you like to tell us how's it going with you?
It is busy, but we're more busy when we actually have to file the H1s. So June 31st is when we are really busy. Registration, some companies, do the registration on their own. Some companies use an attorney, and the registration process is simpler than the regular H1B process. So but having said that, since you only have 2 weeks to file the registration, yeah, that does make us busy.
Yes. And I think last minutes are more busy, right? They come in with the late late
Correct.
filing.
Yes, there's always the last minute stragglers.
Yes, yes. Thank you, Prashanthi, for joining us today. I'm looking forward for today's discussion as we are going to discuss especially the frequently asked questions. And of course, the April 2025 visa bulletin is out. So maybe let's start with that. And yeah, I got this first question, Prashanthi, about the visa bulletin. If you can tell us about some of the significant changes which we see in the April 2025 visa bulletin as compared to the previous months, and how these changes will impact, the applicants across various visa categories, family or employment.
Yeah, so we've seen some good forward movement for EB3 India and a slight forward movement for EB2 India and some forward movement for EB1 India as well. So overall, we've seen some forward movement in this month, which is maybe a little surprising because we were not expecting this much forward movement uh, for EB. So we've always known EB3 is doing better than EB2. And EB1 is heavily backlogged, so it's going in that order. But let's just a quick snapshot of um, forward movement for April compared to March. So EB1 India has moved by 2 weeks. EB1 China, there's no change. EB1 rest of the world, there's no change. It's current anyway. EB2 India has moved by 1 month. Rest of the world has moved by 5 weeks. EB2 China has moved by 5 months, so that's a pretty significant forward movement for EB2 China. So unlike EB2 India, EB2 China is not as backlogged. EB3 India is moved by 2 months, so that's the maximum movement for any category this month. EB3 China has moved by 3 months, and EB3 rest of the world has also moved by 1 month. So the maximum movement is for EB2 China 5 months, and after that followed by EB3 India, which is 2 months, and EB3 China, which is 3 months. So the biggest news, of course, is retrogression for EB5. EB5 India has retrogressed by 2 years, and this is the unreserved category. EB5 China retrogressed by 2 years and 3 months, so more so than India, but we know China is EB5 category is used more by China than it is by India. But looks like India is catching up as well in the usage. EB5 rest of the world unreserved is current, and EB5 for rural high unemployment infrastructure, which is the set aside area, is current in all categories. So unreserved has moved by 2 years, 3 months for China, and 2 years moved back, retrogressed for India. So we see that the maximum retrogression for EB5 India and China, and we see forward movement in all categories for India. So 2 weeks for EB1, 1 month for EB2, and 2 months for EB3. So what can be done? And the other thing to keep in mind is also that they will be looking at the final action date table for employment-based and the dates for filing table for family-based. So if your date has passed the date that is mentioned in those tables, then you will be able to file your adjustment of status application. Just focusing on the employment-based cases, what should be done? If you're from India, obviously you should try. If you are EB2, you qualify for EB3 anyway, so you want to file for a new I-140, so that you will have an I-140 in EB3 as well. That way you will be able to take advantage of the forward movement in EB3 India. EB3 India is right now April 2013. And EB2 India is January 2013. So the same year, but EB3 has reached April, while India is EB2 is only in January. So they're 4 months apart. So if you want to file for an I-140 for to get an I-140 approved in EB3, and if you already have an approved I-140 in EB2, you can keep both, and then you can ask USCIS to use the I-140, which is the most current. EB1 India has moved up by 2 weeks, so if it's reached February 15, 2022, so if your priority date is that, then you can go ahead and file your adjustment of status. So if your dates are current, make sure you get your adjustment of status application prepared this month, then file it. Get your medicals prepared this month, and all your other documentation ready, and make sure you file it before the end of next month, because you don't know whether the cases will continue to be current or they will retrogress the following month. You will, of course, know that by about the 10th or the 15th of the following month, April, with reference to May. So you'll also have a better idea at that point. But I would say don't take the risk. Prepare everything, especially the medicals, and then file if you can for next month if you're current. Also, you have to keep in mind that you need to have birth certificates, and if you don't have birth certificates, get non-availability certificates from your country of origin, and also get secondary evidence such as birth affidavits, school leaving certificates, letter from your hospital, etc. These are the two most important documents: birth certificate and medicals that you would need to look into. The rest of the documents you might already have. So that's, yeah, on that, Nipasa, we can go to the next question.
Sure, absolutely. Thank you so much, Prashanti, for giving us the highlights of the 2026 April visa bulletin. So, all the best to folks. I know the wait has been long. For some of you all, congratulations. It's finally current now, and you can apply for your adjustment of status. But all in all, I think we still have to be patient, especially for these countries who have been in the list for quite some time now, especially India, China, Philippines, Mexico. So yes, talking about the visa bulletin again, Prashanti, there is retrogression also that we are seeing. So if you could tell us what could be some of the reasons behind the retrogression which we observe in the EB5 category, the unreserved category for China and India.
Well, any retrogression is because of high demand. And, as, the EB2 and EB3 dates get more and more backlogged, especially for India and China, as we are seeing that it's 2013, you will see that there'll be more and more people trying to file or qualify for EB5 investor visa. And so that's what's pretty much happening. But unfortunately now I mean, it still moved from 2022 to 2019, but it's still better than 2013. So you will definitely see high demand for EB5, even though the amount, I mean, they've gone increasing the amount of investment. You will still continue to see high demand simply because the other dates are not categories are so backlogged.
Right, right. Thank you so much, Prashanti. And I would just like to say hi to Unnati. Thank you for joining us, Unnati. We will address your questions, but stay with us, all right? And today we are discussing about H1B registration and the April visa bulletin. So we are going to discuss about some of the frequently asked questions for H1B, and stay with us. If you have any questions also, please feel free to join us to ask your question yourself on this phone number that is displayed on the screen. And the number is 425-436-6335, and the access code is 988888. But also, otherwise, you can comment and we will take them up. So, Prashanti, my next question to you would be if, for folks out there, who want to be able to interpret the final action dates and the dates for filing in the April 2025 visa bulletin, what strategies should they consider if their priority dates are approaching and if they have become current now? What should they do next?
Like I was saying previously, I mean, if they're approaching, if they're current, I mean, it's a no-brainer. You should go ahead and prepare your documents now and, submit your documents. If they're approaching, then I would say might be a good idea to keep documents ready. Remember that you can no longer file your 485 without medicals. They will be returned to you. But um, uh, you can, get your medicals done. Of course, medicals may become invalid after a year, so make sure you don't do it too much in advance. But you can definitely get your birth certificate in order because especially if you don't have a birth certificate, or if first of all, if you don't have a birth certificate, then you'll have to get a non-availability certificate from the district or from your hometown where you were born. And that non-availability certificate will have to say that your birth was never registered, or there's no record of registration of your birth in their database. And that usually takes some time. And in addition to that, you'll have to get your secondary evidence. That is, get either a new birth certificate made, like a new, but which is registered presently. In which case, if you have a birth certificate that is presently registered, then in lieu of the non-availability certificate, you can also do a new birth certificate. But if you get that, you'll anyway have to get secondary evidence. That is, letter from the priest, letter from the hospital where you were born, school leaving certificate, affidavits from people who know of your birth, or who were present at your birth, at the time of your birth. So all this takes time. So my suggestion is get everything ready in time. If you are using an attorney, which I suggest you do, contact your attorney ahead of time because they might be busy as well, and inform them that you're expecting your dates to become current or they've already become current so that they can start their preparation work ahead of time. And they'll give you a list of documents that's needed so that you can get those documents ready and see if you have all the documents ready ahead of time as well.
Absolutely, friends. And you can also contact Attorney Prashanti Reddy for the same. Maybe send her an email or give her a call on her number. And her number, um, and her contact details as well is here 212-354-1010. And you can also email prashanti at reddyesq.com or go visit www.reddyesq.com to get to know more about Attorney Prashanti Reddy. And so, Prashanti, I have another question about the visa bulletin. And if you could, of course, the current trends, and if there are any forward movement, that is in the oversubscribed categories as well, since you've already mentioned about some of the movements, 2 weeks, 2 months, or, well, even the significant backlogs that we see. So, how can they plan ahead, in terms of immigration strategies for applicants out there?
Well, then you should move to the categories which are not as oversubscribed. Depending on which country you're from, for India, that would be EB5 or that would be EB1. And as I said, if you have cases in EB2, you automatically qualify for EB3 as well. So you should file for the uh, filing from downgrading from EB2 to EB3. Instead of filing an amendment, my suggestion is to file a new I-140. That way, you have two I-140s, one for EB3 and one for EB2, and you can toggle between the both of them depending on what the priority dates look like, because we see that sometimes EB3 is backlogged and sometimes we see EB2 is backlogged. Uh, so that keeps changing. The reason now why EB2 is more backlogged than EB3 is because a lot of people who are filing are people who have come here on an F1 and have done their master's degree here. So most of them have a master's degree, and they have, the job requires a master's degree, and that's why a lot of people file in EB2. But it might make more sense now if you're filing a new perm, even though you qualify for EB2, maybe it might make sense to qualify to file an EB3 or maybe file for, as I said, two I-140s so that you have both. But remember, if you file your perm in EB3, then you don't qualify for EB2. But if you file in EB2, then you automatically would qualify for EB3 as well. Because the requirements are always lesser for EB3 and more for EB2. So while you can go up, you cannot go down, right? So try to toggle your applications between the two and EB3 and EB2. Also, see if you qualify for EB1. There's no purpose in doing an EB2 national interest waiver. A lot of people try to do that because that might be the easiest one to get, but the EB2 national interest waiver is advantageous only if you don't have an employer or if your employer is not willing to sponsor your green card. Then you need to check and see if you qualify for an EB2 in IW, but otherwise it makes more sense to do an EB1. EB1 could be, you could do it if you are extraordinary ability in the arts, sciences, business, etc., STEM. But remember, not many people qualify. It's obviously only for the top people who have an extraordinary ability in that particular category. If you're a regular software developer, then you don't qualify. You have to be an extraordinary person within your field, having received awards, memberships, being judged other people or done research. If you could also do EB1 researcher category if you're a researcher, if you've had several publications and if you have patents on your name, etc., etc., then you can definitely look into the EB1 extraordinary ability category. The other EB1 that you can look into is the multinational executive. So if you have worked as a multinational, as an executive for your company abroad, and if they have a company, qualifying company in the US that is either a subsidiary or a branch or an associate of their company abroad, and if you're going to be working for the same in the same position of an executive or a manager, then you could possibly look at the EB1 multinational executive category. So a lot of people on an L1A would qualify for the EB1 multinational executive. While the EB1 is backlog 2022, but it's still better than the EB2 and EB3, which is 2013. So this is what I would do. Try to see if you qualify under any of the other categories and file your application in those categories, or at least file under EB3 if you have an EB2, because you would definitely qualify for EB3.
Right. So, friends, H1B is not just your only option. And to know, which other option do you have, I think it's always best to consult with an expert, and attorney would be best for you. And why not contact attorney Prashanthi Reddy? Her details are scrolling on the screen already. Note it down and give her a call or send her a mail. And I think at this moment, Prashanti, I would like to take up Abdul's question, since I think it is urgent. So he's saying, I just received RFEs on my H1B petition for fiscal year 2025. Please, what are my chances of my case being approved after responding to the RFEs?
It depends on the RFE. It is not it is not surprising to get an RFE, so there's no need to panic. RFEs, you can get it for various reasons. If you can share more information about what the RFE is about, maybe we can give you a more in-depth analysis. But really, if you've maintained your status and you're able to respond to all what is being asked in the RFE, then you should not have a problem getting it approved.
Mhm. Okay. It'll of course depend on what the RFEs are about as well. So maybe Abdul, you can tell us more details if you can now in the show itself. Otherwise, it's best if you can email prashanti at readyesq.com. Or you can even email me and I could direct it to attorney. And my email address is nipa@staffingly.com. Okay, so we have Ravinder also joining us. Ma'am, how to apply for H1B visa? Now, this is a very vast question, but Prashanti, if you want to quickly maybe address to this as well.
Uh, well, you have to have an employer that's willing to, that has given you a job and that's willing to sponsor you. And the job should be a specialty occupation. Specialty occupation means the job should require industry-wide a bachelor's degree in a specific field. Yeah, then you have to apply for the registration, because if you've never applied for a H1 before, it comes under new cap petition. The registration is opening up, and we're going to be talking about the registration soon. It's already opened up on March 7th, closing on the 24th. So you have to apply for a registration. If it gets picked, then if your number gets picked in the lottery, if your name gets picked in the lottery, then you can apply for the H1B, and you'd have to do that within 90 days.
There you go. Ravinder, you've got it. I hope you've noted it down, but even if not, you can watch this again and take your notes down. So thank you for joining us. And why don't you call us on this number to ask your questions yourself. And the number is 425-436-6335, and the access code is 988888. All right. So this next one is from your channel, Prashanti, and this is from Sriva asking, based on April visa bulletin, when can PD January 2014 be current on EB3 or EB2 for India? Thank you.
I wish I had a looking glass which would tell me what the future looked like, but unfortunately I don't. So your guess is as good as mine. If they're working on 2013 April, then for them to move that many months, I think it's going to take time unless something happens and we see rapid forward movement. I think we will see a slow forward movement um, of a few months at a time, and there may be some months that you will not see any forward movement. So it may not happen. It may not even happen this year. So wait and see.
Right. And Sriva, so true. I think we are all wishing that we could really see what the future would look like and wish we could really tell you the exact wait time and everything. But I think we'll just have to be lucky on the same side now. And she's asking another question. Can there be site visit for people on green card EAD? Have you seen any?
Not really. Haven't seen site visits for GCEAD. But having said that, if you filed a 485 and if your 485 is not for future employment and you're presently working for that company, you should, make sure that you have an employer always attached to your, 485 application. You could be on an EAD, and you can work for more than one company on an EAD, but you should work for the company that's petitioned your 485. If you're not, then do an AC-21, change the employer if the job is similar, and then can work for that new employer after doing the AC-21. So make sure you're always maintaining your status on that 485. It's possible that the 485 could be for a future job offer, but if you're not working for that company after getting the EAD, then sometimes, especially if there's an interview or some stage of that at the 485, they might ask why you're actually not working for the employer that petitioned you, even though you have an EAD to work for them. So you'd have to have a proper reasoning behind that. But usually, no, there are no site visits as they are for a H1, as they're as these are the only requirements that have to be fulfilled. There's no requirements, H1 requirements or similar requirements to H1 that have to be fulfilled.
Okay. Okay, Sriva, thank you for joining us with your question, and I hope that you've gotten your answers. And Ravinder, by the way, says, okay, ma'am, thank you. So thank you, Ravinder, also, and all the best. Seems like you are going to apply this time for your H1B visa. So I hope you make it through the lottery. And Prashanti, let's get to some of the questions, which would be some frequently asked questions on H1B registrations. So, this first one that I want to ask is, on what website or platform will USCIS host the electronic H1B registration process?
Well, USCIS, okay, let me first start with a little bit a background on H1B registration. As you know, there's a cap on the H1Bs, so we have 65,000 for bachelor's degree holders, and 20,000 for masters, US masters degree holders. So there's a total, that's the total H1B cap. And since the cap gets filled very quickly, they've come up with, it's always up oversubscribed really. So they've come up with a process whereby if they receive more applications, then they can hold a lottery. So they have a lottery system, and the lottery system, the registration to enter into the lottery has opened on March 7th and will close on the 24th. The results of the lottery will be known on the 31st of March, and then you'll be able to file your H1 from April 1st if it gets picked. This year, the lottery, as the same as last year, is beneficiary centric, meaning that based on your passport, you'll get only one entry into the lottery, even if you do 10 registrations or more than one registration. Also, the fee has increased this year to $215. So you see a 200% increase in the fees this year. And also, as of last year, we have new organizational accounts, which have the ability to do many more things when compared to the previous registration periods, so that our organizational accounts allow multiple people to log in at the same time. They have a way of checking duplicates. As you know, you cannot file a duplicate registration for the same person. If you do, then all the registrations become invalid. They allow you to populate certain information on the form. So it's pretty cool, the new organizational registration system. But anyway, to answer your question, you have to go to the My USCIS online portal to and open an organizational account to be able to register for your lottery this year. So you have to first log in to your account. If you're doing it for the first time, make sure that you open the account, register the account first, and then log into it. And remember to use the same email ID that you used to open the account to log in when you're logging into your account. And there's a lot of information on how to create a USCIS online account, on the USCIS portal.
There you go. Thank you so much, Prashanti, for telling us about the H1B registration process and some of the latest updates as well. And we have Ravinder, who is back again with another question, and let's quickly take it up. He's asking, ma'am, by profession, I am a teacher from last 5 to 6 months. I don't have any other experience in teaching. Can I apply for H1B?
It depends on the job that you're getting. If you're getting a job as a teacher, and if a teaching job requires a license in that particular state, then you need to get the license. You have to fulfill the requirements.
Yes.
You have to have a bachelor's degree in education or a related field. Depending on what, go to DICE, go to Monster, see what educational requirements are there for a teacher in the US. Also, if it's available, go to the Department of Labor website, the Occupational Outlook Handbook, and see what they say about teachers there, and see what the educational requirements are. If the educational requirement is a bachelor's in education, then obviously maybe you would need that. Or if it's a bachelor's degree in the specific uh, subject that you're teaching, then if you have that, then you might be good. But look into the licensing requirement as well.
Right. Thank you, Prashanti, for taking that up. And Ravinder, thank you for participating with your
So
question.
as far as I
Yeah,
know, public schools might require a license, maybe private schools don't. So again, you need to look into it depending on which state that you're working in.
absolutely. And Ravinder, why not collect more experience, maybe? But if there is a job waiting for you in the United States, then of course, Ravinder is also adding, saying that he's a double MSc and a B.Ed. So that adds.
Yeah, if he has a bachelor's in education, yeah, he might qualify for a teacher. But again, look at the requirements for the particular state where you're going to work and see if there's a license required.
Right. So all the best, Ravinder. And yeah, let's go on to our next question, Prashanti. And if you can tell us if, can a petitioner or an employer or a registrant use the same email for two different My USCIS account types?
No, you have to have a unique email address. So you can, being one company, you can of course, um, have two different accounts, because maybe, I don't know, for whatever reason, maybe there's one account that you want to use. One branch is using, one group is using one account, and the other group wants to use another account, but make sure that there are no duplicates, because if you have two separate accounts, there's no way of checking duplicates unless you do that on your own.
Mhm.
But if you want to open two separate accounts, then you will have to use a different email address for the two different accounts, because each account has to have its own email address. If you try to use the same email address and try to open another account, it won't let you do that. So make sure, and also each account has to have their own designated company user as the administrator. So that there has to be a different person administering each account, and there has to be two different emails used for each account.
Okay. Very interesting. Thank you so much, Prashanti, for taking that up. And we got another question from our audience, and this is from your channel actually. And this is from Manjot Singh asking, hello, ma'am. My name is Manjot Singh. I'm from India. My visa category is F4. My PD is 7th of April 2007 from India. How much time for welcome letter?
Again, we cannot really say how long it's going to take. He says that visa category is, yeah, F4. Yeah, we can't say how long it'll
Yeah.
take. Very difficult. F4 is the most backlogged category. It could take several years. I need to look at the visa bulletin to see what F4 is right now. I don't remember, but it hasn't reached 2007, and it might take some time before it does.
Okay. All right. Control, if you want to display also, like if you can display the April visa bulletin, we can just quickly check it out.
Yeah,
Uh,
make sure you display it for 2025,
F4
April.
category. Let's go to the family based. Scroll down, there'll be a table.
This is 2024. This is 2024.
Okay.
Yeah, there you go. There you go.
F4.
So F4 is,
Could you zoom in a bit?
here it is. It's 2000. Yeah. For India, it's 2006.
Hmm.
Is this the final action date or the dates for filing?
Final action.
Final action date. And can we see the dates for filing?
There. Yeah. F4. Please zoom in a little bit. Control.
Yeah,
2006. So
one
almost the
minute, ma'am. I'm
same.
just zooming in.
It's 2006.
Yes, ma'am. This is it.
It's 2006 for pretty much
Yeah.
both. And his is 2007. So it's about a year away, but doesn't mean that, every month there is a movement in the cases. Sometimes it moves for 2, 3 months. Sometimes it only moves for a week.
Mhm.
We haven't seen any much movement in the F4 category in the last few months. So I don't think it'll definitely take more than a year again, unless some event happens where the numbers are not being used or something like that happens, and suddenly you see a forward movement.
Right. Right now, F4 is 1st October 2006, and which is current. Thank you, Manjot Singh. But it's really hard to predict, how long will you have to wait for your welcome letter.
Definitely more than a year.
Yeah,
Yeah, definitely more than a year, maybe a few years, unless
really
something
happy.
happens or there's some new law that is passed, etc.
Yeah. But all the best. Thank you, Manjot Singh, for joining us. And yeah, let's go on to our next question. Prashanti, if you could also tell us, if a company has multiple entities, maybe, for example, subsidiary, affiliate, and parent. So can each entity submit a registration if they have a federal employer identification number, FEIN?
Yes, they're allowed to. Each organization is a separate organization, so they can definitely submit their own registrations. But you have to remember that if they submit the um, registration for the same beneficiary, it could be considered to be collusion. I'm not saying that they can't, but as long as there is a legitimate business need for by each of the petitioners, and there is a separate and real job opportunity, meaning there's an independent job opportunity that each company has, and it's not for the same job, then they can definitely submit also a registration for the same beneficiary as well. They have to show that there's, of course, an independent, legitimate business need. Otherwise, USCIS might, they will definitely put it into the lottery, but even after approval, or maybe they might send an intent to revoke or intent to deny if there is an RFE, if they find out that they're related entities and it's the same beneficiary.
Okay.
But USCIS has recently indicated that um, multiple entities or employees may register um, or may designate one user to act as a signatory for multiple entities,
Mhm.
but a separate email address would be needed uh, for that administrator in the MyUSCIS account. So you can use the same person,
Mhm.
but you'll have to use a different email address for that person
Okay.
if you want them there to be an administrator in all the accounts.
Okay. So different emails.
Correct.
Thank you, Prashanti. Thank you. And so says Manjot Singh. He says, "Thank you, ma'am." And we should quickly take up Mook TV's question as well. How to find employees once created account? So
How to find
I think
employees?
so. The employee had once created an account and how to find that account. How to find
Oh, you don't know. Can you please elaborate on your question?
Yes, Mook TV, we would like to know what exactly do you really want to know. But thank you for participating. Looking forward for more clarification on your question. We have Venkata now, again on your channel, Prashanti. And Venkata is asking, how many H1B cap registrations will be applied for fiscal year 2026? Any guess?
Maybe about 100 and something, 100,000 or 120,000. Because last year and the years before we've seen around that number. Last year there were two lotteries, and the reason that even though they're only 85,000, they choose about 100,000 plus is because they expect that some people who get picked in the lottery will not ultimately file their H1, or it could be that the H1 will get denied. So that's why they usually pick more registrations than are numbers available.
But we never know since there is quite a hike in the fee. So let's see what happens. But yes, friends, I would say stay with us, subscribe to us. We'll be the first one to let you know, and you can do so by subscribing to our channel. Our handle is Immigration Talk Show. Thank you, Venkata, for your question. Now, we should also address some of our questions from our Facebook group. So, if control, you can display them also. And meanwhile, Prashanti, if you could also take up another frequently asked question, which is, what information is required for the electronic registration process?
Yeah, for the electronic registration process, it's some basic information needed. You need the name of the company's organization, the legal name, the doing business's name, also the FEIN number or the Federal Employer Identification Number, the office mailing address, uh, and the name, the last name, first name, middle name of the contact at the office, and their phone number as well of the authorized signatory, the contact information, the name, phone number, email address of the authorized signatory. For the beneficiary, you need their name, gender, date of birth. If they're master's cap, then make sure that they actually have a master's degree that um, that fulfills the requirement of a master's cap. Not any master's degree will fulfill it. It has to be a non-profit public organization. Um, you need the beneficiary's country of birth, their country of citizenship, their passport or travel document number, and also very, very important, there are no exceptions to this. The passport must be valid at the time of the H1B registration. And also, please note if you've done the registration before for a beneficiary, the system will not allow you to reuse that information. You'll have to enter all the information again. So it's important that you have all this information handy before you start the application. Remember that the application will time out in 15 minutes
Okay.
if you don't enter the information, but you should be able to save the information so that you can come back to it later. Um, and also, you have to make sure that the passport that you use is the same passport listed in the H1B petition. But at times, USCIS may allow a different passport to be used when you're filing the H1B petition under some permitted limited circumstances, such as if there's a change in the legal name due to a marriage, if there's a change in the gender, change in the passport number because, or the expiration date because a new passport was obtained, or if the passport was lost and there's a, or stolen and there's a replacement passport obtained. So you have to show all that to show why you're using a new passport, and then they might allow a new passport to be used.
Okay, okay. So things to keep in mind, and I hope that folks out there are, taking notes. And also about the information, what about the offered position? Does it need to be also provided as part of the electronic H1B registration process?
No, you don't have to provide the job title in the registration process, but it might make sense to figure out what your job title is and what the minimum job requirements are, and to see if the beneficiary qualifies for that position, and to see if your business requires such a position. Because once you do the registration, and if it gets picked, then if you are not able to file the H1, it might be a frivolous registration, and USCIS might come after you for filing a frivolous registration. So, in order to avoid that, you need to look into any questions of approvability of the H1B petition if the registration is picked. And so, going through the minimum job requirements and the job title might be a good thing to do.
Okay. Thank you, Prashanti, for addressing that. And Venkata also says thank you. Thank you, Venkata. And now, Control, if you can also display some of our Facebook group questions that we have. Let's start off with this first one, which is from an anonymous participant. So, Prashanti, hi. Did someone get an RFE recently from their H1B renewal visa interview? And trying to understand how long uh, the whole process takes for getting the visa stamp after the initial RFE.
So, it's not called an RFE, it's called administrative processing.
Okay.
So, usually they don't give you the visa right away. They return your passport and put you into administrative processing, where they cross check whether the job is available, whether the employer still has the job. They contact the employer. If there's a client involved in a consulting scenario, they contact the client to see if that job is still offered. And if they get a favorable feedback, then they will, send you a notification asking you to come back
Mhm,
or send your passport for stamping.
mhm.
Administrative processing can take from a few months, and sometimes, in the worst case scenario, it even takes a few years. I've seen administrative processing cases pending for, 1 year, 2 years as well. But usually, it shouldn't take more than 6 months to a year.
Okay. Thank you. Thank you, anonymous participant, for your question. And let's go on to our next one. So, hello everyone. I had my H1B visa interview last year in June. After the interview, they requested me to submit a few documents in soft copy. It has now been almost 9 months and I haven't received any response. Could someone guide me on what should I do next? I applied from Islamabad, Pakistan. Thanks.
So, one thing to remember is that there might be a travel ban very soon. That is implemented by the Trump administration, and they might include Pakistan as part of that travel ban. If that happens, then even if you have a visa, you will not be able to
Travel.
travel to the U.S. Or they might, so from what has been informed to us, that there are several categories to these travel bans. There are red countries, yellow country, orange countries. So depending on the color that they have given that particular country, they're expecting Pakistan to be red, but if it isn't, if it's orange or yellow, then there might be extreme vetting on the visa process, and that and already there is extreme vetting, especially for some countries, and that could be a reason why it's taking longer, or it could just be that they're following their regular administrative processing time and they're trying to find out whether the job exists or not, and they've contacted your employer. So you have to call your employer or connect with your employer to see if they have received any communication from the Department of State with reference to your visa.
Okay.
And as I said, this they might be waiting for information and doing further investigation. Once they have that, then they will get back to you. It shouldn't take more than a year, but sometimes, as I said, it can take longer.
Right, right. Well, about the travel ban, what if there are folks already from Pakistan in United States? Are they also going to face any sort of issues or problems, Prashanti?
If they're already in the US, then there's no travel ban. But if they travel and leave the country, then they will not be allowed back, depending on
Okay,
what the
verdict.
final travel bans is. Yeah.
Okay, thank you, anonymous participant.
And this could be from other countries as well. Even last year they imposed a travel ban,
Hmm.
uh, but I don't think Pakistan was part of it. But it was imposed for some other Muslim countries, Afghanistan, Iran, and some other countries as well, Syria, Libya, etc.
Hmm.
So we have to wait and see which countries are included in the travel ban this time.
Right, right. So remember the colors as well: red, yellow, orange, and see which country you're from. Thank you so much. And Control, if you can also display maybe the country list in a while, that'll be nice. Moving on to our
At least the tentative. So we don't have an actual country list, but this is the
tentative.
tentative one that the newspapers have reported based on what the information they have received from, reliable
Mhm.
sources. Just something to keep in mind.
Right, right, Prashadi. Thank you, thank you. And this next question is: my first H1B stamping was outside India. I am within 12 months of my last H1B visa expiry. I never had an H1B stamping done in India. Am I eligible for Dropbox in India?
Yes, and as you have rightly pointed out, the visa interview waiver has been changed from, I believe, 48 months to 12 months. And they did this without any notice and comment period. They did this just suddenly, just by notifying. I mean, a lot of people just missed it because it was just on their
Hmm.
website. They didn't even publish it in any news outlet or anything like that. So it was just on their individual websites.
Hmm.
So a lot of people were really um, surprised to see that they were called in for an interview after being
Hmm.
um qualifying for a Dropbox. But the question here is, I never had my am I eligible? You are, but remember, it's still discretionary, even if it's within 12 months. They can still call you in for an interview. The visa interview waiver is a discretionary process, and they might use that discretion now more strictly. They've always used it liberally and they've allowed for Dropbox, but now maybe they'll move away from that
Right.
because there is more vetting under the Trump administration, and he said, as per his executive order, that there should be more vetting, extreme vetting for visa applicants.
Right, right. So, thank you, Prashanti, for taking this up. And we also have another question. So, let's address that as well. This is: please advise me on this situation. So, I entered US on new H1B, and my employer didn't run payroll for nearly 3 months since I didn't have any job from the client side. Then, when I got job from the fourth month onwards, my payroll started running. Will I have any problem because of this during my H1B renewal or stamping? Thank you.
Yes, even if you didn't have a social security number and they had to delay the payroll until you got a social security number, they should be paying you back wages from the time that you
Joined.
entered the country and joined the company. So you will definitely have issues if they find out. And now, as per the new H1B regulations, you have to submit upfront documents to show status.
Mhm.
And status means that they might require you to show status for the entire period of the H1. And if that is the case, they'll ask for pay stubs from, all the months. So it depends on, of course, when you're filing for your renewal and what information they ask. And also the W-2 will show a lower amount.
Mhm.
So yeah, all in all, it is problematic. You should try and resolve that with your employer.
Absolutely. And I don't think it's fair or even acceptable when they don't pay you. So, yes, I think you should do more research, Mr. Or Miss Anonymous Member. Thank you for your question. But thank you, Prashanti, also for taking this up. Now, I'd like to address this one from the LinkedIn user asking if there's a promotion and no change in job duties during perm process, does it require to be refiled?
Well, during the perm, yes, because when you're filing the I-140, you'd have to show the same job position. If it's after the approval of the I-140 and 6 months of the 485 being filed, then of course there is a lot of leeway there to change the job if as long as it's the same or similar job, but that leeway doesn't exist before the approval or filing of the I-140. So you pretty much have to file then a new perm if there is a change in the uh, job title
Mhm.
as well, because the wage might change.
Okay, okay. Well, thank you so much, Prashanti, for addressing this as well. And quickly, I'd like you to also let's address Unnati's question since we missed it earlier. Sorry, Unnati, for keeping you waiting so long. Unnati is saying, I just registered for the H1B lottery this year, but I keep hearing about how competitive it is. Realistically, what are my chances of getting selected? And if I don't get picked, what are my options to stay in the United States legally?
Um, well, um, the chances of getting picked traditionally for over the last few years has been about 30%, not including that 1 year, the 2024 fiscal year when there were so many duplicate registrations filed. But in general, it's about 30%, 25 to 30%, and we're expecting it to be the same this year, even though people are saying that there might be less registrations this year because the fee has gone up. Let's wait and see. But there's still a demand in the industry, and this demand is genuine. It is, we're not considering those frivolous registrations that people are filing, and there's a lot of fraudulent registrations people are filing by just taking money. Uh, um, so I don't know, maybe there will be less filings this year because there's an increase in the fee. We have to wait and see. But in general, over the years, we've seen that the pick rate has been about 25 to 30%. That means about, there's been about 300,000 to 400,000 cases filed.
Okay, thank you. Thank you for taking that up for Unnati. And now let's take up Rekha's question. I am on an F1 visa with OPT expiring in June. If I get picked in the H1B lottery, how do I bridge the gap until my H1B starts in October? Will cap automatically apply, or do I need to take a few extra steps?
Cap actually automatically applies,
Okay.
and you don't have to worry about October because, as per the new H1B regulations, your cap gap extends until the next year of April. So even if your H1 doesn't get approved by October for some reason, as long as you're filing a change of status, of course, then your cap gap continues to be in place until the H1 gets approved, until next April at least.
Thank you, Prashanti, for patiently addressing all our viewers' questions. And I think with that, we've covered each and everyone. So, thank you everyone for joining us with your questions. I wish we had more time because there are so many frequently asked questions, and I think Prashanti will have to save some of the questions for the coming week or so. And I hope that you will join us again
Yes.
since it's the H1B season. There's so much to discuss, and there's always less. I think the more we have, the lesser it is. So. Yes, with that said, thank you, Prashanti, for joining us today. And if you have any end notes before you leave us today, what would you like to say?
Um, I think we should discuss H1B regulations, H1B registrations, and H1s, since there seems to be so much interest. Uh, have another show on it and continue with we have a lot of questions that have remained unanswered. So we'll be happy to answer that in the next show. And in the meantime, please be aware of the dates. We only have this week and then the following week, because even though the registration period closes on the 24th, which is Monday, you can't consider that as a full day because it closes at 12 noon EST. Please keep that in mind. So I think you have to file your registration either this week or next week. And then you have the weekend coming as well.
Yes.
So you lose the weekend. So it's not really, you only have, I would say, 5 working days other than this week. So that's counting today, Wednesday, Thursday, Friday, 8 working days remaining to file your registration, which is not a lot of time.
Well, when you put it like that, Prashanti, it gets scarier. But thank you so much for the heads up and all the best, friends. Register quickly. Don't wait for the last moment, and especially not for the 24th of March, okay? Try to do it before that. And yeah, all the best.
Also, I just wanted to point out that if you wait until last moment and if there's some issue with your registration, it cannot be fixed. If it gets denied due to some issue, and you do it, it gets denied before the registration window closes, no problem. You can just refile the registration again.
Mhm.
You won't be able to do that if you're filing it in the last minute and the registration gets denied for some reason. Maybe the payment didn't go through, or maybe you didn't do something correctly, and it gets denied after the registration window closes, then you're in trouble. You have to wait for next year.
Yes. Thank you, Prashanti. Thank you for those very important points to keep in mind. And don't wait for the last moment. Once again, I would like to say. So, thank you, Prashanti, for joining us. And we will continue this discussion in the coming week for sure. So, stay tuned, friends. Watch out for Immigration Talk Show. Subscribe to our handle and also hit the bell icon so that whenever we have discussions, you are notified and that you can join us. So thank you, Prashanti, once again. Have a great day ahead. See you soon.
Thank you.
And
Take
yeah,
care.
you too. Folks, you can also contact Attorney Prashanti Reddy, and maybe you want to speak with her regarding your case. You can call her on her number 212-354-1010, and you can also email Attorney Prashanti Reddy at prashanti@reddyesq.com, and go visit www.reddyesq.com to get to know more about the law offices of Prashanti Reddy. Once again, thank you. And if you want to email me also, you can email me at neepatstaffingly.com and call me or WhatsApp me on my number with regard to your questions that you have. It's best to leave me a WhatsApp message, so that I can check them out and also forward them accordingly. So my number is 408 335 6444. Thank you once again and subscribe to Immigration Talk Show. Check us out not just on YouTube, but also on LinkedIn, Facebook, X, and Instagram, and stay connected. Bye for now, but stay tuned because we have a lot more coming on Immigration Talk Show. Hello and welcome back, everyone, to Immigration Talk Show. I'm Napasa and I'm going to be your host for this session. Thank you so much for joining us here once again. And friends, this is Immigration Talk Show. We have a very interesting webinar lined up. And before we have our guest for today's discussion, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, welcome once again to this very important session, I would say, because it's going to be on a very interesting topic, what we are all wondering and reading a lot about, especially because it's the season. So, what is the impact of new H1B regulations and FDNS site visits? And of course, we are going to also discuss about the April 2025 visa bulletin, which is already out. So it came out yesterday, and we are going to discuss some highlights with our guest. So, yes, let me introduce you to none other than Uma Mantravadi. How are you doing, Uma? Thank you so much for joining us. How are you? So,
I'm doing great, Napasa. It's such a pleasure to see you again and to have this session with you.
Same here, Uma. It's exciting. I think this year we didn't meet, I mean, like this for a discussion. So I'm really happy to be here. And folks out there, for those of you who I'm sure are wondering who is this familiar face, let me tell you that she is none other than Attorney Uma Mantravadi from Mantra Law Office, which is a highly reputed firm, and it's located in Houston, Texas. So United States, at around this area, Mantra Law Office is where it's going to be also very busy. So yes, Uma has expertise and experience for over 3 decades now. So I'm sure, friends, you must know her or want to know her for sure. So go check out www.mantralaw.com. And yes, thank you, Uma, once again. So
My
um,
pleasure, Nipasa. So much going on under the Trump administration, as you know that, and there's every hour by the hour we get information that is updates and can be surprising to our listeners. I mean, there's people even ask me this question: how are you able to digest this information? By the hour it comes out, and then the changes. There's so much that's going on, and in fact, me and Sam had talked about a couple of weeks ago that the forms were retracted back to an old edition, which caused a lot of problems for attorneys where the forms were being uh, not accepted and the packages were sent back by many attorneys, especially the 485s, many other forms. So, as a group of attorneys, we have filed a lawsuit against the government, and now they are
okay.
accepting all additions and will give us additional time to let us know what addition they will accept in the future.
Very
So I
interesting.
guess it's going to be a game of lawsuits, going back and forth.
How's the response so far? Are they reacting well to this?
A good question, Nibas. I wish I could say there's anything good, but
Mm.
we always take the positive side of everything. There's always a negative side, but there's always a positive side, and that's what we bring to this show to the listeners, to ease their lives, to kind of give them a path, a guidance, hoping that they would go on the right path. So.
Absolutely. Thank you so much, Uma, and it's always a pleasure to have you. So, as we start today's discussion, also, you said you have a couple of updates. So, would you like
Yes.
to give them first?
Yeah, that lawsuit was one of the updates that I wanted to bring about. And then, second thing, the Department of State, they've eliminated what's known as the deference policy on non immigrant visa waivers. What that means is, a deference is kind of going to your history and giving weight on your history and your documentation. For example, if somebody had an H1 and had an H1 approval, they would give deference to that approval from the past, not just the current one. And that would give some benefit to the applicant filing an application. And but this one particularly, they're talking about removing the policy from consular officers recommendation of approval of non-immigrant visa waivers. They're talking about waivers. Like, for example, if somebody had an individual waiver for a non-immigrant visa due to any ineligibility for in or called as inadmissibility due to medical grounds, criminal grounds, immigration violations, fraud, misrepresentation, any of these grounds, if somebody has been denied a visa and they applied for a waiver, now they could use that waiver that was obtained in the past, even for the current situations, and move on. That's what was the deference policy. But now the department is saying, that Department of State is saying, we don't have to go with your deference of the non-immigrant visa waiver. We can definitely request you to get another waiver before we can grant you the current visa. It can be an H1, an L1, or a B2, doesn't matter. Just because you got the waiver in the past, we're not going to give deference to that. We're going to ask you to get another waiver so that, we want to make sure you've not violated anything in between. So this is going to place additional burdens on people who've had violations and then who've got a grant of the waiver, now have to go back and get a second waiver, so they have to review each waiver application independently, and a new waiver has to be approved before the officer can give any undue deference or rely solely on the previous officer's decision to grant that waiver for the approval. So this is going to put additional work on people, additional delays on cases. So it's not great news, but that's what it is.
Well, thank you so much, Uma, for that very important update. And folks, yes, thank you so much for joining us. Rahul, thank you for your questions. Please stay with us. We are going to address them a little later in this episode. So, yes, and Uma also, the visa bulletin is out for April
Yes.
2025. Yeah, so let's look at some of the key updates and changes, maybe. What do you say? So,
EB1 for India has advanced to Feb 2020, Feb 15th, 2022. EB2 category has moved to Jan 2013, and EB3 for India has progressed to April 2013, April 1st. It's a little bit of an improvement. I wouldn't say it's extraordinary, but I think, even if it is moving at a snail pace, I think people from India are still happy to see some improvement in
improvement,
the disability.
right?
So we can
Well,
talk more about it, but those are the cutoff dates. And EB3 other workers is also at April 1st, 2013 for India.
mhm, mhm. Right, right. So, thank you, friends. There is little movement, of course. There are also retrogression that you can see, but it's not that great, like Uma has mentioned. It's not extraordinary or wow that we can talk much about it. We'll just have to be patient. But congratulations for folks whose dates have finally come, and all the best for the rest of, the process. And
Right.
yes, Uma. So, coming back to some of our questions, our topic of
I know you
discussion.
mentioned
Yeah.
about the retrogression, and I didn't talk about that, which is the EB5. EB5, India's unreserved EB5 immigrant visas numbers that are not set aside for rural or high unemployment or TEA. Cutoff date is retrogressed to November 1st, 2019.
Yeah.
That is the retrogression. And
Yeah.
EB5, of course, right now there's still the 800,000 for the rural as well as urban investment for target employment projects, as well as, high unemployment areas. But if you're doing an individual investment, it's still 1,050,000. But of course, Trump has discussed about the gold card that is not yet the law. Right now, EB5 is a legislation by Congress, and so this will remain in place until September 2027. But we
Mhm.
don't know what the Trump administration still can do. As you know, that they can always bring about executive orders to create chaos.
Yeah.
Will they do that? We don't know that.
Well, we'll just have to wait and watch. But I know the gold card is also making quite a lot of noise. Just the $5 million news, I would say, and so many hopefuls out there. But let's wait and watch. We never know what's going to happen. So, also, our topic of discussion for today is about FDNS site visits. So, if Uma, you can also provide sort of an overview of the FDNS and what significance it has in the context of H1B visa rules and requirements.
Yeah, sure. Thanks,
Thank you.
Napasa. First of all, FDNS site visits is not something new under the Trump administration. It's been there for a while, even under Clinton, even under the Obamas, George Bush, all of the presidents, pretty much we've seen it. But I think the enforcement is going to be much stronger under the Trump administration's second term, because immigration has been the discussion and focus for President Trump under the second term. And, as you can see, deportations are on the high priorities, and this has been going on. So, what is FDNS? FDNS is the short form of the Fraud Detection and National Security Directorate, which is a division of the USCIS, which conducts, let me use the word clearly, unannounced site visits, particularly to H1B employers as a part of the compliance and fraud prevention efforts. And this visit is the aim is to verify the legitimacy of an H1B petition and making sure that an employer and employee are both adhering to the program requirements, And because of the recent changes, as you know, the H1B modernization has come about in 2025. These visits will affect both employers and employees because of this. And it is widely expected that the US CIS will increasingly shift its focus towards enforcement efforts more under this second term of the Trump administration. And that's why the employers should be very, very familiar with what or how these FDNS site visits are conducted and how can one be prepared with these visits in advance. So that's what I wanted to talk about. Just to give, I can't tell word to word what the FDNS officers can really mention, but we can what are the things that they possibly can ask, So that's what I'm talking about.
Yes, that's right. And they are surprises, like Uma has already said that they are unannounced. So it can happen anytime. All we can do is play safe. So abide by the rules that you have to follow. The of course, company policy, and goes without saying that your workspace has to be your workspace, and you should be working while it's your time to work, right, Uma?
Absolutely. Well,
And documents.
go ahead.
No, and what about a document? Should like suppose there is a visit, and what will they be asked for? Of course, their identity card, probably.
Let me go through possible scenarios where, there's typically an unannounced USCIS officer visiting the work location specified in the H1B petition. And if they give a third party site, they're going to go there. If they give their own office location, they can go there. Or if they are giving the location of a remote, for example, if the employee is working from his or her own apartment or home, they can go there also for a site visit. And when they do go, they typically engage in one or more of the following things. They verify the physical existence of the business. For example, if the employer has given their office address, they can go there to verify if they really exist or they don't. Confirm the employment of the employees designated work site. They want to make sure if they're, like I just said earlier, if it's at a third party location, interview the H1B employer or employee or their representatives. They can review the payroll records, timesheets, work schedules, any other connected documentation, and they can probably assess the compliance with the H1B regulations. So basically, the idea is to prevent fraud or misrepresentation by the employer and the employee.
Well, well, right, very rightly put, and thank you so much, Uma. So these were some of the documents that or questions that you could be asked for. So Uma, thank you for highlighting them. And also at this moment, I'll quickly say hello to Yash and Echo Alex. And I think let's take Echo Alex's question. So he's asking for El Salvador TPS extension. Do I need to fill out Form I-765 and pay the fee, or just I-821 form?
If you need the work permit, definitely you need to fill up the 765 and pay the fees accordingly. There is a whole chart of fees that you need to make sure you're paying the correct fee.
All right.
This is for TPS, which is also known as temporary protective status.
Right. Right. So all the best to Eco Alex. And now let's also quickly address Yash's question. I've heard that FDNS site visits are becoming more common. Do you How do they decide who to inspect? And are certain industries, companies, or job roles more likely to get a site visit?
Not really. They don't go by industry or they don't go by employer. It can be a Microsoft or it can be a mom and pop kind of small employer with only 2 people or 10 people or 100 people. So it all depends on the officer. If they feel there is a red flag somewhere, the documentation was not clear, or they feel there is some kind of a fraud in their own mind, how do they determine they're not going to tell anyone about that? Or if they get a tip from somebody, it could be any of the following reasons that can lead them to an FDNS site visit. So we cannot say it's because of a job duty, job role. It can be for any umpty number of reasons.
So it's just like the lottery then. How lucky your day is today. Anyway,
Exactly.
but thank you so much, Uma. And thank you, Yash, for participating. Thank you for your question. Very interesting. And also, let's take up Rahul's question. I am an H1B visa holder working at a third party client site. With these new regulations, is there a higher risk of denial or site visits? And what kind of documents should I keep ready in case of an FDNS inspection? So, Rahul, I hope you were watching us. We've already addressed these questions and also discussed a few, possible questions or, demand for documentation by the inspection officer. And also, maybe we can take up the first part, Uma.
I've
Third
lost
party
what was
client
the first
side.
part. Oh, he's
Yeah.
working at a third party client site. Okay. That has to be, they'll check the LCA possibly to make sure that the LCA has the third party client site listed, or if it is a hybrid work arrangement. And, they can, FDNS officers typically have a wide and great authority to assess compliance at multiple work sites. So if they don't actually come to you, they can go to the third party client to verify your employment. They necessarily don't have to come to you, the employee, to get this information. They can get it from the third party vendor to get that information. So under the new H1B regulations, we are definitely expecting increased scrutiny, increased FTNS site visits, verifying job duties, employee qualifications is going to be a big question too. Employees placed at third party client sites, depending on each case by case or circumstances, Nabasa, FTNS may check with end clients, like I just said, whether the end client's minimum requirements have been met with or matched with by the employer. For example, if the end client is requiring a software engineer, but then
Mhm.
you placed a software developer, so now that is a red flag.
Okay. So the job description is very important, and doing what is said in the job
Also
description is
meeting with the job requirements of the end client.
right. Right. So thank you so much, Uma, for taking that up, and Rahul also for a very important question. So third party client site. And now, Arpita, hi, thank you so much for joining us. I wonder where you have joined us from, but thank you for your question. So let's take it up quickly, Uma. So she's asking, I've been with my employer for over 4 years on H1B without issues. But now I'm hearing that even long term employees are being scrutinized under these new rules. So, why is that? And should I be worried?
I wouldn't say long term, short term. There is no uh, reason to say a long-term employee will not be scrutinized by a FTNS visit. FTNS are equipped with lots of additional sources to detect fraud. Nipasa, for example, they have leveraging data analytics with their USCIS office to flag any inconsistencies in employer filings, be it old, be it new. They have the data analytics to do that. The employers found to have submitted any kind of false or misleading information also will face heightened penalties. So, they have every um, information and leverage to get the information. And
Mm,
based on that, they can go with an old employee doesn't matter. Somebody's
mhm.
been beyond the 6 years, they're filing for an extension, even that can be an FDNS visit.
Okay, okay.
So it's got nothing to do
Thank
with
you.
how long or how old, how long you've been with one employer or employer two or employer three. And as I said, there's a lot of questioning about the verification of job duties, employee qualifications, whether they meet the end client requirements, whether employer is in compliance with the LCA salary. A lot of employers I see that, they don't pay as per the salary. In fact, some
Yes.
of the employers pay a month later. If they're supposed to pay the Feb wages, typically are not paid till March or till April.
Hmm.
So
Hmm.
these can be problems too.
Right, right. So pay stubs are going to matter as well. Who knows? They would ask.
Absolutely.
Right.
Absolutely.
Thank you, Uma, for addressing this for Arpita. And folks, thank you for your questions. I would like to say that we also have a calling in line available. So why don't you call us to ask your questions? Echo Alex, Arpita, thank you for your questions. Why don't you join us on 425-436-6335, and the access code is 988-888. So if you call in, we are available and you can talk directly with none other than attorney Uma Mantravadi. So you can also email Uma in case you want more attention on your case and you want proper guidance or probably just a one-on-one consultation. You can call her on her number 713-787-5297, or email uma@mantralaw.com, or go visit www.mantralaw.com to get to know more about attorney Uma Mantravadi. So, Uma, also, we have more questions to address.
Sure.
Let's quickly take a couple of them. My next question to you would be, about the main changes in the new H1B rules. How are they affecting employer responsibilities?
Well, like I said, Nipasa, the F1, H1B modernization brought about a few good changes, and there's also uh, great length of discussion about enforcement and FTNS site visits. The good changes are, for example, in the past, an employee could not be a partner or hold any kind of partnership or stock, holding stocks in that company. In the past, you could not do that. If you did that, that would be considered as a bias. But now they're saying it's okay, you can be an employee and be a part owner of the company to file the H1. So that is one good new rule that is coming about. They're also saying we're going to give deference to your previous H1, previous H1B approval. So if we see that you've had prior H1 approvals, we're going to give deference to that to make sure, that you have a greater weight on your possible approval of the H1. Of course, they're still going to go through and make sure everything is in compliance, even though, they're going to give deference to the previous H1B approvals. But one of the key compliance requirements for H1B employers is maintaining also the public access files. The public access file must be readily available for inspection and contain, the certified LCA, the wage rate, explanation how the wage was determined, documentation of any previous wage sources, statement of notice to workers, meaning where did you place the LCA. All this plays a crucial role when there is a FDNS site visit, and it serves proof that the employer is complying with the wage requirements and the labor conditions. And if you don't maintain the PAF, which is a public access file, it can lead to penalties and compliance issues. And Napasa, we've seen some employers in the past, they were also banned from filing H1s if they felt the violations were extreme and the persons did not maintain the proper public access files. They even blacklisted them and did not allow them to file H1s.
Right. Right, Uma. Thank you so much for bringing that up again and highlighting them as well. So, yes, a lot of things are to be kept in mind, and there are new rules which, you would like to check out as well, it's always best to stay updated. Do your research properly, especially when
Absolutely.
whichever visa that you are applying for, get to know more about it and what rules govern all that, and play safe, of course. So also, there were new rules much before even the new administration came into being. A couple of days, right? I think it was January
Yes,
17th.
this modernization rule was implemented on Jan 17th, 2025,
Right.
exactly 4 days before President
Trump.
Trump took the office.
Right. Right. So yeah, now coming to my next question to you, Uma, would be, how does these new rule make FDNS site visits mandatory for employers?
It doesn't make it mandatory for employers, Nipasa, but then, as I said, with the data analytics and information available to USCIS, if they feel there's a red flag going off, they can always, come to an employer to make sure they, audit your existing public access files. They can ensure the records are, kept complete. If you haven't, you need to make sure that you maintain accurate and up to date employee records, which is keeping copies of their paychecks, W 2s, in case of any FDNS visit. So, right now, as I mentioned, this Trump administration is looking for more of enforcement rather than just looking at compliances alone. Compliance and enforcement kind of come together. So definitely there's going to be more site visits, and employers should mandatorily maintain a proper public access files.
Okay, and just in case, these employers, they do not cooperate with these FDNS site visits, inspection officers maybe. So what do you think is going to happen next?
As I said, possibly penalties could be also a risk of getting blacklisted, where they will not be allowed to file for any future H1Bs.
Mm-hmm. So, all right. But is there
Employers need to,
anything?
sorry,
Okay.
go ahead, sorry.
So, and I was just going to ask, is there any way they can avoid these, maybe answering to these FDM, politely, of course, maybe saying that I would like to have my attorney while I answer or something
They
like
can
that?
always do that. They can, if there's any legal matters that they don't know that is complicated for them, they can always say, you know what, let's schedule a time where my attorney can be present and explain. I have the documentation, what I can, but if I don't have, maybe I'll keep it ready. I should have, but I didn't, or maybe my attorney has it and I don't. They could definitely,
Okay.
and not that the attorney would be immediately available for them to
Mm-hmm.
show up at their physical location, but they can definitely ask for time. So, in order, I would say the best practice for the employer is to make sure your public access files are kept up to date in case of an inspection, maintain employee payroll records, payroll information, train your HR personnel to be prepared for these unannounced FDNS visits,
Visits, yeah.
um, and make sure that your employees know their job roles, their wages, their work site location. Sometimes people get nervous, if they are a programmer and they'll say, I'm a software developer, they're completely giving wrong information. So they need
Right.
to be, addressed properly, and keep your documentation organized with the LCA,
Mhm.
employment agreements, any kind of organized org charts are very important. So employer needs to maintain that.
Right, right.
These are the
So,
ways to avoid uh, intricate FDNS questioning.
Thank you so much, Uma, for bringing them up and highlighting them. So I really hope that people are pretty much ready for all these more site visits, you can say, this year. And also, we were speaking about what can happen to employees, but do you think the same is going to happen to the company also who doesn't follow these FDNS site visit rules? Maybe do you think it'll affect their reputation and even the ability to maybe even hire
It
H1B
can,
workers for them?
it can, and it can, I mean, once they've had an FDNS visit and they find a lot of violations of the employer, then anytime you file an H1, you can expect RFEs, you can expect NOIDs, which is the notice of intent to deny, or in a situation where they feel they violated, they can always do a notice of intent to revoke that current H1B as well.
All right. Thank you so much, Uma. Now, well, we got Kaylee Huey saying hello. So, hello to Kaylee, Kelly. Sorry if I've got your name wrong. But thank you so much for joining us. And if you have any questions, do ask or join us on call. You can dial this number 425-436-6335, and the access code is 988-888. So, especially folks out there whose questions we address, don't forget to also like our channel, subscribe to our channel, and our handle is at Immigration Talk Show. Follow us, connect with us. We are not just on YouTube, but also on LinkedIn, Facebook, X, Instagram, and stay connected with us. Watch out our space because we have so much information all the time coming up, the latest ones, updates that you don't want to miss, and also so nice to have Attorney Uma Mantravadi today, from the Mantra Law Offices. So thank you so much, Uma. Now, I have another question. And, if an IT company faced an FDNS site visit in February
Mhm.
2025, shortly
Mhm.
after the new H1B compliance regulations took effect,
Sure.
unprepared and unable to provide the required documentation or personnel, the company was flagged for non-compliance, and this led to several H1B petitions being denied or revoked, severely impacting operations as well. So, following this, the company implemented strict compliance protocols to avoid future issues. So, how can companies ensure, especially immediate access to necessary documentation during site visits?
First thing I tell employers, please have an attorney who can help you with your public access files. Make sure your I-9 is in compliance. Make sure you're an e-verified company. There are many things you can do to avoid even being red flagged and having a site visit. As I mentioned, as long as there is no fraud or violations, everything should go well. But first thing is to contact an attorney. There are attorneys who also specialize, particularly in public access files, how to maintain, what do you have to do, what are the documents that are required, how do you be ready for an FDNS site visit. So there are attorneys who do that, and I do assist my employers who are working with me to make sure that they have a complete and proper FDNS visit public access file so that they don't have too many problems.
That's a really very kind of you and thoughtful of you, Uma. So um, I think it's always best to have an attorney by your side and lead you and guide you in the right path. So why not contact Attorney Uma Mantravadi, and you can do so, by asking for more attention on your case by dialing this number 713-787-5297. And you can also email Uma about your case to uma@mantralaw.com. You can note it down, it's there on the screen below. And also go visit www.mantralaw.com to get to know more about Attorney Uma Mantravadi. But for now, I would say stay with us. We'll just go for a short break and we'll be right back with Attorney Uma Mantravadi on Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. So, this would be the second part of the webinar today we are having with none other than Attorney Uma Mantravadi from Mantra Law Office, Texas. And it's very nice to have you, Uma. Such a pleasure always, you know, to have your expertise, your knowledge, you imparting that with us in our show. So, thank you. And
Most welcome.
And also, it's really lovely, folks, that you join us with your questions. So I would really like to quickly take up this next one. This is from Mohammed, and he's asking, what are the new regulations? We
New
already
regulations
addressed that a
about
little time.
what? I think we've already discussed it over and over again. So,
Yes,
all I can tell Mr. Forget his name, Mr. Muhammad.
Zuhair.
Uh-huh. Mr. Muhammad, you can go to the USCIS website and go to H1B modernization rule, and it's all there. You can look at it if that's what you're looking at. I don't know, it's a generic question about new regulations. So if it's about H1, you can go there and look up the new regulation.
Yes, in fact, if it's about H1B, we already discussed a little while back on this very episode. So you can always stream this episode again once, watch this episode again after the stream is over as well. So thank you, Mohammed, for your question. And now we have our next one. This is from RK. Oh, Kaylee. Kaylee asking, I currently live in Ethiopia and trying to take USMLE. I am a medical doctor. What will be the next step after my USMLE?
I wouldn't know that. That's something you'll have to check in the medical field whether you need to go do additional education, residency, board exams. I'm not familiar with that. That's something you'll have to check it out.
Okay.
I don't know
Well,
what step, because all I know is USMLE is got a step one, step two, step three, and then you have to match to the residency programs. And if you do get into the residency, that's what you do. But I don't know more details than that. It's only a general information.
thank you. And thank you, Kelly, for your question. Now, let's take up this next one. This is from RK. If a site is done and the employer is found to not be in compliance for one or two employees, what happens to the other employees at the same employer?
Possibly even they can be, their cases can be questioned because there was a red flag on this employer. So there is
Mhm.
a possibility that, you know, once a doubt, they can, you know, go into other cases too.
Okay.
Possibly. We don't know that.
All right. So I also have another question which I received in my WhatsApp. But before that, Kelly is already saying, okay, thank you. Thank you again to you too, Kelly. And this next question I received in my WhatsApp is I'm Abraham. I get your contact from the internet. Thank you so much for joining us. I am from Ethiopia. I need to go abroad, work hardly, and help others. So, my question is, how can I get H1B visa? Could you help me, please?
Well, right now the H1B lottery is going on, and if you have an employer who's willing to file your H1, you can file your H1B electronic registration. And if you're lucky, you get picked in the lottery, then you go forward. And the deadline for filing is March 24th, 2025. So make sure your employer files your registration, electronic registration, before that date.
All right. Thank you so much. And thank you, Uma, for taking that up. All the best. I know it's a very vast question, but I really do hope that you qualify and have a job waiting for you. So, all the best to Abraham. All right. Now, next question to you, Uma. Let's get back to our questions. Okay, let's take these from our Facebook groups, or this is from our YouTube channel. And this is, if I petition from August 2017, got welcome letter and numbers from a couple months now, but the payment is not opening for me to pay. It's for my over 21 children in Jamaica. Now, this
I
is
didn't
interesting.
understand the question.
If I petition from August 2017, got welcome letter. I think
Welcome
his,
letter meaning they got a green card welcome letter.
yes, probably their
Is
dates are,
that what I can assume?
yeah. So maybe, so a couple of months of petition for child over 21 years. Okay, could be that too. But for a couple of months now, he's received this petition, but the payment is not going through.
I don't know
Uh,
what payment they're referring to. Is that the NBC payment? You would have already done it if you've already got the green card approval. You're saying you've got the approval, but then you're talking about the payment. So it's confusing. I would suggest whoever this is, please reach out to me individually, and I'll be glad to take it up and then, answer your question. Please send me
yes.
an email to my email address, uma
So,
at mantralaw.com.
Thank you, Hermione, for your question, and do message Uma. Now, this one is from an anonymous participant in Facebook, Uma. So they're asking, hey everyone, I was rejected twice for my F1 visa interview 3 years ago when I applied for my bachelor's. Now I'm planning to apply again for my master's in the United States, and I want to make sure I address any political issues and strengthen my application this time. What factors should I be careful about, and does anyone have insights or advice on improving my chances?
Uh, all I can say is I don't know what happened in the past. So I would have to look at the past history, why he or she was denied twice in order to make sure they strengthen their case this time. And a lot of
Right,
times, what happens if you've had a denial in the past, few people keep getting denials, and few are lucky enough to overcome those denials and get a visa approved, be it a B1, B2, F1, H1, it doesn't matter. But we have to look at the history to determine what went wrong there in order to correct it now. So,
right.
again, if you want to reach out to me, you're more than welcome to.
Right. Thank you so much, Uma, for taking that up. And anonymous participant, you can always reach out to attorney Uma Mantravadi at uma@mantralaw.com. And you may even call her on this number, 713-787-5297. So let's go on to our next one. This next one is a typical situation. I'm on H1 and recently moved to US. Since my wife can't work on H4, I'm thinking of applying F1 to get her to the US. Please suggest what if they ask why F1 instead of H4 in the visa interview?
Well, my advice would be, or my suggestion would be, let her come here on an H4, and then you can always change it to an F1 when she's in the US to avoid any issues.
Absolutely. Thank you, Uma, for that very direct and prompt answer to this typical situation. And this next question is, hello everyone. I have a query regarding H1 transfer. The current employer, they see where I'm working, filed H1 transfer in normal process on January 15. At that time, I got another offering from a big tech company, but they were doing background verification and now they completed and processing my transfer premium. So the attorney is asking latest pay stubs, but my employer is saying that they have a payment period of 45 days. So I will get my salary on the 15th of March. I joined on receipt notice as my grace period was about to be over in a few days. Initial document I gave to attorney was my previous employer because that time I was in grace period. Now what should I share with the attorney?
This
Thanks.
is way too much information. I'll have to, speak to this person individually,
Mhm.
Nipasa, because I'll have to get a lot more information before I can give them any kind of guidance. So I would advise them to reach out to me, and then, we can take it up, because there's a
Absolutely.
lot more
Anonymous.
information that I need other than what they are saying here.
Right, right. So, anonymous participant, do reach out to attorney Uma Mantravadi, and her contact details are already on the screen. I hope you have noted it down. Let's go on to our next one now. This next question are okay. We have addressed all our Facebook and YouTube questions for now, but also another question I have for you is Uma, if you can tell us,
Sure.
how to follow FDNS site visit rules affect H1B employees' ability to work and stay in the US, which
Sorry, would you repeat that question?
how could failing to follow FDNS site visits, the site visit rules, they affect these H1B employees' ability to work and stay in the US if it's an
Well, if the
H1B?
employer doesn't comply with the FTNS site visits, during the FTNS site visits, As I said, they can get a notice of intent to revoke or a notice of intent to deny. And would that be all the cases possible or some cases? We don't know. So they need to, first of all, during or prior to the FTNS visit, an employer is required to cooperate fully with the FTNS site visit to demonstrate their compliance with the H1B regulation. So, in order to do that, they need a point of contact, somebody who knows all about the company, the H1s, like an HR or an immigration attorney, to handle site visits. And they need to make sure that all the essential documents are there in the public access files, including pay records, work schedules, everything. So they need to make sure they are in compliance, or at least make sure they're ready for the compliance. Speak to an attorney. FTNS visits can be very, very damaging to an employer if they don't maintain proper documents.
Right. So, and anyway, like it's very important to have your documents right, and there are documents that you should also keep with yourself at all times: identity card, of course, and your visa status, with no doubt, and also your passport, maybe, because you may be asked anytime.
Absolutely. That's for the employee, keeping a copy of the I-797 approval, copy of your passport, your current driver's license. All of that is, yes, a requirement. But for the employer, the FTNS site visits are more stringent on the employer.
Right. Right. Thank you so much, Uma, for that. And maybe, before we wrap up, are there any points or end notes that you would like to make, especially with regard to our topic of discussion today, that is the April Visa Bulletin, and what is the impact of new H1B regulations and FDNS site visits? Anything more you want to add before we leave?
Sure. I always like to tell people this, especially now under the Trump administration, the second term. Don't take chances. Please, contact an attorney. Ensure that you're in compliance with all the, whether it's an H1B regulation, L1, TN, E2, E3, F1, doesn't matter. And second thing I would advise is, this is not a time to travel. Do not travel. Avoid it. Just stay put. Because if you have issues, when you come back at the port of entry, CBP is not being very kind on people. They're even deporting permanent residents. So I wouldn't take a chance.
It's
Do
crazy,
not
but
travel if it's not necessary.
thank you so much, Uma, for those very important points and advices. So, with that, I think we have come to the end of our episode today. This very important webinar, full of important updates and a lot of discussion, a lot of important points to keep in mind as well. So, I would say thank you so much, Uma. It's always a pleasure and an honor to have you here
My
with us.
pleasure. Have a good one and a
You
wonderful rest of the week.
You too, Uma. All the best. And friends out there, thank you so much for joining us once again. And if you want to have a one on one consultation with attorney Uma Mantravadi or contact her, do call her on her number 713-787-5297, or email uma@mantralaw.com, and go visit www.mantralaw.com. Also, you can email me or WhatsApp me in this number. My number is 408-335-6444, and my email address is nipa@staffingly.com. But before you leave, friends, don't forget to subscribe to us if you haven't as yet already, and do like and share. Also, don't forget to hit that bell icon and get notified whenever we have discussions like these. And that said, thank you once again for joining us on Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, X, Instagram. Check us out, connect with us, and watch out our space, because we have a lot of important updates you don't want to miss. Bye for now. This is Nipasa signing off. Hello, everyone, and welcome to another episode on Immigration Talk Show. I'm your host, Napasa, and I'm going to be there with you for this next 1 hour on a very, very interesting discussion with our guest for today. And before we have our guest join us, I have this very important disclaimer to keep in mind. So, friends, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, welcome to Immigration Talk Show. It's really nice that you have joined us. We are streaming live right now on YouTube. And also, you can check us out on LinkedIn, Facebook, X, Instagram. And please feel free to connect with us, friends. And also, don't forget to subscribe to our channel at Immigration Talk Show. And you can also participate in this discussion by commenting wherever you're watching. And also, you can join us on call, maybe ask your questions directly to the attorney. And that you can do so by calling on this number 425-436-6335, and the access code is 988-888. So, yes, and without further ado, friends, today's guest is none other than a very familiar face, attorney Chand Parvatineni from SPB Law Firm, Dallas, Texas. And it's always lovely to have you, Chand. I hope you're doing good today as well.
Thank you, Nipasa, and thank you very much. And then hopefully we'll have another very fruitful and very informative session today. We're going to talk about the perms, the relevance of perms, especially to the folks that are on H1B, working on H1B in United States, because there are term limits. There are limits on how long somebody can stay in US on a temporary non-immigrant visa, such as H1B. So we will talk about all the nuances and things concerning the time limits that will help them extend their stay on H1B in this country.
Right. And friends, it's going to be very interesting. Maybe you can join in with your questions because we're going to be here for the next hour. And yes, we'll be happy to answer to your questions as well. So join us in this discussion. Chand, I'm excited. So I think we should not wait too long. Start off with some of our questions, So I have one first question to you, and that is, if you could tell us about what happens when an H1B worker reaches the 6 year limit, since that is also our topic, and are there any immediate extensions available?
Sure. So one thing that anybody that's on H1B should realize and remember is the H1B can only be used for a maximum of 6 years. That's the general rule. And each time somebody applies for a H1B, they can typically get an approval that is for a max of 3 years. So somebody gets a H1B, they can get a 3 year H1B. They go for an extension, they can again get another 3 year H1B, and the limit for that is 6 years. So the general rule by regulation says somebody can be on H1B only for 6 years. And the reason for that rule is because H1B is supposed to be a temporary visa. It's a temporary non-immigrant visa where somebody utilizes H1B to come and work in United States, but on a temporary basis. So that's how this 6 year rule came about. And then eventually what happened was, what if you need to stay in the country and work for more than 6 years? And the Congress, so basically what happened was they went and the regulations got changed. And the rule is, yes, you can extend the H1B after being in the United States on H1B for 6 years if certain conditions are met. And so under certain conditions, they can extend it after 6 years. And the main condition is the green card process should have started. So somebody should have an intent to get a green card. Somebody should have an intent to stay as a long-term permanent resident in United States. Only then somebody is eligible for extensions after they cross 6 years on H1B. How is this possible? So the first thing is the perm application. So typically people are on H1B. They need to have a sponsor. They need to have a sponsor, and typically that sponsor is their employer. That employer should sponsor their green card, and they have to be at a certain stage of their green card in order to qualify extensions that cross 6 years. And the way that works is employers typically have to do something called a labor filing, labor uh, perm application. So if the labor certification is filed, it's filed by the employer. That is the very first step when a company tries to sponsor somebody's green card, labor. So if this company sponsors labor, they file the labor. And if that labor certification is pending for more than 12 months, technically, again, they are eligible for extensions. So if somebody's company has filed a labor application, it's called 9089 application. If it is pending for more than 365 days, USCIS will agree for an extension. Or there is something called an I-140. So I-140 is an immigrant petition for an alien worker. Typically, this is again applied by the employer. So if the employer applies for an I-140 and they get an approval, so that is another way where somebody can again get an extension after they cross their 6 years. And again, there are some ways where somebody can self-sponsor their I-140. There is something called EB2 National Interest Waiver. There is something called EB1A. So there is this process. So if somebody applies for their own I-140 using these categories where they can self-sponsor and they have an approval, that is another way where somebody can apply for an extension. And the general rule is, if you're not in the process of getting a green card, if you're not in a spot where you either have an I-140 approved or your labor certification is pending for more than 1 year, you will not be given extensions. So from a general perspective, people have to make sure that if they do want to stay in the country for a longer time and they want to stay and work on H1B, the only way is they have to get the green card process started, and they have to be at a certain stage to ensure that they can extend their H1B after 6 years. And if this is not done, the only way they can stay back in this country is by transitioning to another visa type. Maybe if they're eligible for O1, maybe if they're eligible for L1, something like that. They have to transition to another visa type. And if that is not possible, and if they want to stay on H1B, they have to make sure that either the I-140 is approved or the labor application is pending for more than 365 days.
Thank you so much, Attorney Chand, for highlighting how important is 6 year limit to keep in mind, and also extending at the right time if you are eligible for any extensions as well. So, thank you, and we will discuss further on this. So, stay with us, and also hi to Bhavini. Thank you for joining us on YouTube. We will take up your question, but in some time. So, stay with us. So also, Chand, my next question is about filing a perm. Can filing perm application before the H1B 6 year limit help extend an employee's stay in the US? I mean, you already discussed about it a bit, but if you can tell us further, and what are the key deadlines, to keep in mind?
Yes. So filing a perm application. So perm basically means program electronic review management. That is that is what the perm stands for. And from the form perspective, it is called the form 9089. So if this application is filed, and this is done before the 6 year limit is done, under certain circumstances, it can help extend an employee's stay in US. So that is like the first and foremost thing that typically everybody that is on H1B should aim for. Basically, convincing their employee that they're a valuable employee, and it it makes sense for the company to sponsor their perm process. And perm is a very complex process. It is also expensive for a lot of companies because there are mandatory advertisement that have to be placed. There is a recruitment process that the company has to follow. There is legal fees. So it's a pretty expensive process. Not only expensive, it is also a complex process. So for that reason, a lot of companies typically, unless they see a real good reason, they will not file the perm. And the reason for that is the money and the cost, and also uh, the long term need. So the company has to be convinced that they're hiring somebody, they want somebody to be their employee for a long time to actually sponsor their green card. And once the company is convinced, that is where the company will start filing the perm. And the key deadline is the company has to file the perm before the H1B workers 6 year limit is reached. And when we talk about 6 years, we're talking about 6 years overall. So it's not just with that particular employer, but the H1B throughout that employee's time in US. So it is time counting the prior employer's time period, any other employer that the employee might have worked under H1B, and so on. So the total time with all the employers, former employers together on H1B is 6 years. The max is 6 years. So before the 6 years limit is crossed, the employer should file for the perm process. And the big rule is, if uh, the perm should not only be filed before 6 years, but the perm also has to be pending for at least 1 year. So if the perm is not pending for at least 1 year, again, you cannot get extensions unless your I-140 is done. So what that means is, you cannot really wait until your sixth year to have the employer file for the perm. So the perm should already be pending for at least 1 year. So what that means is, before your fifth year ends, the company should have filed the perm for you. Because if the company files the perm for somebody before fifth year, then when during the sixth year, when they're ready for their extension, it is already pending for at least 365 days. So the rule is, on the day you want to get an extension filed, the perm should already be pending for 1 year. So the bottom line is, if the company does not file the perm application before fifth year, you are at high risk, because you're getting very close to your sixth year. And once the sixth year is done, unless the perm is pending for pending for 1 year, or the I-140 is complete, you pretty much have to leave the country or convert to another status. So that is like one of the main things with the deadlines. And the other option is I-140 approval. So if the I-140 is approved before your sixth year, you're good. And what that means is, to file the I-140, you require the perm if the employer is sponsoring you. So you have to account for that timeline. If not, what a lot of people are also considering nowadays is EB2 NIW. So EB2 NIW is something that a lot of people should explore. The reason is, if somebody's in the country for such a long time, they're contributing to US, and they're working in a field that is of national interest, and you have a very high pay, you more than likely, depending on your credentials, you might qualify for a national interest waiver. And the way it works is you will file an I-140 under EB2 NIW process, and you can do it in premium. And what that means is you have to account for the time. So you probably will need about 6 months, because in case you have an RFE, you have to account for that timeline. So if you have about 6 months of time, you can at least explore EB2 NIW option in case you are qualified. So the bottom line is, at least by the end of your fifth year, either your EB2 NIW or hopefully the perm process, if they start, more than likely you are in good shape. So in terms of the key deadlines, you always look at your 6 year limit. So everybody should keep in mind what their 6 year limit is, and based on that, always aim to have the perm filed at least 1 year before that deadline. So that is the crucial deadline that everybody should keep in mind. And if it is not done, you are at risk when the 6 years is done, because I do know a lot of people who have completed their sixth year, they don't have their perm application pending for at least 1 year, their I-140 is not done, and unfortunately they had to leave the country, they have to go back to India, wait until this entire process is done, and then reapply and then come back to US.
So it's very important. Thank you so much, Chant, for highlighting the deadlines and dates to keep in mind, at least to keep how much buffer time. So 1 year, 365 days at least. So thank you, Chand. And also hi to Nilanjana. Thank you for joining us with your question on YouTube. We will take them up very soon. So stay with us. Also, Chand, if you could tell us about this. What is the role of an I-140 petition in securing H1B extensions beyond the 6 year cap?
So in the last few minutes, we talked about two ways that one can get an extension after 6 years. One is uh, by showing that the perm application is pending for at least 1 year. The
Yeah.
other option is I-140 being approved. So these are two ways where somebody can get an extension done, and there is a difference. So if perm is pending for at least 1 year, but your I-140 is not done, what typically happens is, yes, you're eligible for an extension, but you can only get a H1B for 1 year. So if I-140 is not approved, but perm is pending, one is still eligible to get an extension, but they can only get a 1 year approval. And say the I-140, so I-140 petition. So if the I-140 petition is approved, the beauty is that you are eligible for a 3 year extension. So if I-140 is approved, you're getting a 3 year extension. So the eventual goal is to see an I-140 petition that is approved. And doing so, you will be guaranteed to get an approval for 3 years when you apply for your H1B extension. And I-140 approval, again, it's two types. One, an I-140 where your employer is filing for you because they have sponsored the perm application. That is the most common way people get their I-140 done. The second uncommon way is you self-sponsor I-140. You can self-sponsor I-140 under EB1A category if you qualify, or you can self-sponsor under EB2 NIW, National Interest Waiver, if you qualify again. So the goal is either you self-sponsor your I-140 if you're qualified, get an approval, or have your employer file the I-140 following the perm process. And after the perm is certified, they file the I-140. And the goal is try to have an I-140 approval before the 6 years, because that will guarantee 3 years of approval. And that's always better than just showing the perm that the perm is pending for 1 year and getting an extension. Okay. And I-140 does impact the H1B workers stay, because technically without an approved 140, you either have to leave the country, or maybe the max you'll get is a 1 year extension if your I-140 is not approved. And I-140 being approved, you are eligible for 3 year extensions. And also the beauty is that if your I-140 is approved, and the I-140 is approved for at least 180 days, you can even transfer your employment. So down the line, if you get a better offer, you get a better job offer from another employer, you can always change your employer. The I-140 stays with you. So the date, the priority date, and that approval copy stays with you. What that means is you can apply for your spouse's EAD card, H4 EAD, or you can apply for your transfer, even though that I-140 is with the previous employer. That I-140 can still be used to get your 3 year extensions. So even after your 6 year period is done, if your I-140 is approved, so theoretically you can use that approval to keep on extending your H1B until your dates are current. So the key point is try to get an I-140 approved uh, based on how you're qualified before your 6 year period is done. And doing so, you can guarantee that your H1B can be extended till the dates are current.
Okay. All right. Thank you so much, Chand. And well, also, what if a perm labor certification is still pending close to the 6 year H1B limit? So, what options does the applicant have in that case?
Sure. So if the perm labor certification is still pending, what that typically means is the I-140 cannot be filed. Only once the perm labor is certified, the company can sponsor the I-140, can file the I-140. And nowadays, unfortunately, what is happening is perm is taking a very, very, very long time. From the date somebody applies the perm, it is taking almost 15 to 16 months to get a perm labor certification. This was not this way about 2 years back. So what has happened was they changed the perm system. So previously the perm used to go through a different system. The system used to be called a PLC, and now they changed the perm to a new system. Now we use something called flag. We use the flag system for perm labor certifications. And when they made the change, because things got changed a little bit, we are seeing extreme delays in perm labor certifications. So once the perm is filed, a couple of years back, it used to take 4 to 5 months to see the perm certified. Now it is taking almost 15 to 16 months. So, and what that means for everybody is until your perm is certified, your I-140 cannot even be filed. So you not have a I-140 approval. And what that means is tomorrow you can, I mean, tomorrow if you have a very, very good job offer from another company, you cannot even take that job because if you are close to your 6 year limit, even if you get a job, even if you try to change your job, you might not even be eligible for 3 year extension. So you're in a spot where you can't even take up a good job offer if you get a good job offer because your perm labor is pending, you're getting close to your 6 year limit, and your I-140 cannot be filed. So, so in terms of options, what people typically can do is if your perm labor if your perm labor, even though it is pending, if at least 365 days have passed, if your perm is pending for more than 365 days, you can at least apply for an extension. The only challenge is you can only get 1 year. So even though technically you can apply for an extension, you're only getting 1 year. And 1 year extensions are always risky because if you go for stamping, you'll only get a visa for 1 year. And again, after 1 year, again, you have to file your H1B. And again, we don't know what kind of rules will change in the next 1 year and so on. So theoretically, the good news is yes, you can get an extension, but that extension is only for 1 year, and that is only if your perm is pending for 365 days or more. So how do you tackle this? So the way you can tackle this is to get your perm application filed as early as possible. Don't even wait until it is fifth year or sixth year. Your perm has to be filed as early as possible. And what we tell people is try to work with your employer and try to get it done in the very first year of your employment. Convince your employer, show your work product, convince them that you're a good employee, convince them that you have the talent, and try to convince your employer to file the perm as quickly as possible. If the company is not filing your perm in the first or second year of your employment, it's probably too risky to stick to that employer because tomorrow when it is time, when it is close to your 6 year time period and your perm is not done, right now we are talking about 15 to 16 months to get the perm application done, but to even file the perm there is almost a 6 to 8 month of work that needs to be done before the perm is filed. There is something called prevailing wages. The company has to apply for prevailing wages. Prevailing wages take 6 to 7 months. After prevailing wages, the company has to do recruitment. Recruitment is another 2 month process. So by the time you add the prevailing wages, recruitment, applying for the perm labor, and then applying for the I-140, you're looking at almost 2 to 3 years nowadays. So if you are working for a company that is delaying your perm process, you are at risk. You are at risk for 6 year. Once you cross your 6 years, you are at risk for getting extensions done. In case something happens to the perm, you get a perm audit, and say the perm fails, tomorrow you are at huge risk. So for that reason, what I think everybody should do is file perm as early as possible to maximize that your extension will not have any issues. And again, if your employer doesn't look like they're filing the I-140 or perm pretty quickly, explore the EB2 NAW options, explore the EB1A options, and see if it is something that you might qualify. And another option is look at the O1 visa option. So the O1 visa does not have the 6 year limit. And a lot of people who are who do have extraordinary ability in their field might qualify for O1 visa, and a lot of people are exploring the O1 visa option. So O1 visa option is another option that people can explore if they feel that their perm is getting delayed. So if not, you are at risk. Uh, so so what it means is uh, do apply for perm. Do make your company apply for perm as early on as possible. And if you feel that the company is delaying your perm and it is dragging the process, you might have to explore finding a job with another company, because you don't want to work with a company where tomorrow they're not doing the perm processing on time. Because what that would mean is by the time your 6 years is over, you might even have to step out of the country. You might have to leave the country because you're not getting an H1B extension done.
Thank you so much, Chand, for taking that up as well, and also, for highlighting how important it is. So, hi to Ganesh. Thank you so much for joining us. I think we should quickly address some of our viewers' questions. Let's start with Bhavini. I'm currently in my fifth year of H1B, and my employer just started my perm process. Given that perm can take months, what happens if I hit my 6 year limit before my I 140 is approved? Can I stay in the US while waiting?
So at least the good thing is, looks like your employer has actually started the perm. And so right before your 6 years expires, so your H1B approval copy, you can see when your current H1B expires. So before that date, your company will have to apply for an extension. So so when they are applying for your extension, if they've already crossed 365 days of filing the perm, you probably will not have any issue. Even if your I-140 is not approved, they can still ask for an extension. The only problem is you only get a 1 year extension, not a 3 year extension, but at least you can get an extension. And if it is fifth year, the big challenge is the perm itself. After applying the perm, it is taking almost 15 to 16 months to see an approval. And then you have to file an I-140. The good news with I-140 is you can do it in premium processing. You cannot file the perm in premium processing, but you can file the I-140 in premium processing. So if luckily just before your extension is required, if your perm gets approved, you might be able to do your I-140 in premium. But worst case, if the perm on that day, the day your extension is required to be filed, if your perm has crossed 365 days, yes, you're good. If not, this is what you should do. There is something called recapture. So recapture means, say you travel out of the country, you stay in India for a month, or in the past you've traveled to India, you've taken a vacation, you've traveled to some other countries. You can count all those days and you can recapture all that time and add it to your 6 year period. So what that means is, 6 years is the time you're able to physically stay and work in this country on H1B. It is not the approval time period. So in the 6 years, whatever vacations you have taken and gone out of the country, you can count all those days and you can do something called recapture. And those days can be tagged on, can be added on to top of 6 years, and they can extend your H1B. So what you should do is check with your company and see how much of recapture time you have that can be added. And then the next thing is, see if your perm is going to be pending for at least 1 year by the time your extension is due. So doing so, you can add and get your extension done.
Very interesting. And thank you so much, Sean, for taking that up for Bhavini. And recapture is another very interesting, way, I think, to count your days. So, yes. And we have Nilanjana now. Nilanjana. My employer started my perm process late, and I only have 10 months left on my H1B. If the perm gets delayed or denied, am I out of options, or can I still extend my stay?
So looks like you have 10 months stay left, and then you again you said the employer started the perm process late. Uh, at this point of time, if the perm is already filed, I think you're in good shape, because you have 10 months of time and the perm is already filed. I think you'll be okay, because you can always uh, look for recapture option, because it's only 2 months. You might be able to recapture it pretty easily by working out of the country. But if the perm process has just started, but the perm is not actually filed, then I think you're at risk, because when you say the perm process has started, they start off with the prevailing wage process. Then they do the advertisements and mandatory recruitment and so on. So that will take a long time. So the whole thing is, if your perm is already filed, I think you're in good shape. If your perm is not filed yet, just check and see with your company how quickly are they going to be filing the perm, filing the actual perm with DOL, and then talk to them about recapture, because people can always use recapture, stay out of the country, and all the time can be added on. So you definitely will have to talk and see the exact date your perm was filed. You do need to get that date, the date that perm was filed with DOL. Normally, what happens is when the perm is filed with DOL, your employer will get an email. So that email is good proof that the perm is filed. So try to get a copy of that email so you exactly know when the perm was filed. And then look at all your recapture options, how much time you have spent outside the country, because all that can be recaptured. So anytime you take a vacation, go out of the country, you can recapture and add it to the 6 year period.
All right. Thank you so much, Nilanjana, for participating with your question, and also Chand for being such a sport and answering so patiently. So we do have Ganesh's question. Sudhir, hi Sudhir, thank you for joining us on YouTube. Stay with us. So we'll just go for a short break quickly and be back here on Immigration Talk Show. And today, friends, we are discussing with attorney Chant Parvataneni from Dallas, Texas, about reaching the H1B 6 year limit and what are your options with firm. So, yes, you can also have a one on one discussion with Attorney Chand himself, maybe about your case. You need some private time and a consultation. Why not call him up on his number, 817-523-8247? Or else, yes, you can email him at law@spblawfirm.com and go visit www.spblawfirm.com. So now, friends, we'll just go for a short break. Don't go anywhere. It's me, Nabasa, with Attorney Chand Pravathaneni. Hello, everyone, and welcome back to Immigration Talk Show. And this will be the second part of this discussion we're having with Attorney Chan Parvathineni from SPB Law Firm, Dallas, Texas. And it's always wonderful to have you here, Chand. Always a pleasure to have you on our shows and discussing about so many various topics, including this one today. So, Chand, we have been answering some of our questions from the viewers. So let's continue and let's take up this next one from Ganesh. So Ganesh is asking,
Mhm.
I have an I-140 approval from my previous employer, but I never got a green card. I'm now working for a different company and my H1B is about to expire. So, hold
Yeah.
on. Can my new employer use my old I-140 to extend my H1B beyond 6 years?
Yeah. So again, that's a good question, and I think a lot of people, I think, will be in that situation. The reason is getting a green card when somebody is born in India or China, the countries that have a lot of retrogression. It takes a very, very long time. And for somebody who's born in India, even though you have an I-140 approved, green card is like a very lengthy process. It takes a couple of decades right now, based on the current priority dates. And people do get better job offers, like as they are progressing in their career, they get better job offers. And USCIS, I think, has made it easy for everybody. So the current rule is, if your I-140 is approved and more than 180 days have passed, so after the approval, uh, tomorrow that I-140 can be used for transfers, for 6-year extensions, for H4 EADs, and so on. So what that means is, you can get a transfer done. Your new employer can use the old I-140 from the other company, and they can use it to get 3-year extensions. So that I-140 is still valid. The I-140 still will belong to you, and you should be able to get 3-year extensions. And the new employer can still use that old I-140 to do the transfer and get you the extensions.
There you go, Ganesh. All the best, and thank you for participating with your question. Now let's take up Sudhir's one, Chand. Sudhir is asking, if my perm is denied but I'm close to my 6 year limit, can I apply for another H1B under the cap exempt category, or is my only option to leave the US?
You- Um, so normally, if your perm is denied, the company should be able to file a motion or file an appeal, and then go back to DOL, and the doing so. So if your case, so if your company is appealing your denial, the good thing is your company should still be able to apply for 1-year extensions, because the perm is denied. But again, if the company is fighting it and company is filing a motion, filing an appeal, uh, while that thing is in process, your company should be able to file for extensions. So you don't really have to leave the country. And if the company is going to fight your denial, you might be able to get extensions. Uh, and the other question, can you apply for another H1B under cap exempt category? So if your 6 years is done, because a lot of people will be in this spot where the 6 years period is done, they don't have a perm or they don't have I-140. So to apply in the lottery, to apply in the new H1B cap as cap exempt, I mean, to apply in the lottery, you have to stay out of the country for 1 year. So if you stay out of United States for 1 year, then you can again come back in the lottery. If not, technically you have to argue under the cap exempt category and try for extension. Okay, so you can't go through the lottery if you have been in United States, you have not left the country. If you left the country for at least 12 months, then you can go through the new lottery and again get fresh 6 years. But if not, I think in your case, your best bet is your employer will fight the denial, go back to DOL, fight the denial, and based on fighting the denial, based on filing the appeal, you might be able to get 1-year extensions.
All right, so you mean if it is a cap exempt category, it doesn't count within the 6 year limit, does it?
Yeah. So if cap exempt means they don't come under the
Mm.
lottery. So they're exempt from the cap. So what that means is you have to prove that you're exempt from the cap. And the way you'd show it is you'll show that you have been counted in the cap, which in this case it is very easy. He has a previous H1B approval. So he will show that H1B approval to show and argue that he's exempt from cap. But then again, the next challenge is if you're exempt from cap, you can only use a max of 6 years. So if you cross 6 years, you need to have the perm. In this case, since the perm is denied, by appealing and by fighting the denial, he might be able to prove that he's still cap exempt.
All right. Thank you so much, Chand, for taking that up. And now, quickly saying hi to Srinivas. Thank you so much for joining us on YouTube. I wonder where you have joined us from. And he has a question, Chand. Hi. I completed my H1B 4 to 5 years out of 6 years back in 2017 and spent 7 years outside US and came back to US in 2024 on extension. Does it reset my 6 year period? I still have 7 months left.
No, it does not reset the 6 year period. So, if somebody has completed 4.5 years on their H1B, so when he went out of the country in 2017, spent some time and came back, he is only eligible for that balance period. So he has already used 4.5 years. So the balance period is 1.5 year. So that 1.5 year is what he can use when he's coming back. If he wants to get the entire 6 years back again, you will have to go through the cap lottery, and then by going through the cap lottery, only then you'll be able to get your 6 years back. If not, in your case, because you are using your prior H1B, so whatever is the balance out of that 6 years, in your case, it is a year and a half. That is all you can get, and what that means is you really have to get your perm either certified, or at least it should be pending for at least 1 year to qualify for your extensions.
Right. All the best, Srinivas, and I hope that you figure out soon. Thank you, Chand. And we have addressed some of our questions from the viewers. We will also address some questions from Facebook groups. So, Control, if you can also display them, please. And also, friends, I would like to tell you, you can join us on call. And all you have to do is dial this number 425-436-6335, and the access code is 988-888. And also, please feel free to comment wherever you're watching us right now. And if you haven't as yet subscribed to our channel, subscribe to Immigration Talk Show. That's our handle. And you can also find us on LinkedIn, Facebook, X, and also on Instagram. So this first question, let's take it up. It is from Bilawal. It's from LinkedIn asking, I want to apply for an H1B visa process. Okay, that is it. So what do you suggest this Bilawal should do?
So yeah. So the good thing is right now the H1B lottery, the H1B registration, it's in process. It just started on March 7th. It will end on March 24th. So the first and foremost thing that anybody wants a H1B should do is find a bona fide and a genuine employer. So that is the very first step. And that employer should be willing to sponsor and have a job offer. So if a company has a job offer, that company will have to enroll somebody, register somebody in the H1B registration process, the process that has just started. After that, more than likely we'll have a lottery. We have been having a lottery every year for the last decade. So assuming that the lottery is done, and if somebody is selected in the lottery, then the company will have to file the actual H1B with United US CIS, United States Citizenship and Immigration Services. And once that H1B is approved, you will have to go for stamping and then come into United States and then work on H1B. So the bottom line is you need to have an employer. You need to have an employer that has a job offer, and that employer should sponsor you, put you in the lottery, get that selection, and once that selection is done, file a formal H1B petition, and then get you into the country to start working on H1B.
Okay, okay. Thank you so much, Chand, for taking that up. And also, Srinivas from some time back is saying thank you. Thank you, Srinivas. And if you have any more further questions, keep commenting. And now let's go on to our next one. This next question is from an anonymous participant asking, hello everyone, I'm currently on H4 visa and I have 11 years plus experience in IT, 7 plus as clinical SaaS programmer, and the 4 years as a senior associate. I need, yeah, I
Senior
need to
associate.
know if someone can help me register for H1B 2025 lottery.
So again, I think it is very important that everybody works with an employer who is reliable, who is genuine. And I think what you should do is you should look at job postings on LinkedIn, Dice, the websites that a lot of technology companies use. More than anything, I think what you should do is you should do your own background research on the company, and Google is like the fastest way to start off research. See if that company has filed H1Bs in the past, if that company is big, and also try to get like some individual referrals. Don't go with, because H1B side, majority of the companies are good, but there is always fraud. And the H1B is something where you should always work with companies that are genuine, that are reliable. And what that means is try to do your own independent research, try to get referrals. I mean, like, if your friends have worked with some companies, and it's first hand information that the company is reliable, that is like always the best way to verify things. And then you always should look at like this reliable websites. And next and the foremost thing that I think I should warn everybody is H1B is something where the employer has to pay the fees. Employer cannot demand fees from you. Employer cannot ask you to pay any fees, whether it is legal fees, whether it is government fee, or whether it is an extra money for doing the H1B process. So my thing is, if a company is asking somebody to pay, they're asking you to pay some H1B fees, the company is definitely, I mean, you have to think twice before going with that company. It is very important that the company pays for the H1B fees. At the stamping nowadays, when somebody goes for stamping, these questions are asked: did you pay for the H1B fees? Has the employer charged you? At the port of entry, even if you get a H1B visa, entry is not guaranteed. At the port of entry, again, that question will be raised. At site visits, that question will be raised. So the bottom line is, if a company is sponsoring H1B, the company has to not only sponsor you, but also has to bear all the fees associated with H1B. And that is one way you know that the company is reliable. And always do your own background research, Google and all these places, and then you cannot pay the H1B fees. H1B fees is something which the company has to pay.
Right, right. And with especially the fee increase, I'm sure that many companies are going to think about who to spend for the $215. But yes, thank you so much, Chan, for taking that up.
Yeah.
And we have more questions. So, Control, if you can display that, please. Mohit is asking, hi all, I find myself in a strange situation. I got laid off today. The company refused to sponsor my visa in November. I have been trying to switch before the lottery deadline, but have been unsuccessful so far. I have 5 months to look for a new role. This could this would have been my last lottery attempt. My STEM OPT ends in January 2016. What are my options? And is enrolling for a day one CPT course worth it? Will employers whom I interview will with willing to bring me on just on my day one CPT? Sorry about my flumming. And any guidance is appreciated.
Sure. So if somebody is on STEM OPT and they got laid off, they can be unemployed for a maximum of 150 days, and that is where I think the 5 months is what the person mentioned in their post. So one can be unemployed for a max of 5 months, and anything more than 5 months will be treated as being uh, uh, failing to maintain their valid status. So up to 5 months, yes, one can be unemployed, but if they cross it, there's a problem. And before 5 months, they have to find a job. That being said, uh, because his STEM OPT is expiring in January 2026, and what that means is, if he does not have an H1B sponsor, if he does not have an H1B employer file for him this year, uh, in January,
Mhm.
his STEM OPT is going to expire, and he'll be out of status, and he'll have to leave the country. So again, pretty much it is pretty important that he finds a sponsor before March 24th. And if he does not find a good employer, a bona fide employment before March 24th, what that means is more than likely he's losing his H1B chances this year. And come January, he will have to leave the country or change to another legal status. So I think he has a risk. But the good thing is there is another couple of days, and if you find an employer before that time, you get an H1B registration done, you get selected in the lottery, you'll be in good shape. If not, I think I do see a challenge. And day one CPT is always questioned by USCIS. Day one CPT has a lot of restrictions. It is legal. The only thing is you do have to make sure that you're following all the requirements, you're attending classes, you're progressing towards your degree. And not only that, the CPT should be integral to the curriculum, and then there should be a compelling reason why day one CPT is required by that particular university, by that particular program. So for this reason, we always see a lot of RFEs for day one CPTs. So it could be legal. The only thing is, because there is a lot of burden, you always have to think twice and make sure that you're following all the rules of CPT before getting enrolled in a CPT program.
Okay. Thank you so much, Chand, for highlighting some of the challenges of day one CPT as well, and yes, taking that up. So now let's go on to our next one, and this is from Angela. I'm Angela, currently pursuing my business administration degree and will graduate in May 2025. My EAD card is approved and I'll be ready to start work on July 14th, 2025. I'm looking for any job opportunities in business related fields and would love to connect. If you know of anything, okay, this is probably somebody looking for a job, but control if we can have another question and be. This is from Sagnik. My previous visa was F1. Have scheduled a Dropbox for H1B visa, first time stamping at Chennai for March 7th, 2025. Do I need to channel and schedule office and interview? My hometown is Kolkata. Can I schedule for both office and interview in my hometown? Can I reschedule the appointments now or do I need to wait till March 7th?
I'm not sure. I think the poster's prior visa was F1, and so I think the current visa, I think, is scheduling for a Dropbox H1B visa stamping. Um, so I think so. What has happened is recently they've changed rules, and now if it is first time H1B, they still have to go for Dropbox, because in the new rules, what has happened is one is eligible for a Dropbox only if they already had a H1B in the past. And not only that, that H1B should currently be active or should have expired in the last 12 months, a very recent expiration of the H1B visa. If that is the case, now they're eligible for Dropbox. And because of that new rule that came out in February, what is happening is anybody that does not qualify for a Dropbox appointment, interview waiver, all those appointments are being cancelled by the consulates, and they're being rescheduled. So in this case, more than likely it is better for you to reschedule it if the consulate has already not rescheduled it. If not, more than likely they will cancel your appointment, because in the old rules you're qualified for a Dropbox, but in the new rules, because this is first time H1B, your prior stamping was with F1B, sorry, with F1, you definitely will be called for an interview. You will not be eligible for an interview waiver. So definitely you will have to check with the consulate. Maybe they already rescheduled it, they already canceled your appointment. If not, it's better to reschedule it and go for an in-person interview.
Okay. All the best, Agnik, and thank you so much, Chand, for taking that up. And we have Srinivas actually back again, so I think we should take them up as well. So let's address Srinivas's first. I am in my sixth year of H1B, and my employer has not started the perm process. I still have 7 months to complete 6 years. Are there any options left for me to continue?
So if the company has not started, so basically when your company applied for your H1B, more than likely last time they only got 1.5 year. So they did not even probably have received a 3 year approval. So if you look at your approval, you more than likely see that it has been approved for a year and a half, because looks like you've used up 4.5 years previously, and you only have year and a half left. So at the time, you're close to getting your H1B done. In the current fashion, you more than likely will not be able to extend it. So the only way is your company will have to start the perm process. And if they at least start the perm process, some people, what they do is the company will start the perm process. You go to India, and you're probably working from India, and then that gets you to that 1 year deadline, and then your company will apply for an H1B extension and then bring you back in. So you definitely will have to talk to your employer and see where your case is, your perm cases, because you more than likely you would have a challenge when it gets to your extension time period. And looks like you don't really have a lot of time for your extension. So just check with your employer to see when your H1B is expiring. You probably have a copy of your approval, and try to get your perm processing at least started right away, because worst case you might be able to recapture, travel to India, work from India for a couple of months, add that timeline, and then apply for an extension.
Right. Thank you so much for taking that up for Srinivas. Thank you, Srinivas, once again. And we have Sakshi now asking another question. Hi, Sakshi. Thank you. Yes, we could definitely take up your question. And she's asking, can we able to change employer with I-797B consular approved copy while I'm on STEM OPT? What might be the complications involved?
Sure. Definitely, it can be done. We have done that a number of times, and it should not be a problem in general. So the only issue is you're assuming that your approval copy has not been revoked for fraud or misrepresentation. The prior copy, the prior counselor approval copy, if that has not been revoked for fraud or misrepresentation, you should not have a problem. You can either have the same company file for a change of status, you can change your employer, a new employer can file a H1B for you under change of status or as counselor process. And the way they would do it is they would argue that you're cap exempt, you've been counted in the cap previously, your approval copy is proof that you've been counted in cap, so you're cap exempt. And based on that reason, the new employer can transfer and can file a H1B for you. You should, I mean, unless there is a revocation, unless there is some fraud or misrepresentation in your prior approval, if that has not happened, I don't think you should have any problems at all.
Absolutely. Thank you so much for taking that up. And friends, I would like to tell you that you can also join us on call. Why don't you join us on this number 425-436-6335, and the access code is 988-888. So it'll be really nice if you could join us to ask the questions yourself to Attorney Chand. Sakshi, Sindhura, let's take up Sindhura's comment. I am an F1 visa student and would like to understand my path from F1 to H1B and eventually a green card. Could you please guide me through the steps through employer versus self employed? Both.
Sure. So the most common way is through employment. So what you would do is you're an F1 visa, and once your F1 program is done, normally what happens is you typically will be eligible for OPT, optional practical training. And when you get your optional practical training, what you do is that gives you an opportunity to find an employer, because the beauty of OPT is you don't need any sponsorship. So because of that, a lot of employers will be willing to sponsor. I mean, will be willing to hire you. So so a lot of people, they use this OPT, get employment, and while working with the employer, they impress the employer that they're a good employee, and then the employer will sponsor the H1B. So typically, the employer will register you in the H1B lottery, and then file the H1B, and then you start working with them on H1B. And then the employer eventually, what they will do is they will sponsor your green card. And sponsoring the green card is basically filing the perm, getting through the perm, then filing the I-140, getting through the I-140, and then you waiting until the date is current to get the green card. And the country of birth makes a lot of difference. So if you're born in India, for example, India is extremely slow because the dates are backlogged. So somebody born in India will take a very, very long time to get a green card. And if somebody is born in Pakistan or Nepal or Bangladesh, for example, because those dates, they come under the rest of the world category, there is not a lot of demand compared to India or China. India and China are countries that have a lot of demand, a lot of retrogression. So if you're not from one of these countries, typically your process is quick. You can get a green card a lot quicker than these two countries. So that is what is the normal process. The other way is self sponsorship. So USCIS, they passed some new regulations this December, and starting from January, they said that you can self sponsor your H1B. So if you start your own company and you show a business plan, a legitimate business plan, and you show what you will be doing for your own company, you can also self sponsor your own H1B. It can be done. The burden is very, very high because you do have to establish a company, and then you do have to show what your company is doing and all those things. But if you have a great idea and you are a startup, you can self sponsor your H1B. And that's another route. Self sponsorship is a little bit more difficult, which is why a lot of people don't go that route. But again, if you have a promising idea, you have a startup, you have probably good funding, that's another way to explore. But the most common way is you will get a OPT, you find employment, you find a good employer, that employer files H1B, eventually work towards the green card process.
There you go, Sindhura. You have it all there. Thank you so much, Chand, for patiently taking up all these questions and comments for us today in this session. It was very interesting. Well, we also got Sakshi again asking, what should be the minimum pay employer must pay on STEM OPT to employee? Can it be more than I-983 planning training plan? And what should be the minimum in I-983 training plan?
Sure. So the I-983 is a document that the employer has to follow and has to make sure that uh, work is being done as per that particular 983. And when you talk about minimum pay, H1B has a minimum wage. So if somebody's on H1B, you look at the LCA, and the LCA is the minimum that an employer can pay. And when it comes to STEM OPT, the minimum is so USCIS does not say a per se minimum. There is nothing like an LCA requirement, but there are state minimum wage laws. So every state has a minimum wage law. So for example, Texas, it is $7.25 per hour. That's the minimum. Anything lower than that, DOL will immediately step into the picture, and it is a violation of law. And again, some states, for example, some states have $15, some states have more than that. So every state has something called minimum wage, and you can just Google your state and say minimum wage, for example, state of New York, for example, you will see the minimum wage. So no employer, no company can pay anything less than the minimum wage. So pretty much every employer is required to pay at least the minimum wage. That is the general rule. And on top of it, normally what the companies are supposed to do is they're supposed to meet industry standards. So if company is like completely like paying very very low, suppose the industry standard is, the range is like this to this, if the company is like depressing the wages, paying a very very low salary, tomorrow if there is an audit, that company will have to explain, because the goal of the OPT program is not to depress US wages. So the company should try to keep wages at a market level. So even though legally on a DOL side, the minimum requirement is meet the minimum wage, in general, the good practice is the companies should not use the OPT program to depress the US wages. They should meet the market wages. And everybody's role is different. If somebody is working as a software engineer, it is different. If somebody is working as a pharmacy trainee, for example, things are different. If somebody is working as a validation engineer, again, depending on what state you are working in Texas, it is a different wage. New York City, it's different. Bay Area, it is different. If it is a small town, it is different. So that is why what the company should do is they should make sure they meet the minimum wage on a bare minimum, and on top of it, they should match whatever is the market standard in that particular city for that particular role. And if they pay more than that, it is always good. If they pay less than that, that is where there are problems from USCIS, DOL, sometimes even DOJ, because sometimes if things are not being followed and it is depressing US wages, or there's some kind of discrimination or something of that sort, sometimes we see even DOJ, Department of Justice, step in, because sometimes people try to hire people on a specific work visa because they feel that they can give low salary. So we have seen cases where DOJ will interfere and say you're discriminating and preferring people on this particular visa status to pay them a lower salary than the industry standard. So there are so many things. The general rule is if the company follows market standards, they will be in good shape.
Thank you so much, Chand, for taking that up for Sakshi. Sindhura says thank you. Thank you, Sindhura, as well for your question. And now, Geeta. We have I-140, and in the month of June, we have to renew our H1B. What challenges to renew?
So if you already have an I-140, at least you will not have any problems with the 3-year extensions. So the 3-year extensions part, it's not a problem at all. So the next challenge is the company making sure they have a bona fide job offer and proving to USCIS. Prior to January 18th, the rules were a little bit different. Starting from January 18th, they added some more additional burden. Now you have to, if you're working on a client project, you have to show the nature of their assignment. So maybe a purchase order, maybe client vendor letters, etc. So as long as the company is making sure they prove that the job offer is bona fide, they prove that the company is legitimate, I don't think you should have any surprises in your H1B. So at this point of time, in the last 1-2 months, yes, we are hearing a lot of rhetoric about immigration issues with immigration. But on the H1B side, I think the new government, I think they're still in favor of H1Bs. We are not seeing any bad RFEs. We are not seeing any approvals, short-term approvals. Prior to 2020, we used to see short-term approvals, 1 month approval, 2 month approval, 1 year approval, and so on. In the current administration, at least we are not seeing short-term approvals. As long as the company is legitimate, they're able to prove to USCIS, you should not have any problem. I think things are still smooth with the H1B
Okay.
approvals.
Okay. Well, thank you so much, Chand, Yeeta. Thank you so much for your question. And also, don't forget to like Immigration Talk Show. Also goes the same to all you folks out there. I'm sure that you resonated with Chand's response to your questions. Sakshi and also Sindhura, Yeeta, everyone actually. So thank you so much for your questions and for joining us with your questions here on this episode we had today with Attorney Chand Pravathaneni. And please feel free to also contact him, for your consultation, or maybe you really need attention. You need an attorney to guide you with your case, then why not contact Attorney Chand on his number? His number is 817-523-8247. And also you can email him, and his email address is law@spblawfirm.com, and go visit www.spblawfirm.com. Also, when you contact him, do let him know that you watched him here on Immigration Talk Show, and he'll be happy to help you and to even know that. So, thank you so much. Yita also says thank you very much for your answer. Thank you, Yita. And Chance, before we leave, if you have any end note, to leave folks out there watching us right now, um, yeah.
Sure. So one of the things that has been happening with the H1Bs and the perms and I-140s is the timelines are very, very bad. I mean, again, this is not nothing to do with the new Trump administration. This has started in Biden administration. The perm, what used to take, what used to be very, very a fast process, now has become a very, very long process. They've not changed the rules. It is just that the adjudication timelines have increased. So perms are taking almost 15 to 16 months to be adjudicated. And because we have the 6 year limit on H1Bs, I think, and things are not like what they used to be a long time back. Uh, Long time back, we used to see perm approvals 4 to 5 months, used to be common. Definitely, what we're seeing now is kind of pretty rare. And moving forwards, I don't think the times will shorten. I think the times probably will stay the same. And for that reason, I think everybody that does not have an I-140 or perm filing done, you should always like work with your employer and see what they're doing. And if you feel that your employer is not a reliable employer who you think will file the perm process for you or go through the I-140 process for you, you should remember that there is a 6 year limit. So either you have to leave the country after 6 years, or you find another employer, a reliable and a genuine employer who would be willing to sponsor your perm. Because if that is not done and it is sixth year, you'll be like going back and forth, and then you'll be in a very, very bad spot. So everybody be conscious of that 6 year limit and then the importance of perm, and do not wait until the last minute. So doing so, you'll have very less surprises when it is your sixth year on H1B.
Absolutely. Thank you so much, Chand, for joining us today and for sharing with us all these expertise and this knowledge that you imparted on today's webinar. Very important points, and I hope that friends out there took notes as well. And even if not, you can always rewatch this whole episode. Thank you for joining us. It's Immigration Talk Show. Do follow us, hit that bell icon so that whenever we have discussions like these, you are notified. And also, you can call me. You can leave a message on my WhatsApp as well. And my number is 408-335-6444. And you can email me at nipa@staffingly.com. And that's it. Thank you so much, Chant, once again. I'm really looking forward, to for you to join us maybe in the coming week. So yes, thank you everyone for joining us, and for those celebrating Holi, which is a festival also. Happy Holi ahead, and yeah, thank you for joining us today on Immigration Talk Show. It's Napasa saying bye for now. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Napasa, and I'm going to be with you for this session today. And it's going to be a short one today, shorter than usual. We'll keep it at half an hour. So, yes, before we head on with today's discussion and have our guest join us, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, friends, welcome to Immigration Talk Show. Don't forget to subscribe to us, hit that bell icon so that whenever we have discussions like these, you're notified, and also that you stay updated with the latest on immigration news. So, yes, today's discussion is going to be on got an H1B RFE. What are the common reasons and best ways to respond? So, we are going to discuss this with none other than our guest for today, who is John Kostravi. He is the founder of the JQK law firm, president of the educational and media company Immigration Lawyers Toolbox, and also host of the Immigration Lawyers podcast and publisher of the Immigration Lawyers Toolbox magazine. So, as an immigration attorney, John and his team have really helped hundreds and so many out there, the clients, for over the last 12 years to fulfill their dream of living, working, and studying in the United States. So, yes, without further ado, please help me welcome him back to the show. Hi, John. How are you doing today?
Hi, Nico. Thank you so much for having me on. I'm doing good. How about yourself?
I'm doing good too, and
Wonderful.
it's always lovely to have you. So, yes, with the topic of discussion today, what can friends out there expect from this session?
Well, we're going to talk about the H1B process, and there's going to be a focus on like RFE's request for evidence when someone has an issue with the case or the government has an issue with the case and asking for more documentation. But just a heads up, the H1B process is a lottery system for the most part. If you're going to work for a nonprofit organization or something like that, you don't need to join the lottery. But the lottery means that every year there's only a few amount of visas available, and you have to register first. Buy a ticket to the lottery, which is right now. It opened up a week ago, and it's open for another week. So, employer during this 15-day period or so registers online at the USCIS. They increase the fee to be able to register for it to $215. And then in a month or so, they'll release the results. If you're chosen, then there's always a little bit nuances here that I'm just brushing over. But if you're chosen, then you can file the H1B case, Form I-129. The employer does it. The employer does everything essentially in these cases, and they pay for it as well. They're supposed to. If you're submit the paperwork, then you might get a request for evidence saying there's issues. And we're going to discuss that, but I'm happy to discuss the general process of H1B as well, especially because it is the filing season right now.
Yes, absolutely. So, friends, the filing season is on and it'll be on till the 24th of March, 12 noon Eastern Time. So, keep in mind and don't leave anything to the 24th. I think you should finish much before that. So, yeah.
Yeah, we have
John,
people calling us even now for H1B filing, and it's just a lot of fast moving stuff you got to do to make sure it's something we can do.
yes, absolutely. And I think it's always best to have an attorney guide you. So why not contact attorney John Khosravi as well? His details will be scrolling on the screen very soon. And friends, you can also join us on this conversation by dialing this number 425-436-6335, and the access code is 988-888. So, John, coming back to our topic of discussion, I also prepared a couple of questions. So, if you could, tell us some of the most common reasons, USCIS issues a request for evidence or an RFE for H-1B petitions.
Sure. So, the H-1B process is for specialty occupations. And a lot of times the immigration department makes these terms up and then the definitions keep changing every day. And every officer reviews it has their own definition of what a specialty occupation is. Though it's somewhat listed, but that becomes a major problem when they say, okay, this work that they're doing is too general. It's not specialty occupation. Now, if you're doing H-1B as a lawyer, okay, lawyer, they know what it is. But if it's some sort of analyst, it gets kind of vague. So having a detailed description becomes really important. And then another one is just the educational background. Do they have, qualifying bachelor's degree? One issue that pops up for India, which is 95% of the H-1B visas probably, is the bachelor's degree there could be a 3-year bachelor. So sometimes we have to show that there's an additional year of education in addition to that, maybe a master's degree. as well as you could do a 3-in-1 rule. So if you have 3 years of experience in that area after graduating, you could use that as 1 year as well. So that degree background becomes really important. Sometimes you need to get expert letters for it and stuff. And then it really just about whether the job is too generic or it's not expressed right, or it's too entry level of the job. It's not really what the degree needs, or a job that requires a degree per se. So a lot of it is questioning the job itself, and whether it's a proper appropriate job. And then the other, a lot of times, is educational level. Then there's a million and one issues: a person's background, the little, like, typo kind of stuff. Or for example, they say we have such and such work experience, but in the past, the foreign applicant had applied for a tourist visa, never listed any of that employment. So now in H1B, they're saying, I worked for 4 years for this company, but they're like, well, in your B2 tourist visa application, you listed that you were a homemaker. So how did you work for that company? You lied somewhere. Are you lying here or lying there? Which one is it? And these stuff, especially with the technology getting better, where they can access old databases of evidence and information, is becoming more and more of an issue in these kind of in just all cases, but including these ones.
Absolutely, and there's going to be more scrutiny, more, I mean, much, much more than ever before. So, including your social handles
Yeah.
being watched, from what I hear, right, John? What do
Yeah,
you
so
want
I
to
mean,
say
this
about
year is going to
that?
be a completely anything we talked about. These might be the easy problems we're saying. It might be a whole new set of problems happening because there's the Trump administration's here. It's the first cap season that they're going to be under control of. One thing they're adding, it's probably in 45 days going to be added to the new applications, is all the social media stuff in the U.S. as well. They used to ask you for, they've been asking you for if you're getting a visa through the embassy, they're adding to the U.S. But additional stuff, and extreme vetting is coming back, and all sorts of different background stuff and delays. And so H1B is a very controversial visa too, so that's going to be a problem. Staffing issues. So you could submit your H1B case. It might take forever for them to even make a decision, or you might get approved. You go to the embassy interview, and they don't have any appointment times available, and they're backed up. They do an interview, but they can't approve you for a while. So everything is a unknown. Everything I pretty much all the experience I may have, it might not even matter for what's happening. It's everyone's making it up as they go along because everything's going to change. And so it's a fight day by day as this new situation, new regime is in charge of the H1B process.
True that. Thank you so much, John, for that. And now, I have this other question. And if you could tell us, how employers and employees proactively reduce the chances of receiving an RFE, especially while filing the H1B petition.
Sure. Whenever, depending on the job title, especially having really good job duties of what they're doing is going to be really
Mhm.
important. So again, if you're a lawyer or very unique jobs, that's like people expect there to be a degree for and stuff like that. But it's more open-ended. Marketing person, for example, really specifying how their degree relates to it and as much as possible. Having the educational credentials already looked at. Sometimes getting an educational evaluation beforehand, which costs extra money, which a lot of times employers don't want to do. But having that evaluation becomes really important to show that it's equivalent. Having all that paperwork ready. And another thing that employers run this operation, so they're really focused on the H1B portion of it. But they don't, and the lawyers are really focused on that as well. But they might not spend as much time looking at the background of the applicant to see, okay, did you ever file for a green card before? Did you ever do other kinds of applications before? Because we might get the H1B approved, but we don't know if your background's okay. You might have other issues. You might have been some part of some organization that the government doesn't like or doesn't want. Right now, it's a big controversy in America right now where a green card holder, too, not even a visa holder, a green card holder was showing sympathy to Hamas on college protests, and they want to take his green card away. So if you're on social media where you said I support Palestine, then and then you say I support Hamas or Palestine in this effort, that could be used against you and get your visa denied. This has never been happened before. I mean, it happened, I don't know, during communist times with Russia, if you're a communist sympathizer. These are old rules from way back when. But any recently, maybe 30 years ago, there was one random one. It's very rare to use these laws, but they're being used. A law that's rarely, if ever, been used in the last 100 years is being used again. So not only is it just watching out for the H1B stuff, that's a typical kind of thing here, but it's also just personal stuff.
Yes, so true. And that said, Mahmoud Khalil, an activist. So yes, it's happening, and there are problems arising where what we've seen situations like this have never risen before. So at least in the recent past. So Yeah, let's see. Let's go on to our next question. Also, John, if you can also tell us, are RFEs becoming more common due to policy changes, and how has the trend evolved in the recent years?
Well, they went up dramatically during the Trump administration. They had a policy of no deference. So, like, if you had an H-1B approved and you're renewing it, they would start everything from scratch. The policy before was you got to approve before. We're not going to re-adjudicate the whole thing. Trump said everything, redo it from scratch. So that was a big hassle and delays. But then Biden administration went down. The expectation is going to go up. And there's been some changes. The Biden administration, before they left, they updated the policy where they said usually there has to be an employer-employee relationship. So if you own a company, it's almost very difficult to apply for your own H-1B because they'll say, "Oh, you're just trying to hire yourself." That's not the real H-1B. But they opened it up where you could be the majority owner of the company and still apply for an H-1B, but you have to show that you are, a real employee. You get fired and all that kind of stuff. And this is a new policy that has been tested. You could have got away with this sometimes before, but they hassle you. But as a formal policy, that was okay as a new thing. But we'll see if this administration is going to get rid of it or just not really get into it or find problems with it. So that's like a big one that's probably going to happen a lot because a lot of people want to take advantage of this option. If they own a company, they want to file for their own H-1B. So that's something that's going to be happening. But again, they're going to be picking out these whether there's a specialty occupation, going through the degrees, and just delays could be really problematic.
Right. And from what we hear, there could be more RFEs also. So we'll just have to see what could happen this year. And it's really early to say because there just has been the policy shift. I mean, a change in administration and a lot of new things coming up every day. So let's just wait and watch for now. And now let's take up Yuri's comments. He has a lot to say or ask. Let's find out. So Yuri is saying, I am in my sixth year of H1B, and my employer filed for an extension based on a pending perm. The RFE is asking for proof of 1 year pending labor certification. How do we prove this in a way that satisfies USCIS?
So it should relatively be easy. This is based on the AC-21 extension. This is the rules they made about 25 years ago, updates to give this flexibility. So the H-1B has a limitation on how many times you can renew. But if the employer starts a green card case, they file a perm, a labor certification, and the process going forward, then you get 1 year renewals until that process is done, which could take forever sometimes. You just keep renewing it every year. But if you have a labor certification filed or your I-140s pending, you kind of just have the receipt notice showing that it's been pending for a year. So usually you file that with the application as proof that that's happening. I got to see what unique issue may exist here, but usually it's pretty straightforward. This wouldn't be the issue that people have RFE on unless they just forgot to put, or the government didn't read it. It's in there, your application, your extension, but the government didn't just notice. That might be the situation. But here has another question about whether he can stop working if he does a H-1B transfer. So H-1B transfer is if you're working for one H-1B company and you go to another one that wants to sponsor you, you could do that. And the main thing is it has to be timely filed within the grace period, the 60-day grace period. And one thing about that grace period is discretionary, even though they usually approve it, but they made it where they could say, oh, there's no grace period. So it's kind of annoying. The safest thing to be is like working for the first one, immediately request a transfer, and then once it's approved, shift. But having said that, it's usually not necessary. They usually abide by the grace period that they give. But whether you can work, the rule is that as soon as the file gets to the government, you can start working. You kind of wait for you get the receipt notice. But if you get the H-1B transfer receipt notice, you're allowed to start working with the new employer. And so that's a pretty good situation there. I can hold you over. Now, if you have a perm pending, that creates all sorts of other issues where you could transfer the labor certificate to a new company. You probably can in this case because you have to have I-485 pending to be able to transfer I-485 pending for 6 months. Getting kind of technical here. I'm not sure if you'll be able to save your perm with the old employer if you move, but generally, yeah, if you just file it, upon filing, you can start working for a new employer.
Right. Thank you so much, for taking up Yuri's questions and comments, John. We
You
have
got it.
Kritika. Kritika's, yeah, sure. Tell
Same
me.
kind of question. I'm sorry, but it's the same question where you can start working. If it's a properly filed H-1B, you could file. You could continue to do that transfer and work for them. But I must say, I got to see what's going on. So this is general education only. Some stuff might not apply to yours. So I'm not sure. I can't say whether you can work or not because I haven't reviewed your RFE or your case. But generally, you could work once the case is submitted for the transfer.
Okay. Thank you so much. I think it's the same person because they sound the same questions. But thank you so much, John, for taking that up. And now I have another question, and that is if you could tell us, one of the most frequent RFEs, which is related to specialty occupation requirement, and what key evidence should be included, to successfully respond to such an RFE.
Sure. I mean, it's a little bit of the person's background, their degree, maybe their transcripts too, to show what they studied. It goes into what the job is, and a really good description, a paragraph of like what the job entails, what is required, and sometimes you got to jump through more hoops to explain it. There's government website, the OOH website, that breaks down what his job entails and whether it needs a degree and stuff. Using language from there is key, and sometimes having expert letters if the job is really kind of a vague job. Having an expert opinion, there's professors and stuff like that that write letters saying, yeah, this job based on this transcript and what your requirement is a specialty occupation. They describe it. That's something that could be obtained, but it just requires prep because you don't want to. If you think there's worries, you want to get started out soon because preparing all the paperwork for this could take weeks and weeks. And if you get an RFE, there's time limits on when you can respond to RFE. So you want to have a running start on this stuff. You want to know who you want to hire, who's acceptable to write this letter. So it's stuff that, again, as it goes to being proactive to be able to prep for it. Sometimes, the law firms, there's cost to this because extra legal work, there's extra cost for this and that person, fees here, fees there. It's sometimes they might say, okay, we may be good as it is. Let's see if they push back, then we'll spend the time and money to try to develop a response. So sometimes you just do what basically will get it done 50% of the time or more, and you'll save the extra work needed for that. We don't like doing that at our office. We always require to do everything up front, even if it's like extra. But a lot of firms you work for, especially ones we don't do a million cases. Most of the H1B filers are companies that might do thousands of these. So you can't spend the time individually to review all these and do all the proactive kind of stuff. So a lot of their game plan strategy is, okay, we'll file it. If there's pushback, then we'll deal with it. We'll have time the RFE. But our office, we don't like to wait for pushback. We try to be more proactive because we intentionally keep our caseload lower to do that extra work. It's just one of those versus like one of those things that we could do, but bigger firms that usually handle a lot of H1Bs can't.
Well, thank you so much for taking that up, John. I have another question. If you could tell us, how should an employer handle an RFE which questions the beneficiary's qualifications, such as a degree of equivalency or relevance of education to the job role?
So, the lawyer should get a copy of the RFE, but if they don't, immediately talk with the lawyer to review what specifically was problematic in the request for evidence RFE. And then, go back to the employee about his qualifications, see how he can be bolstered to show what it is, and then just rework and re-explain the job requirement, get expert letters, go on the government websites to show what it is, show that in the history of this field and our other employees, they had the same situation. Other employees that are U.S. employees in the same, doing what this person is doing, they also have the same job requirements and background. So this is typical of what we do. You kind of just dig in to document and explain everything that's there. This is typical and is expected in the industry. And again, you get industry letters, expert letters as well. Sometimes there'll be websites that talk about this, trade publications that talk about this stuff too. You kind of got to dig in deep to see how you could answer those questions.
Right, right. Thank you so much. And Control, now if you could display some of our questions from our Facebook groups or YouTube, maybe. But thank you, John, for taking that up so far. Also, meanwhile, if you can also tell us if an RFE requests additional proof, regarding the employer-employee relationship. So, what kind of documentation should be submitted to strengthen the case?
Yeah, this is a tough one when they get you on this, but essentially they want to see that the person who's an employee is actually an employee, means they can be fired and if at will, So if they're not really an employee, they're really like the owner of the company, they can't be fired. That's problematic. So you want to have systems in place, HR documents that say one of the terms are a contract with this person that says you could be fired based on cause and everything. Maybe have a board of directors that have control over this person, their position. Because, for example, they might be the president of the company. They'll say, well, they're at the top of the company. Who's going to fire them? But there's a board of directors that exists that can make a decision as directors to do that. So there are ways to do that. And the new policy by USCIS that came by administration kind of opened it up to say, it's still doable too. This person gets payroll. It's a real job they're doing. They're not doing like the actual work, because they don't want people who are rich and kind of like own a company to say, oh, I'm working here, but they're not really. They have to really show to like what is the job they're doing that day-to-day basis. It's not like being a secretary kind of work, but at the same time, it's not just hanging out collecting checks and making money. What work are you doing that's related to your education? So they're going to be looking deep into these, but my guess is a lot more people are going to be filing this because they opened it up last year. And this issue is going to come up more and more in this season, this year.
Yes, more explaining to do, and yeah, there will be more scrutiny for sure. So,
This
yes,
one,
control.
if there's a
Yeah.
sense that there might be employer issue, you want to like proactively like prep everything ahead of time so that you're consistent from the beginning of what you're saying. You don't have to like clean that stuff up later. You want to make sure everything is all your ducks in a row before you file that kind of case.
Interesting. Thank you so much, John. Now, control, if you could display some of our questions, please, from Facebook groups. So, this is from an anonymous participant asking, my first H1B stamping was outside India. I'm within 12 months of my last H1B visa expiry. I never had an H1B stamping done in India. Am I eligible for Dropbox in India?
So one thing about the Dropbox situation that I'll just say is like there's word that they're changing everything with regard to interview waivers and Dropbox and stuff like that. So anything I say right now within an hour might be different, or it already is different. So you kind of just leave it up to them. You file the case, and then you see whether they say they want an interview or not. But everything's changing so rapidly with visa processing and that I'm hesitant to even give an answer to that one right now. We're seeing like all sorts of different changes, particularly interview waivers, not required to go in person. That's changing.
Mhm. 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 Well, thank you. Thank you, John, for taking that. Now, this next one is from Mohit. Hi, all. I find myself in a strange situation. I got laid off today. The company refused to sponsor my visa in November. I have been trying to switch before the lottery deadline, but have been unsuccessful so far. I have 5 months to look for a new role. This would have been my last lottery attempt. My STEM OPT ends in January 2026. What are my options? And is enrolling for a day one CPT course worth it? Will employers whom I interview with willing to bring me on just on my day one CPT? Any guidance is appreciated.
Okay, so first off, on the STEM OPT, you have a limited amount of time where you can be unemployed, so you have to make sure you don't fill that up. How much is it? It's like I think on I can't remember the exact numbers. On regular OPT, you get 90 days plus extra 20 days for STEM OPT. I can't remember exactly, but make sure you don't use up that time. Now, the problem with STEM 1 OPT is it's not per se a problem, but first of all, you have to go back to school. So you have to start a new school program, and so that's new F1.
Mhm.
There's a lot of fraud and abuse that potentially happens in day one CPT. A lot of people use it, no problem, but especially the Trump administration, you got to be kind of cautious. Make sure it's a legitimate program. If you go to that course, that's that school, you go to school as required. There's tests, there's exams, whatever school requires, you pay the fee. It's not just a front where they collect money, you don't show up, and just give you work authorization this way. So there's that risk that exists with first day CPT. But with your question, will employers who interview with willing to bring me on? That's an employer. That's whatever the employer is. That's their decision. I don't have any power or knowledge of what they want to do. So if you could tell them that it's up to them. You got to explain that this is a job authorization. But it's really just, it's kind of like, will they hire you? Let's put aside, let's say you're a U.S. citizen. I don't know if they're hiring you now. So it depends on how much they want you and how needed you are.
Mhm. Well, thank you, Mohit, for your question, and also John for taking that up. So let's go on to our next question. This is from an anonymous member. I'm seeking assistance from anyone with experience in this matter. I'm currently in the process of changing my J1 visa to H1B status within the US without returning to my home country. I recently got married, and my home country may be on a travel ban list. My question is, if I obtain the H1B visa, will the ban impact my wife's ability to secure an H4 visa, considering I do not plan to travel back home? Can the ban affect her H4 visa status if I have an active H1B?
So this question about the ban is something I get all day, every day for the last several weeks. There is no at this time recording. There is no ban. They're just rumors and newspapers and stuff like that. So unable to give legal guidance on something that's not law. I'll just be making things up. So it's illegal for me to do that. And there's a lot of clickbait online of people talking about this because it gets a lot of attention. But there is nothing written down that's this. So I can't speak to hypothetical. Hopefully the ban is applied to you, but we don't know if there is a ban, what it would entail. If there's exceptions to it, there's loopholes to it, or what. Now, if you do change from J1 to H1B, you're even if you don't leave, your spouse, generally speaking, let's say they're German, a country that's probably not going to get a ban. Your spouse, even though you didn't get an H1B visa yourself, just status in the U.S., your spouse could potentially apply for the H4 and come. You don't need to have the visa yourself; just the status is fine. But with regard to bans, it's impossible for me to answer. Potentially, if you're married, without returning to my wait, say I currently in the process of changing. I recently got married in my home country, maybe on travel. So, how did you get married? So, if you haven't left for your home country, or maybe you left with J visa, came back, but you can get the beach. I don't know. But if you're married lawfully, you saw each other, it wasn't like an absentee wedding kind of thing. Maybe if you haven't changed, if you get the J1 as soon as possible, maybe too late for them to come as soon as possible. That's the only other thing I could say. But there's no official ban yet. So I'm going to go do a Google search right now. Let's see a travel ban if the news popped up. But there's nothing I can answer that. Even if it did come out, just read it, so I can't answer that. But travel ban trends. Okay, so it's just rumors right now. There's no official travel ban this time.
All right. That's interesting. Thank you so much, John, for that clarification, because I think there are folks, who have been wondering what if a travel ban is imposed, and especially if it's their country on that list. So thank you, John. And now, if we can go on to our next question. This one is saying, hi everyone. I had my H1B visa interview in the US consulate in Toronto on January 7th, 2025 at 9 a.m. Okay. The officer approved my visa, took my passport, and gave me the Know Your Rights pamphlet. However, my CEAC status changed to refused on the same day. Since then, the status keeps getting updated every Monday, but it still says refused with only the date changing, no emails or additional document requests so far. Has anyone experienced this before? And how long did it take for your status to change to issued? Should I reach out to the consulate or is it just a normal delay?
So this is like the horrible situation people get involved. Refused doesn't mean denied. It means they're doing additional research, review, and the like. And it comes a black hole many times where it just gets stuck. It's hard contacting the embassy in Toronto. I don't know if there's even a way to email them or contact them, and if you do, they'll even answer. But it's just, if it's been pending for 2 months now, over 2 months, yeah, contact them. Say, is there any documents needed or stuff? It's best to consult with an attorney to review what happened. There may be confusion about one of your documents that we could notice and be like, okay, this is the issue. Let's proactively contact them or contact the senator, or the employer contacts the local senator to say, hey, this document didn't make sense, but we have clarification. Maybe that'll help do the homework for the embassy to solve it if that's the issue. But we don't know what country you're originally from, what background issues you have. There could be other things that we don't know about that are problematic here. So it could be just normal. It could be there's major problems. We just don't know anything about your background. But the fact that the date keeps changing on it means they're continuously working on it in some fashion. That every time they touch the case, they update it on the CEAC website. But there's no timeline for administrative processing when you get these refusals. It's called administrative processing refusal. So you just want to try to solve the issue. But if you're like from a country like from Iran or something like that, these things happen all the time, and there's like 6 months, 12 months, 2 years of waiting because it's national security review. Those are open-ended. Hopefully it's just a document issue.
All right. All right. So this is the last one from our Facebook group. My first
Actually, we
H1B
went over
stamp.
this one. Is there another one? This was
Yeah,
about
we
the
already did this.
yeah, John
Yeah.
Markson. We did this one as well. So if
So
there are
we,
no other questions, yeah, the main thing is to prepare for the visa process. I mean, it's hard to prepare for anything because everything's going to be changing and delays are going to be happening. The main thing is have your documents ready and focusing on just filling out the paperwork correctly. So most people watching this are probably not the employer, they're the employee. When you fill out your form DS-160, which is your background, make sure it's full,
Mhm.
proper. Don't have your travel agent do it. Don't have your cousin do it whose English is better, something like that, because they're not going to pay attention to answer questions properly. If you've been married before, list your spouse. If you have children, stepchildren, list all of them. Excuse me. You don't want to come back later and say, oh, you didn't list this child. You're lying to us in some fashion. Or you previously applied for his tourist visa. You're denied. You didn't tell us this time. Just make sure everything is properly done. And one thing about this Form DS-160 is once you submit it, you can't access it again. So before submitting, take screenshots of every page so you have records. So if a lawyer in the future needs to say, hey, what did you say in this application? You have copies of it. So a lot of times people come to us, they have no copies, almost every time, because when they don't have a lawyer, they don't save copies. So we have to make a request from the government for a copy of it, which they could not give, or it might take 6 months to get, but it's too much delay. We can't use that. So having the paperwork already ahead of time, it becomes really helpful for future attorneys to be able to see what's going on with your case.
Yes, absolutely. And I think it's always best to stay prepared and, avoid any sort of, misrepresentation. Say
Yeah.
all the information that is required. And thank you so much, John, for that, great session. Short, sweet, informative. And, well, maybe before we leave, if you would like to give out a couple of tips, maybe in the best way to respond to RFEs, maybe just
I
generally.
appreciate that. Yeah, one thing is just reading the RFE well. A lot of times people really get worked up, and then when we come to us, we read the RFE with them, and it's like, oh, it's an easy thing. They just want to copy your passport bio thing page. But like just the idea in RFE just got them so worried and heck that they didn't even read the whole thing properly. Mailing it to the right place, the right address, being mindful of the deadlines, and just keeping like addresses updated if needed. It's really more the basic stuff. The harder stuff, inevitably the lawyer sits and works on it and gets it done. But the mistakes that happen a lot of times are things you wouldn't expect. For example, people doing change of status from a J1 or F1 to H1B, they realize they have some sort of document issues that even though the H1B is good, some of the background paperwork is missing that's problematic or is not timely filed. Like having pay stubs to show they maintain status, for example, they want to show like, okay, you're working as an OPT, now you got H1B, did you maintain it? So it might say, give us pay stubs. So keep all your pay stubs when you're on F1 OPT, a student visa working, to show that you're consistently working. You didn't have gaps, for example. So the documentation is the key. Keep everything you can. Just keep a file on Google, a copy of everything, scan it, take a photo of it, clear photos. A lot of times people take photos. They just take a piece of it, their hands in the middle of the page. For foreigners, no shadows, something like a print, and an officer of the USCIS can read it properly. Documentation is what we do. It's all about paperwork. So you got to just keep good records of everything. And whenever you get a lawyer, it's easier for them to get the job. And it comes cheaper too, because when people come to us and are missing documents, we got to do extra work and the price goes double. But if you have everything for us, we could read it. It's much faster and the price goes down. So it really saves you a lot.
Right. Right. Thank you so much, John, for those awesome tips, I would say. So
Thank you.
thank you for joining us today. It was wonderful having you, very informative, and it's always a pleasure having you on our show. So thank you
So
once
God
again.
bless you. I appreciate you having me on.
All right. So have a happy H1B season, I would say, and I hope to see you soon once again. So hopefully we can catch up soon.
I
Bye
would love it.
bye.
Thank you so much. Bye, everybody.
So, friends, you can also contact attorney John Q. Khosravi, and you can do so by calling him up on his number 818-934-1561, or mail him at info@jqqlaw.com, and go visit www.jqqlaw.com to get to know more about John Khosravi. And also, you can email me or call me or WhatsApp me on my number. And my phone number is 408-335-6444. And email me at neepadstaffingly.com. So thank you once again, friends. Don't forget to subscribe to our channel, hit that bell icon. And our handle is Immigration Talk Show. We are not only on YouTube, but also on LinkedIn, Facebook, X, and also on Instagram. So check us out, follow us, and connect with us. Thank you. And yes, stay tuned on Immigration Talk Show for more on immigration. Bye for now. Hello, everyone, and welcome to Immigration Talk Show. I'm your host, and I'm going to be with you for this next hour, this session which is lined up for you, a very interesting one and a topic which you would love. So stay with us. And before we head on with the discussion of the day and also have our guest join us, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, I hope that you've kept that in mind and welcome once again to Immigration Talk Show. And today's lined up discussion is going to be a very interesting one. The topic of discussion is, can H1B visa holders be detained? And we're going to try to understand the immigration policies and also the risks involved. But yes, there is increasing immigration enforcement, evolving policies, high scrutiny, and so much happening, right? Especially with this new administration coming into the picture. Well, we also have many H1B visa holders and employers who are very concerned about the potential risks, and especially when it comes to compliance, legal pitfalls, and even detention for that matter. So, today we're going to discuss with none other than this very distinguished guest who's going to join us today. And she's none other than Isadora Velasquez. Yes, please help me welcome her. Hi, Isa. How are you doing today?
Join you. Well, very happy to join you. I'm doing very well today, and I'm sorry we have to discuss this topic, but I think it's really relevant, as you mentioned in the introduction. There are detentions going on today. It is a bit of a promise that we had from the administration that took over. So it's good to know our rights and what we can do to protect ourselves and whether we can run the risk of detention under this current precedent that we have. So I'll let any of you ask me questions, including, of course, of you, Nipasa. So take it away.
Thank you so much. And folks out there, we have attorney Isadora, who has dedicated over 15 years to immigration law, fighting for individuals and families, in a wide range of cases. So please feel free to join us with your questions. And yes, we also have a phone number actually where you can on call to ask the questions yourself and maybe even get onto a short discussion. And the number is 425-436-6335, and the access code is 988-888. So, yes, Isa, like you said, this is a very timely topic, and it's crazy because it's not like earlier, when you talk about H1B this year. And there have been changes, of course, since fiscal year 2025, we saw that. And now the fee hike, and so many things are, governing what is happening to H1B right now. So, where should we start? What can people out there expect from today's discussion?
Okay, so when it comes to detention, I want to point out that it's not that the law itself has changed. Nothing has actually changed when it comes to detention. The elements, the requirements to detain anyone in the United States are the same. What has changed is the intensity in which these detentions are occurring. During the campaign, we heard a lot from the Trump or current president about conducting mass deportations. In order to get to the level promised, detentions had to occur. What we've noticed in the first 100 days of this presidency is a large volume of detentions. Most of them have not led to the deportations promised because there are due process and steps that need to be taken for these deportations to occur. People have rights and you can present your case before a judge. But we have noticed that many cases that normally wouldn't lead to a detention, that would normally lead to a case maybe let go or just overlooked, are now being processed in detention. So that's why I appreciate having the opportunity to explain when a case, particularly an H1B visa, could be subject to detention, so that we know it's not a change in the law. It's just something that we need to be on the lookout. Obviously, the most common way is we need to understand that a visa can be revoked in all candor for any reason. The U.S., the same way they issue the visas, they have the authority to revoke said visas. The most common way to revoke a visa is when we are accused of a crime. This is an important distinction because we don't necessarily need to be actually convicted of a crime. The simple accusation is enough. And this is also important because the government recently passed significant law, a new law called the Laken-Riley Act, that also encourages the government to actually seek forward detention of anyone accused of certain crimes, particularly violent crimes or crimes of theft. So keep that in mind, that if you are accused of a crime, of course, that will lead to the revocation of your visa, but it would definitely lead to your detention, but based on this new law. If you're coming in through the airport, that is typically the most common way for H1B holders to be detained, because that's typically the most common way in which they tend to find out whether or not their visa has been revoked. Based on past experiences, the Muslim ban was very controversial back during the prior Trump administration. And it was a very controversial way in which people found out their visas being revoked. And it actually led not so much to detentions, but to people not being allowed into the US, even when they had a valid H1B visa. So far, we haven't received any announcements of any potential bans. We have received potential travel bans for particular countries such as Cuba and Haiti. They have yet to go into effect, and we don't know if they will affect visas such as the H1B visa already issued. We will keep you informed if that were to happen. But revocation of visas, to answer the broad question, would be the main way that H1B holders would be detained if they're already in the US. And now, if they're coming into the US and they seek to come in, they could be detained seeking to come in if they're either to be returned or to simply not allowed into the country.
Mhm, mhm. And when you talk about the Muslim ban, I'm sure you know there are folks already in the United States from maybe few from those countries. What's going to happen to them?
Well, the Muslim ban, although it was upheld by the Supreme Court, what was interesting about that particular section is that it only affected individuals who were already out. So if you were in the US when the Muslim ban went into effect back then in the prior Trump administration, it didn't revoke your visa in the US. It simply meant that when you were trying to come in, it wouldn't allow, you were not allowed into the country. It did force many attorneys like myself back then to make sure that the visa that you had, that the status that you had was being enforced, because there's a difference between seeking admission. When you're coming into the airport, you're seeking admission, and that's where people found that their valid visas were not eligible to come into the US. But for people who were already in the Muslim ban, they were already admitted, they already had a valid I-94, and although their visas may have been revoked based on the Muslim ban, meaning they couldn't no longer travel, their I-94, which is the document we received letting us know how long we could stay in the US, allowed the individuals to stay in the country for the amount of time allowed. So for the individuals who were already here from the countries listed in the Muslim ban, they're okay as long as their I-94 allows it.
That is very interesting. And I think at this moment, we should just not travel, stay in the United States. And what do you say, Isa?
Yes, I would recommend. I know it sounds sad and extreme, but I agree with you, Nipa. I think if you have your I-94 and it has a set amount of time, very important. I encourage anyone watching, check your I-94. If you don't know where to have it, you lost it, you've never had it, I maybe we should put it on the chat. There's a website where you can find the status of your I-94. And once again, this document is the one that tells you how long you're allowed to stay in the US, and take advantage of it. It will tell you when you're supposed to leave. And as Nipa said, don't travel unless you have to. I know it sounds sad. We want to visit our friends and family, but now is not the time. Things are interesting. There are many changes happening. We wake up every day to a new executive order. Until things settle down and we know exactly what's going on with immigration, let's stay still and not travel for a while.
Yes, good one. Thank you, Isa. And with that said, and what you were just speaking earlier, do you have any cases or examples of recent cases this year, where H1B visa holders were actually stopped and at the airport and even detained for that matter? And what could be the main reasons?
Yes, and I'm actually going to go and take advantage to answer your question and go ahead and answer Vika's question. So Vika's asked about she has been on an H1B for 3 years and heard about somebody getting detained at the airport after returning from India. Why would this happen? That has actually been a case that I have dealt with recently. People returning with H1B. Why would it happen? And that's why I gave the example of my clients being accused of crimes returning on an H1B and getting detained at the airport, and at the airport finding out that the simple accusation, what we may sometimes may call an arrest warrant, was enough to have that visa revoked. So it's very important that we keep track of our visa, the same way I mentioned before, keeping track of our H1B. We need to understand that the U.S., when it comes to visas, and this is not just for H1B, it can apply to a student visa, it can apply to all visas. They can be revoked unilaterally by the United States government. So if a visa is revoked, you could be detained coming from any country at the airport because you are seeking admission. Now, when you're detained at the airport, one of two things could happen. The government can ask you to withdraw your admission, which would mean that you're simply choosing to go back, or you can state the reasons. You can try to fight your admission. Understand that if it is that your visa is revoked, they have to state the reasons, but they also can, coming into the US is the analogy of coming into the club. If I don't like your outfit, I can tell you no sneakers allowed, and I'm not going to let you in, and I'm not going to let you in. The only people who are allowed into the club all the time, no matter what, would be US citizens. Not even residents have the privilege of going into the VIP room all the time. So because of that reason, keep in mind that even if you want to fight for your right to get in, you might not have the right to do so. The only way to fight all the way to get in is if you're seeking asylum. So the only way to actually push for your entry would be to seek asylum, argue that you are afraid to go back home, have a credible fear interview. Be very cautious with this, as they would close your door to go back home. Personally, I would not encourage anyone to seek asylum, to have what they call the credible fear interview, unless it is absolutely necessary. Coming into the US seeking asylum solely to continue working, I do not believe it's the best choice if in case a visa has been revoked and for any reason they're not letting you in.
Well, yeah.
The question continues to worst case scenario, if you get detained, how long could you be held in the process to get released? And I kind of hinted as to the worst case scenario. The worst case scenario is when they're not giving you a chance to explain, when you haven't been allowed visas at the airport in particularly. It's not a place where you can appeal a decision. Once a visa is revoked, there's not an appeal process. It's not when a visa is denied at the embassy where you can apply again. It is revoked at the airport. There's not an appeal process. You could be detained up to 24 hours until they send you back. So the worst case scenario would be just that you have no other choice but to seek a credible fear interview in order to come to the US. Understand that, for example, if your visa were to be revoked, as one extreme example, because they think your employer is not real, or because if they're a student and they think you're not studying full time, or the example I gave because of any criminal history, you don't have the right to appeal the particular circumstances of the revocation of your visa at the airport. You can only fight to come to the US to seek asylum. So that's worst case scenario. You can only either go back home or seek asylum to come to the US. Sorry about that.
I know it doesn't sound really pretty, but also when you talk about, crime, for a person under H1B, crime, whether you're talking about the home country or in the US or both ways, it's still a crime.
Both. Keep that in mind as well. Sometimes it's a very interesting question because we are asked, have you committed a crime? And we tend to respond, where? Understand that when the US asks the question, it means anywhere. And technically, they do have access to all the records anywhere. So we may think, oh, but I have never committed a crime in the United States. But what about that DUI or that minor marijuana charge that I have back in Canada? Well, the US may be aware of it, and maybe it was legal over there, but it's not legal here in the United States. We need to be very conscious of that. And sadly, these are minor things that they can use against us. And again, these are minor things that you can fight and appeal to reapply for your visa, but there might not be things that you can fight and appeal to enter the US in case you're stopped. And there might not be things that you can fight or appeal if you're in the US and you are detained to seek your deportation. And we need to make that distinction. There's a big difference if you're detained coming into the US at the airport, in which your only choice would be to, like I said, seek asylum or get kicked out,
Mm-hmm.
Or if you're in the US and you have an encounter with ICE officers and you are detained in the US in an encounter with ICE officers and you are detained, you do have certain rights. Only an immigration officer can remove you. I'm sorry, an immigration judge can remove you. If you have been in the US for more than 2 years, and this goes back to the individual who mentioned that they have been in the H1B for 3 years, if you have an encounter with ICE and you are detained not at the airport, but in the US, you have the right to appear before a judge, even if your visa is revoked. And there you may have the right to fight for why your visa may be revoked. So that's the big difference between at the airport, where your rights are very limited. You may only have the right to go back home or to fight for asylum, while in the US, where you can fight for why is your visa being revoked? Is it because they're alleging that your job is not real? Is it they're alleging you're not really a student? You can fight for it if you are detained in the US, while it's different if you're detained at the airport.
Okay. Thank you, Isa, for taking that up. And it relates me to this question from Chandra asking, if I get arrested for something minor while on H1B, does that automatically put me at risk of detention?
Yes, because, and I'm sorry to answer so quickly and so adamantly, but yes, because technically the Department of State can automatically revoke your H1B. We see that this used to seldomly happen. If it was something minor, shoplifting, smoking a joint, we noticed that H1B wouldn't be affected by it. But lately, or in certain administrations, H1Bs could be affected by a minor DUI. So keep that in mind. Because the H1B could be affected by minor crimes, any visa could be revoked by minor crimes, leaving you without status. Yes, you could be detained by being without status. If a visa is revoked, you lose your I-94 status. The argument here would be that you remain legal until your I-94 expires, which is why I encourage everyone to keep checking your I-94 regularly, because the defense for anyone whose visa is revoked while in the US is that you're still allowed in the US for the time allowed when you came in on your I-94, which once again is a document that allows you to stay in the US for the time mentioned in it.
Mhm, mhm. Right. And, before we really started this program, we were talking about scrutiny, social media. So, of course, there has been a lot of changes, especially with the new administration coming into the picture. It's President Trump now. And how has these, latest immigration policies changed things for H1B visa holders? You're saying that there's not real change in law, but there are changes happening and it's governing. Even it's affecting H1B visa holders for sure. So, are they facing more scrutiny now?
Correct. You will notice that your applications will get a lot longer. They will include a lot more information that are already there, but in greater detail about your social media. You may notice the lines at the airport also getting a little bit longer, maybe because of shorter staff, but also because this already started before, but now it has been announced that it will be done with greater scrutiny, as Nipa mentioned. The going through your phone, the checking your social media, and by the way, this is also going to be done allegedly to U.S. citizens, and it's not just with this administration. It was announced with the prior administration as well. But it has been emphasized that for all visas, not just H1Bs, there will be greater scrutiny placed on social media. And now, once again, your phone, your WhatsApp messages. I personally encourage my clients, all of them, to delete social media when you're coming in through the airport. Then again, I must confess, officers do ask you. They find it rather suspicious that you don't have TikTok or WhatsApp or Instagram on your phone, especially depending on our age when we show up. So they will ask you about it. So just be ready to answer. Maybe you're a very healthy individual who has no need for social media. If you're an individual working on tech, it might be kind of interesting if you don't have any of it on your phone. So just be ready to explain it, because yes, there will be a lot more scrutiny on it. And we do expect the visa applications and renewals to include many more questions and to get a lot longer. They keep growing every year and they might be getting longer. If we have any repetition of the 4 years before that we had with prior President Trump, we know that a lot of money was spent investigating people, and this is probably going to be another year, another 4 years of more investigations, just to make sure that when visas are approved, your background check is very clean.
So true, so true. And I think we would just have to say goodbye to side businesses, whether it's even selling a small thing or making a small amount of dollars. But I think, yes, high scrutiny is just going to be there, not just now or just for the next month, but I think it's going to prevail for the whole of Trump's 2.0. So let's get ready for all of that.
Yes.
And yeah. So also, Isa, if you could also tell me about the the talk about fairness for high skilled immigrants act. There has been this talk, and could this really help H1B visa holders feel more secure, or does it not really affect detention risks?
It depends who you ask, because the focus of the act has been more on the caps, but the caps on country conditions, on certain countries, and saying that some countries, particularly India, would be more delayed because there are certain visas issued per country. This is the most you can get. That has been the focus, to make it fair for everyone. No caps. We're just going to apply blindly for everyone. Some people say that's not fair because, for example, the visa lottery, which is a separate visa, is based on people who can't come to the U.S. On other visas, and they apply to the visa lottery because there's not enough diversity of certain countries inside the US. So that's the balancing. There's a lot of debate on it. Personally, the President Trump recently issued an address to Congress in which one of his few remarks on immigration said that the government didn't need immigration reform. It just needed a new president, and he was it. So I do not believe that this act will actually be approved, at least this year, or in the near future, as long as Mr. Trump is president. I do think that if it is tweaked in certain areas, it would be beneficial, but the focus so far has been on the caps for visas, not really on ensuring that protections such as not revoking visas unilaterally are taken seriously. I do hope language is included, because I do think revoking without letting the person know it's not fair. But so far, that has not been the main focus of the government.
I know it's all surprising whether you talk about raids, you talk about anything that the Trump administration is doing just to catch hold and let you off the country.
Yeah.
So that is there. And also, I'd just like to say hi, once again to Chandra, Vikas, and folks out there who have joined us with your questions. Please don't forget to like, share, and also subscribe to our channel if you haven't as yet already. It is Immigration Talk Show on YouTube, and you can also check us out on LinkedIn, Facebook, Instagram, and also on X. I mean, it's just because we were talking about social media. I remembered that I have to do this too. So connect with us and stay connected, friends. And yeah, we have Ayush. I also was reading this news yesterday. So DHS has really introduced this new app where migrants can share their intention to self-deport. So if I
Yeah.
do so, will this ban me from coming to the US forever?
Okay, so let me explain. If for individuals, if you leave the U.S. and you have been in the United States without status, or you enter the country illegally to the border, or you've been in the U.S. for more than 180 days without status, you may think you're leaving and everything's okay, but in reality, you are deporting yourself, and which is really important. So this app, I actually think, is helpful for people who have been in the U.S. for less than 180 days without status, meaning your H1B expired, you didn't renew it, and you've been in the US for less than 6 months without status and you want to leave, it would be helpful to put it in the app, because that way the US will know, okay, you left, and there wouldn't be any negative consequences to you, because you didn't accumulate enough time illegally in the US to have these negative consequences. However, if you were in the US illegally for more than 6 months, the app doesn't really clarify if there will be consequences or not. It will simply say that you will be letting them know that you left. You will be helping the government because they won't have to look for you to deport you. But it doesn't really clarify. It says that maybe later on you could apply for the visa, but the government hasn't really guaranteed that it won't have any negative effect. So what I've been telling my clients is to use it only if they are sure 100%, I know I'm going to leave, there's no way I'm going to stay, I'm leaving, I want to let the government know, then yes, go ahead and use it. Might as well do it because you're leaving. You want to let the government know, but don't use it expecting that by doing so or by reporting yourself, you're going to be able to later apply for a visa and come in with a problems. The reality is that if you stayed in the US illegally for more than 6 months, you
Mhm.
cannot return for 3 years. And if you stayed illegally for over a year, you cannot return for 10 years. And you must apply for a new visa. And it may be that even after the 10 years, you might not be allowed back. So the app is a bit tricky. I think it's lacking some language that clarifies. But if you know you're leaving and you really want to go, might as well report. But don't assume that simply by reporting, you will be okay. There's another important app that I think you guys should know about, and it applies for anyone who comes in. Interestingly, for H1B in particularly, it wouldn't apply immediately. It applies mainly to tourists. Canadians, for example, are very upset over it. And the government has always requested that all immigrants keep the government informed when they're here for more than 30 days.
Mhm.
This is an auto report app, I guess you could call it, or a system, or now all immigrants must report to the government. It's mandatory. It has always been mandatory, but now there's a specific website that we must use. I mentioned Canadians because they have always been allowed into the US without visas for up to 6 months, and now they're being forced to report, which they're not big fans of. But
Mhm.
it has specific exceptions. For example, asylum seekers don't have to report. H1Bs, because you report at the airport, technically don't have to report. But it's important to be on the lookout because the government keeps changing who has to report, who doesn't have to report. I wouldn't want any of you to have to report and miss it and then have your visa revoked over a simple technicality. So keep on the lookout to these executive orders and memorandums that come out, maybe in
Yeah.
case you have to put your information in another website, something simple that you may have to do depending on what the news say tomorrow.
Just like an attendance register or maybe like a biometric system. So different ways, but you still have to sign and let the authority know that you're in the country. So treat it like that. And it's always best to do your research properly and play safe. So I'd always say, if you are confused about anything, or just like Ayush has asked about this new app, I mean, consider consulting with an attorney or an expert who knows all these things at the tip of their hands, and they will guide you in the best possible way. So why not also you can choose to consult with attorney Isadora, and you can do so by calling her on her number as well. Her number is 305-938-0676. And you can also email attorney Isadora at isalawyers.com, and go visit www.isalawyers.com. So thank you for that. And thank you, Isa, for telling us about this other app as well. So,
By the
so
way,
much
the app is
happening, right? Yeah.
called CVP Home. It used to be CVP One. Now it's called
Yeah.
CVP Home. It's not just a self-deport. You can also use it if you're coming to the US, maybe through the border, and you want to get your I-94 ahead of time to make it faster. You can get it up to 7 days before, and it will make your process easier. So it has other tools besides just self-deporting. Just check it out.
Yes. Thank you. Thank you. That was really a good one. And also, we have Neha who's joined in with a question. We'll quickly take that. So, Neha is asking, are there specific warning signs that an H1B visa holder might be at risk of detention? And what should we watch out for? Interesting.
Well, I recommend all my clients, and this is not just in the Trump administration, all my visa holders, when they travel, I always recommend before they come back, check your emails. The Department of State typically announces any revocations, and if they have any issues with your visas via email. Check your status of your visa online prior to coming in, just in case. I do so as the attorney, but just in case, you can be proactive and do so yourself. Check your I-94 prior to leaving, the one that you had prior to leaving the country, if you had one. So it's good to know that you never overstayed. Just in case you're asked, when was the last time you were in the US? How long did you stay? You will feel comfortable answering those questions. Those tend to be the triggers that may lead to an uncomfortable detention. You stayed more than you had to. Your visa was revoked, you didn't know. You did something or committed a crime, or were accused of a crime you didn't know. Sometimes we leave and there's an arrest after the fact, something we didn't know, somebody with a similar name to us gets in trouble and we are accused. So it's just good to check what we can check. When we're traveling, it's also good to have that conversation. All my clients always have my card. The airport is very tricky because it is, I call it no man's land, the same way before I compared it to a club and they have discretion to allow you in or out. You don't have the right to an attorney like we see on TV. You have the right to no, that doesn't apply at the airport. So when you want say you want to call your lawyer, you don't, that doesn't really apply. But if you have somebody's card, which is why I always tell my clients travel with my card, they can call me even if it's at 5 a.m. You can call the attorney, and they tend to have the courtesy. Customer Border Patrol officers tend to have the courtesy, so that would be a good idea to have with you, the attorney's card or at least somebody's card. For example, your employer. If you're comfortable with your employer and you think there might be any issue with your job, it's good to have your employer's card. If they don't know where you work, it's a new place of business, it's good to have your employer's information. Those are warning signs, as you had asked, that you can have with you. Show this is where I work, it's a new place of business. You may not be able to Google it because it's brand new, or because understand Customs and Border Patrol, they're not immigration attorneys and they're not even embassy officers. They're not as sophisticated as we may want them to be, so we can educate them. So anything you can bring with you, as annoying as it may be, to make their life easier, to show how good you are, and that's why you got your H1B, bring it with you, even if your bag is a little bit, your carry-on is a little bit heavier than you would have liked. That would be my advice.
That's a good one. And thank you so much, Isa, for taking that up. And Neha has another question to follow. So, is there any bifurcated data available of people who are detained or are at risk of being detained?
So let me see if I understand your question. You mean like know your rights, or
I think she means like where can she see how many people are detained? Is there a website or somewhere where they can check out the numbers of
yeah.
people who are detained or who are at risk of being detained?
So ICE, ICE.gov, ICE, baby, yeah, like ICE, the ICE. Gov will give you the number of detentions, and it will also give you the number of deportations. And you'll see there's a big discrepancy. And it should have it. But until recently, they were very criticized, the numbers, because they're big. There's a big difference. The reason there's a big difference is because, as I mentioned at the beginning, it's rather easy to detain somebody. You may detain somebody because when a visa is revoked, they're out of status, or they're accused of a crime, but it's something different to deport someone. It's easy to do at the airport, to deport someone because they're seeking admission, so you can tell them, no, I'm not letting you in, and that's different. But when you're already in the US, for people who have been here over 2 years, you can't send them away. They have the right to appear before a judge. And that's where the Trump administration has faced a lot of difficulty. They've noticed a lot of increased detentions, and it's been very difficult in detention centers. So you guys know there's overcrowding in many detention centers. That's why they're using other facilities, like even Guantanamo. But there's not a lot of deportations actually happening because people know their rights. They know they have the right to appear before an immigration judge, and these rights apply to all of you as well.
All right. Well, thank you so much. And Neha, yes, we've already answered that. That's correct. I would like to see the list of people detained. I hope you can find that. But thank you,
Yeah,
Neha, for joining us. Yeah, sorry.
You won't be able to see their names, but you will get an idea of how many numbers. And there's a lot
Mhm.
in ice.gov.
Okay. Well, I wonder why does Neha want to see that? I really hope that you are safe and you haven't done anything that you you would like to see or check if you are in the list. But anyway, jokes apart, thank you, Isa, for that. And also, I have another question about this. The rule for visa interview waivers, which recently changed from 48 months to 12 months. So, how might this also impact H1B holders, especially when traveling internationally?
So what we expect is that it's going to be delays. So before, particularly for any renewals, I'm telling all my clients, if you have to renew, don't wait to apply quickly. Don't any renewals, don't wait. And basically that's the main concern. Renewals are going to take longer because now they're not waiving. And like I said last time, the prior Trump administration cases were going to be taking longer. Because they're going to take longer, that's what we're expecting. Their waivers being shorter, cases are going to take longer. So expect delays. Expect that your case might take longer. So if you were planning to apply when your case was going to expire on this day, maybe talk to your immigration attorney and see if you could apply earlier. I emphasize see if you could apply, because sometimes applying too early might not be the best choice, or you might not even be allowed to apply that early. But check it out. We do. That's what we expect. That's typically what happens when they take away the waiver and interviews. We notice embassies are also saturated. There have been significant layoffs in the Department of State thanks to the Dutch program. So yeah, things are gonna get slower. Be patient. Be really patient, but don't give up. Keep applying. Keep applying. Just be patient and we expect things to be slower. Apply earlier, sooner, quicker, and be patient.
Yes. Thank you for that, Isa. Great tips, I would say. And I think we should just not expect too much, but also at the same time, not lose hope, but keep trying. So, also, when you talk about H1B, it's all about big tech companies mostly, especially, and they sponsor so many H1B visas also. So, do you think their employees also have been facing more issues at the border this year?
I think it's a balancing act. In a way, I think the involvement of Elon Musk and how vocal he was of H1B and his support during the campaign, I am hoping it will reflect in how H1Bs, particularly in the tech industry, will be processed. At the same time, as Nipa has mentioned regularly, I do think there will be higher scrutiny overall, not just in H1B, in all visas. So I expect higher scrutiny, particularly in startups. We notice many questions on companies, whether they're new, whether they're going to succeed, whether they are stable, whether they can afford it. And that's where we expect it's going to get a little bit tougher. But at the same time, like I said, Elon Musk was very vocal in saying that he was here in the US and Tesla is successful because of the H1B program. So that's where we're hoping it will balance out. So be ready to fully understand your company, fully understand your role. So I think interviews are going to get tougher, but at the same time, I do hope that either that the numbers will get higher, that will be the effect of Elon Musk. It hasn't been announced yet, but I'm hopeful that that will happen, or that in the alternative, that it will be more understanding of how we need the tech, because once again, that's how we got Elon into the country. So expect tougher interviews, but at the same time, um, that they said it was good for the economy. So hopefully they'll keep their word in that sense.
Yes, me too. And well, news has it, especially from India, that there has been a very huge drop, when it comes to H1B applications. So I don't know what's going to happen. Will there be enough applicants also registration? What do you say, Isa?
I think with India in particular, the issue has been not so much the tech industry, but the relation between the governments. And if Trump can work better with the Indian government, that hopefully would really work will lead to an increase not only in applicants but also in approvals. That distance between the relationships in the government has also, not only in the H1B area, but it has affected other visas. The lack of reciprocity and treaties between the governments, in India and the US, has affected severely the applications, and it's something that we need. Once it starts affecting the economy, I hope that Trump will extend the arm until it starts affecting the economy. I think we'll see that this will continue. But there is an employee shortage at the moment. Once the numbers start coming down, we'll see the visas increase. That's my hope as well.
Right, right. I mean, so much is happening, and like you said, every day we wake up to new news, new changes, and new rules coming up. So a lot to grasp right now, and we'll just have to wait for things and all this dust to settle in. I think after that,
Yeah.
we will be able to know.
Yeah, remember, I'm sure I've seen your videos, so I know you guys are very aware that the lottery is coming up. I think also once that lottery happens and we see the numbers, that we'll get new memorandum, which goes back to our prior points as to don't travel, stay still, see what happens. We'll get new memorandums how we see how many people apply, how many people we get in the lottery. It will lead to new decisions that will severely affect the H1B, the scrutiny, how many visas may be affected by revocations. So we have a lot that may be happening in the next couple of weeks. So we have to wait and see.
We will. We will. We have no other option right now but to just be patient and still keep trying. So, all right, then. Well, Isa, Neha says, thanks for the information given. This helps. So, I'm sure. Thank you so much also to Neha, for your questions. Very interesting and all the best. So, Isa, we also have more questions from our Facebook groups, and I would really want, Control to display some of them. And meanwhile, if you could also tell us, because if an H1B visa holder gets detained or denied at entry, what are their legal options? Can they really fight the decision? We already touched on this, but what should be their next step?
Entry is very complicated because in entry you're not giving many options, if any at all. At entry, individuals who are you're called an arriving alien. Horrible name, I hate it. But as an arriving alien, you have very minimal rights. You have the right to either withdraw your admission. If they're not allowing you in, you can withdraw your admission and they'll gladly send you back home. That might be best because sometimes when we withdraw our admission, we're simply sent back home without a deportation order. And we may want that if we want to reapply for your H1B visa or for any visa, tourist visa, student visa. For example, if they were to tell us we can't find your employer, so we're not going to let you in because we're revoking your H1 visa because we think your employer's fake. That might not be the time to start arguing, oh, it's real. Like I mentioned before, I encourage you to maybe travel with documents already if you know your employer's new or not as easy to find, to show them otherwise so that you can fight it there. But if you have already tried and you haven't had success, the only other remedy, if you can withdraw and you won't be able to fight the case, will be to seek asylum, which would be to request a credible fear interview, which will actually happen or might actually happen at the airport. Or you may get called back to something called deferred inspection, meaning they call you the next day to conduct this credible fear interview. They're incredibly uncomfortable. You have to show that you have suffered past persecution by the government or an agent that the government cannot control in your country. And that's why you cannot go back, because you will suffer future persecution if you go back. By the way, if you show this, then you'll have an asylum claim and you cannot go back home. So personally, I would not recommend it. If your visa is revoked and you know you can fight this, it would be best to simply withdraw your admission, go back home, and try to fix it there. And that way you avoid a deportation order. Sometimes when we fight this and we start saying, no, you're wrong, I can prove to you that my job is real, that I didn't commit that crime, that is not me, and we are fighting it, we end up with what is called an expulsion order. And that is an actual deportation order. And we're not allowed in the US for 5 years. So you could have fixed your visa, maybe applied again for the visa at the embassy, but we can't because now we're deported for 5 years. So knowing that those are the only two choices at the airport, choose wisely unless you're really afraid to go back home and then seek asylum. By the way, warning, arriving aliens do not qualify for bond. So if you are seeking asylum at the airport, you will be detained and placed in jail until your final trial date. So another one of the many reasons why I do not recommend it.
So I like the first option. It sounded better, at least.
Yeah, I always tell I get sadly during this current administration, I must warn you guys that I have been receiving phone calls of people that tell me they can't find. They're telling me I get many students who tell me they're accusing me of not going to school, and I don't have my school records. And I've told them it's best to withdraw your admission, I'll work on finding your school records. I will work with your school and will reapply for your student visa, for example. I would prefer for my client to go back home and for me to apply for their student visa again, as an example, instead of them having a deportation order. It's an uncomfortable conversation to have. I know my client doesn't want to go back home. They want to go back to school. They want to go back to work. They want to go on their vacation, but I would much rather not have the deportation order because that's just not a good option. And I really don't want them to not be able to ever go back home by seeking asylum.
There you go. Thank you so much, Isa. I mean, those were really helpful. And yes, I'm sure it is the same for folks out there. So I would say please do not forget to like, share, and also subscribe to our channel. Our handle is at Immigration Talk Show. So check us out, subscribe to us, and hit that bell icon. And it's been great so far with Isa. So, Isa, are you ready for more questions?
Always.
All right, so let's take this one. This is from our Facebook group, I guess. And yes, this is from Priyanka. Being an Indian citizen, if a person got stamped her first H1B visa in country other than India, will she be eligible for Dropbox in India, provided she has visa expired in the last 12 months?
Yes, that is part of the waiver, the instructions that they're providing. Each embassy is not, it's providing their instructions online, but all the waiver instructions should be there. And yes, if it's less than the 12 months, you should be able to do it in the Dropbox. So yeah, take advantage of it. I am encouraging all my clients to do the waiver. I mean, before I would always tell them to do it 48, but now 12 months, do it now. And that goes back to the prior question as to what we can expect. There's going to be delays. So don't wait. Do it now. You're a month 10. You think you have time. Do it now. But yes, you should be able to do it in India under the Dropbox. Not an issue.
Okay.
Check the
Do this,
instructions, though. Check the embassy instructions online.
Right, right. Thank you, Isa, for taking that up, and all the best, Priyanka. Now, this next one is from an anonymous participant. This question was also put up 5 hours back. I work as a remote full time in a company as architect, and I'm planning for stamping next week where I have to go through interview. My company said I don't need client letters since I'm full time working as a consultant, and they gave a letter with all my details for counselor appointment. But I work as a consultant for client where they have SOW with us, so I help them customize the product. In this case, do I need a client letter, or since I'm a full time in my company, is the company's recommendation letter enough?
The company's recommendation letter is enough because you're a full-time employee of your company. However, the client letter would be excellent if you can get it. However, I know that it's not that easy to sometimes go to our boss or to the client. If you can get it, excellent. It would be an amazing benefit to have. However, the company's recommendation letter should be enough. You're a full-time employee. That's all that is required. The client letter would be like the icing on the cake to make sure that the officer fully understands what you do. Because as you said, you are the consultant for the client, but you're technically working for the company. If we just help put the full picture of what you do, help answer all their questions. So I understand why you want it. I would want it too. But I also understand that sometimes it's difficult to get clients to give us what we want. So know that what you have is enough. If you can get more, that will be better.
Okay. Thank you, Isa. And now let's go on to our next one. This is from Musthak. I'm planning to go to India for visa stamping for first time since I moved to US. In the sorry, is this the right time? Am I
No.
eligible for interview? No. Okay. All right. Should I go on then, or
Yes. Go. I'll answer everything. I'm sorry.
no? It's cool. Am I eligible for interviews? So my question is, my company says they will give all supporting documents for the interview, but they said I don't need client letter because we have SOW with client and I work in remote and not in client location. Does it seem justifiable for counselor? Is there any case like me?
I have many cases like yours. And what I've been telling my client is, why do we need to go? Like, why do we need the stamp? Is it something that really need to go home? Is it somebody elderly that you need to visit? Are you feeling really homesick? Why do we need to leave? Because the reality is, to answer your first question, as you heard me abruptly say, no, right now it's not the best time. It's just the embassy right now, and it's not just, it's everywhere. Embassies are being, they're not the most welcoming environment at this point. So if you can avoid it, if it's not really necessary, but I understand there's some things that may be out of our hands. There may be some family responsibilities that we need. So if you to answer the second part of your question, if you have to, it seems to me the documents you have, it seems related to the prior question, there may be sufficient, but the more you have, the better. The bigger picture, the full picture that we can show of what we do, that's best. Sometimes it's difficult to get documents from clients. I understand, because of course the H1B may be your visa, but I have to work as your attorney directly with your employer to get records. And I understand how difficult it may be for employer to get records from clients, how uncomfortable it is to sometimes ask letter from clients. So the more you can get, the better it is. But it seems to me, to answer your question, that what you have is enough for the interview. Make sure you understand it. Make sure you're comfortable with it. Once again, if you have to, because if you don't have to, if you're okay here and you don't have to travel, now it's not the best time to travel if you don't have to. If your time is up and you have to, it's okay. But if not, stay here. We're good here. Spring break. Enjoy the time. I'll take another question. H1B. Okay, so H1B stamping in May. It's 160. Oh, submitted within 30 days to that appointment. How do I get? It's not able to retrieve since I didn't submit it within 30 days. But same 160 attached to that appointment. How did I get rid of this to go for same appointment? Oh, I'm not understanding this. Okay, this is what I recommend. If you are using the wrong DS-160 and that's the concern, go to your appointment with what you have. I know how difficult it is to get appointment. I wouldn't want to reschedule. The reality is rescheduling might be a lot more complicated. So I am failing to fully understand if the issue is that you have the wrong DS-160 and your concern is that you're processing the wrong DS-160 application. Take with you the correct application and explain it to the officer. Because once again, I understand how difficult it is to get these correct, to get an appointment. It may take a long time. Take the correct application with you, because it may be difficult, if not impossible, to change it. Also, I understand there's an online system. I'm sure you've already emailed them and contacted them a million times to correct this. Keep doing so up until the day of your interview, but make sure you have the correct information and the correct form with you when you go to your interview.
Thank you so much, Isa, for taking that up as well. I was facing it.
It
I'm glad
happens.
to be
Don't
back.
worry.
So
I just hope I
thank you
answered
for
it
taking that
correctly,
up.
because it seems like if he has the wrong application, but I think if you take the correct one, you should be okay, especially if it's just for stamping. If this is your first time, they'll keep your passport.
All right. Thank you, Isa. Thank you for being so awesome too. So patiently taking up all our questions. So next one is also from an anonymous participant asking, I started filing out my DS-160 a few days ago and have already booked a Dropbox appointment for my H1B stamping. I had a quick question. Does a DS-160 application expire if it remains unsubmitted for too long? I'm holding off on submitting mine because I'm waiting for my updated I-797, and I wanted to ensure that my DS-160 reflects the correct details.
So yes, it may expire, but at the same time, you're doing the right thing, because you do want the DS-160 to be as fully complete and as accurate as possible. You don't want it to be wrong or to have any mistakes or to have any issues like the prior question where you have the wrong application, the wrong information. They may hold on to, especially now with embassies being so picky, they may hold on to something minor just to either delay your processing or to even deny. So it's annoying, but it's best to hold off to make sure the application is correct. Worst that could happen is that when you go back to try to submit it, it may tell you it's expired and you may have to do it again. And I know that's annoying. I know I'm minimizing it here, being like, oh, you have to do it again. But it would be best to make sure the application is as accurate as it possibly can be. Also, I know you guys know this because you watch this, but make sure you print it, have it with you, bring it with you. So I know it says don't bring it to the appointment, but review it because that's what it will. That's what they will ask you. That's what they will go through during the 10 minutes you'll be there, and that's what they will use for all others. So make sure you're always consistent every time you renew it, because we just talked about how waiver time got shorter. So you want to make sure you're always consistent. So every time, every waiver, you never have any issue, and the process is always easy breezy every single time.
Yes, absolutely. Thank you so much, Isa, for doing that. And I think we will move on to our next question now, or have we covered? I think we have covered most of our viewer questions. But, we were also talking about legal options, if an H1B visa gets detained or denied. So, what are the legal options? And we've already discussed this. So, what are some key H1B visa holders they should know before they're traveling internationally to avoid these issues when they return?
So the main thing when traveling, like we already mentioned, like checking before, checking your time you've been here, checking how much time you have left. That's the main issue I see with H1, that maybe that 6, 7 years, like you're already up and you didn't realize it. So check how much time you have left, check how much time you've been here. So that way the questions they'll ask you at the entry, you can feel comfortable answering the questions about your employer. Where is it located? It may seem, especially now with remote work, and CBP officers can be really sneaky, and they will ask you, so where's your office? And you're like, I don't know, it's over here. And that's where they tend to question whether you're really working and really doing the H1B. And you may say, but I work remote and I only go to the office once. And so it's, keep that in mind and bring evidence with you. It's a brand new office, a brand new place. Here's my card. Here's my boss's information. That's to check. Now, here in the US, like I said, if you have that encounter, it's good for your employer to know not only your rights, but the rights of your employees, your coworkers. What we notice with ICE is because of the desire to meet the numbers and the quotas that President Trump has promoted and has promised to the U.S., there may be not really ICE raids, it's more like ICE encounters, we may call it. And know that here in the US, like I said, you have greater rights. So if your encounter with ICE is at your place of employment, they need to have signed warrants by actual judges. So it's good for your employer to know that if they're coming and saying, oh, we need to check the H1Bs in this area. It's different from the Department of Labor going to see if employees here are rightly are actual employees than to actually start arresting people. There are certain requirements. So it's good for your employer to know. And if you're for any reason detained or stopped or have any immigration encounter in the US, that's actually the place where you can fight the revocation of your visa. If your visa is revoked because they don't think your employer is real, you can fight that here before an immigration judge. If they're fighting because they don't think you work, you can fight that here before an immigration judge. You have that remedy here, but that's only if you're already, meaning you're not seeking, the legal term is not seeking admission. It's at the airport where the remedies that you may have are very limited. So it's good, as we've been suggesting, to plan ahead to make sure that you have evidence of always being here legally, evidence of where you work, evidence of the time that you've been here, of what you're going to do, or of where your work is located. Minor details that we normally don't think about, and now might be a good time to keep in mind just in case.
Thank you so much, Isa. Thank you, really. It's been such a great discussion. I don't want this to end, but we've already covered an hour, so I might have to let you go for now. But if you still have a couple more minutes, I would still have more questions. What do you say?
I will take the minutes. I'll gladly answer any questions.
All right. So this next one is actually a case study where, I was reading more about it. So there was a software engineer working in Silicon Valley and went to India for a work trip. But when he came back, CBP detained him over an old traffic related misdemeanor. So his visa was revoked and he was placed in expedited removal. So how could he challenge this, and what options does he have to fix his status?
And that's where I mentioned the importance of checking your visa status before. And that's where you can check your email. The DS-160 that we've been mentioning continuously, we put our email address there where they would communicate if our status, if our visa has been revoked for any reason. This individual maybe use their email address from 1998, and that's where they emailed us. Although the Department of State sometimes is notorious for not even emailing us or simply thinking that we're going to know our visa's revoked by magic. So we'll give him the benefit of the doubt that maybe he didn't get the email and that's why he didn't know. But if you have your DS-160, make sure you check the email address that you used in that form. So that's where you would know what's the status of your visa, number one. Number two, for him, it would be relevant to understand that anyone who is in the US for less than 2 years could be subject to, as Nipa mentioned, expedited removal. So if you are seeking admission, if you're coming into the US, you've obviously been in the US less than 2 years, you just got here. So they can kick you out right away. So in that particular case, if he would had emphasized, as we had somebody else previously asked, they had been working on an H1B for 3 years, it would have been helpful for him to argue, oh, I've been working on this visa for a certain amount of time. This was a very brief trip that I took. There are many circumstances that may have helped him fight his case at the airport. But remember that we have discussed that at the airport, your options are very limited. You can withdraw your admission and that way avoid the expedited removal, because expedited removal is a deportation. That's the deportation that I was mentioning that bars you from the US for 5 years from the airport. Or you can seek asylum, which will keep you in jail until you can prove that you can't go back to your country due to persecution from the government or an agent the government can't control. So in his case, it would have been best to, if it is a traffic charge, once again, sadly, the US can revoke your visa for any reason. And a traffic misdemeanor can include driving without a license, it can include a DUI, and these reasons are very difficult to fight. So while we can later on argue if they were to revoke your visa because they argue your employer is not real, you can apply and prove that your employer is real. Or if they revoke your visa because they argue you're not working, and you can apply later on saying you are working indeed. When it's something criminal like a traffic misdemeanor, because it is a decision from the Department of State, it is very difficult to have that visa reinstated later on, and even more difficult if you already have an expedited removal order because of the 5-year bar that I mentioned. So for him, he would have to either fight the traffic charge, either argue that it's not him, or it will have to be that it's not him, because if it is him, there's nothing he can do. He would have to wait the 5 years, and after 5 years, try to reapply for the visa. If he has any family in the US, it would have to be a qualifying relative, a spouse or a child, or maybe a parent. He can ask for a waiver. Sorry, long answer for a sad response.
No, but I mean, totally makes sense, and I think you'll just have to play safe with all your time out there under a visa. So, I mean, try not to fall into, even though they may look small to you, but it's not really small. It could be getting more
Yes.
complicated a little later. So, thank you so much, Isa, for taking that up. You wanted to add something?
Well, the main point I wanted to add is that right now, sadly, visas can be revoked being only based on the accusation. That's why the Lake and Riley Act is so controversial, because it is allowing people to be placed on removal proceedings, which was what we call deportation proceedings, and technically to be detained only by being accused. So that would also mean that even if, and that's also why I keep emphasizing to check your visa before coming, because you may have this traffic infraction that you think you paid and it's old, and because it spent so long that you didn't pay it, or I don't know, nothing happened with it, now it turns into a misdemeanor, and it just gives the government the authority to revoke it. So just check ahead of time, play it safe.
Absolutely. Thank you, Isa, for taking that up. And maybe before we leave, if you could, Tell what should employers be doing to make sure their H1B workers don't run into legal trouble, especially with all the policy changes that are happening so fast and every day?
First, I'm going to answer the whether traffic infractions affect the B1, B2 visa applicants as well. It affects everyone. Traffic infractions, they sound silly, and I never thought before during the Obama administration, for example, I've been practicing for a while. I'm rather old. I would tell no effect, but I noticed maybe because I live in Miami where people drive very well. They accumulate and they do have an effect, and they, because visas are issued, particularly B1, B2, which are tourist visas, are issued at the discretion of the consular officer. An officer might, at their discretion, and the Department of State, the Attorney General, who are the ones that monitor these visas, may, are at their discretion, determine that you have way too many traffic tickets, and they can withdraw, they can revoke your visa. So be careful. Don't drive like me. They may have an effect. These regulations, the decisions to revoke a visa, are fully discretionary. So because of that, there may not be written black and white in our laws and regulations. So keep that in mind. So yes, traffic infractions could affect even a B1, B2 tourist visa. As to employers, what we can do to protect our employees, I'll tell you my latest case. My employer, I don't know why, I don't know what they were thinking. They were a little bit too laid back with my employee and decided to, I guess, make them partner. I don't know, give them an interest in the company, which is great. But when you make somebody partner, when you include them in the company, you must continue payroll. H1B, one of the main requirements is continue payroll. So make sure your employers keep paying you. And by paying you, I mean that you remain a W-2 employee. Because you are now a partner, or because you are now an essential employee, because there maybe later on will petition for your green card or whatever, you're growing in the company, the tech startup is now a tech big boy, whatever, you're growing, great. It doesn't mean that now because you have the credit card on the company and you're taking the money directly from the bank account, that may happen, that's okay, but you must remain a W-2 employee. You must remain in payroll. I've noticed many employers that as they grow, they feel comfortable with the employees, they give them more responsibilities, and by giving them access to the company, they I guess relax with the payroll and HR requirements. I don't know what's going on, but it has led to a lot of questions when now the waiver and the renewals. I also noticed, I think this had to do with, because of the waivers, people were a little bit more relaxed when it came to reapplying. And now that the waiver is the less time, I am preparing more applications, and I've noticed these mistakes from employers. And I am very worried about whether these visas will be renewed and many issues that may come up. So make sure your employers keep paying you W-2 always. Also, for ICE raids, which I live in Miami, Florida. I practice all over the world, but I live in Miami, Florida. And here in Miami, Florida, there have been ICE raids. None of the ICE raids have occurred fully under the law, meaning that the warrants that the officers have used, none of them have been signed by actual judges. They have been administrative warrants. And so I mention this to all of you because it was not until after that employers realized, wait a minute, an administrative warrant, meaning a warrant that is signed by another officer. If I, as your friend, sign a warrant, has no effect. I don't have to let you in. So keep that in mind. It's something minor, but it's huge, because if I am working, and I don't know if maybe your visa was revoked because you had a DUI yesterday and maybe you are now here illegally, I don't know. And somebody shows up saying they want to have a raid at my job, it's good for me to know, is this signed by a judge? I don't know this person. Maybe call an attorney, and I'm not going to let you into my place of business because I don't know this warrant. And that way protect the person who maybe was accused of a crime and doesn't even know it from detention. So let your boss know that, just in case. They should know. I don't know how comfortable you may feel with your boss having this conversation, but if you know it, and if you are the boss, you can also let them know, hey, no, my boss has instructed me not to let you in because this is not signed by a judge. So those are the two main things I've been telling all my employers: pay your employees by W-2 and check that all warrants are signed by judges before you let anyone into your premises.
Absolutely. Play safe, but also play smart. So no everything well, do your research properly, and I'm sure that nothing is going to scare you when that happens. Knowledge is
True.
power, at least in this matter. So do that. And thank you so much, Isa, for spending this time with us, full of energy, and for patiently answering and taking up all of our questions from our viewers, not just on YouTube, but also from those who are watching on Twitter as well, and also from our Facebook groups. It was really lovely having you, and I wish this wouldn't end so soon, but yes, we'll have to at this point. Yes, so I'm really hoping already to see you again soon. Please tell me
Whenever
about
you
your
want.
yeah. Yeah, but before we go, do you have any end notes, anything more you want to add, and we can.
I know things are scary right now. Every day we wake up and we have different news and different memorandum and something different going on. But don't get overwhelmed. Just stay informed. I know that sometimes that might be overwhelming too, but it's good to stay informed and know that you guys are doing everything right. You're staying informed. You have your visas. You're applying correctly. As long as you keep doing everything right, you'll have the law on your side. And if I can help you in any way, I'm always here.
Thank you so much. And yes, you can contact Attorney Isa, and that you can do so by calling her on her number, and also by emailing her. You can call her on 305-938-0676, and you can email Attorney Isadora at isadora@isalawyers.com. Check out the spelling, it's there on the screen, and go visit www.isalawyers.com. Thank you, Isa, once again. It was lovely having you, and you have a great day ahead.
You too. Thank you guys.
Thank you. And folks, you can also email me or call me or WhatsApp me on my number. My number is 408-335-6444, and my email address is nipa@staffingly.com. And once again, do not forget to subscribe to our channel and also hit that bell icon so that whenever we have discussions like these, you are notified. And absolutely, it was so amazing having you, Isadora. I'm already looking forward to having you back again. So, yes, and friends, also follow us, not just on YouTube, but we are also there on LinkedIn, Facebook, X, and Instagram. So, check us out, follow us, and connect with us. So, bye, y'all. Have a wonderful day ahead and watch out our space. Stay tuned on Immigration Talk Show. Welcome, everyone, to Immigration and Jobs Talk Show, and I'm very happy to have you all join us today. I'm Napasa Pradhan, and I'm going to be your host for this session. And before we move ahead, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, it's really very fantastic to have all of you join us today. We are streaming live right now on YouTube, LinkedIn, and Facebook. And I'm very excited to tell you that this could also be a very participative session. All you have to do is type in whatever questions you have in the comment section, and we'll be very, very happy to take them up in this session later for sure. And today we are going to dive into this very important discussion on this topic. Can product managers and software engineers qualify for the EB1A visa? And it's a topic that
is especially relevant for highly skilled professionals out there in the tech industry. And of course, I am very, very excited today because we are going to have one of our very special guests back with us, joining us after months, really. I think we met last before summer. So please help me welcome attorney Prashant Dubey once again back here on Immigration and Jobs Talk Show. Prashant, really happy to see you after a real long time and really good to have you here. Thank you for joining us.
Yeah, no, thank you. Thank you to the Higher IT team for welcoming me back, right? And having me on another episode, another webinar. Thank you, Nabasa, Zayed. Thank you for all the technical work you do in the background. I'm sure I'm going to have one technical difficulty at least. Otherwise, it would not be a webinar where I have participated. So if I pivot to my phone, don't be surprised at some point. But glad to be back.
Very glad to have you back with us, Prashant. And so, yes, today's topic, what can folks out there expect from us today?
Yeah. So today, one of the reasons why I think this webinar specifically around the EB1A is highly relevant, right? I know we've done a series of webinars before on this topic specifically, and it was very high level, right? Can folks in IT qualify for the EB1A, for example? And we talked about the EB1A process, application requirements, how people qualify. And I think this is a really good opportunity to start double clicking on very specific profiles, right? So, for example, for today, we're going to be discussing how product managers, how software engineers specifically qualify. And I know behind the scenes, we were discussing, doing an episode for like cybersecurity folks, data engineers, that sort of thing. And over the last several months, one of the reasons why I kind of disappeared from these webinars is because that this part of my practice has really started to scale. And the reason was pretty straightforward. So since October 2022, EB1As have become a very hot topic, right? Ever since the retrogressions and priority dates happened. And I was working with one or two clients at a time over the last couple of years to help them get their EB1As approved. What happened earlier this year around the May, June timeframe, one of my clients who got his EB1A approved, he works at Meta. He went and posted internally in a Meta forum about his success with our firm, and then things just kind of exploded from there, right? So over the last, I would say 5 or 6 months, I've probably done twice as many EB1As as I did in my first, my last couple of years, where I've noticed this become a trend. Lots of consultations, calls. And so it's a really interesting time, at least for me, and I think the EB1A community, because there's a lot of best practices that I feel like I'm now uncovering as I'm doing this at a much larger scale, and with many, many more types of clients and different profiles and different case studies that I can bring to the table today, right? And of course, there have been some changes as of October in how USCIS is going to be looking at the EB1 criteria, and we can get into that. And then, of course, I know there's a lot of anxiety around, the presidential election and the recent results,
Right.
and we can talk about that too.
I was just coming to that. And I think before we head on to today's topic, maybe you could tell us how, Donald Trump being elected the 47th US president is going to affect even this category of visas. And it'll be great your point of view on this as well, Prashant.
Yeah. So there's a couple things to that. One is just like my personal experience, right? So like the very first EB1A I ever filed was for a dentist. And it was during the height of the Trump administration about 4.5 years ago, right? And he got approved just fine, right? I think when it comes to the next administration, what I saw previously between 2016 and 2020 was that there was impact for EB2 and EB3 candidates, right? Even H1B candidates. Reason being that there are different areas of that process where they can really influence what's happening, right? And what I mean by that is in EB2 and EB3, you have things like the prevailing wage determination, right? So they can slow that down. You have things like the recruitment process, right, which can really come back and hurt you, let's say at the I-140 stage. They have the perm application itself in which they can increase their audits, right? And those are the types of things that we saw the Trump administration do previously, right? Um, when it comes to EB1As and EB2NIWs, I think any administration has a very keen interest in keeping the best and brightest people here in the US, right? And if you look at his rhetoric, it is all about, potentially changing rules, regulations as it relates to maybe asylum seekers, people illegally entering the country, right? But when it comes to these merit based applications or these merit based benefits like the EB1A, like the EB2NIW, he really that's not a part of his rhetoric, right? I don't expect there to be a whole lot of impact for my EB1A and EB2NIW clients because this is a self petition, right? These applications go directly to USCIS. You have nothing to do with the Department of Labor, so there's nothing they can influence there. It's just you and the officer and the case you present, in front of them, right? So I'd say from that perspective, I hope people aren't as anxious as maybe they might be coming off for EB1As and EB2NIWs.
But definitely, I think everyone is anxious, especially immigrants out there. Like, what's going to happen? Some are really maybe even taking up actions before things get worse for them.
Yeah.
I mean, that's what their thought process is, I guess. So a lot
Yeah.
of things are happening. I think people are still processing the whole information, Prashant.
Yeah. And I'm seeing it too, right? Like I've got clients who are like, can you take my case now? And I'm like, the earliest I can take it is at least January, right? Like I'm working with a cohort of people, that sort of thing. And I'm seeing a sense of urgency where people want to try and apply right away. And like our timelines are just not matching up, right? And that's okay. But I am seeing that sense of urgency where people are worried. But I think it might be a little overdone.
For sure. But let's head on to today's topic, and I got some questions prepared. So, Prashant, if you could just tell us, how might product managers and software engineers qualify for the EB1A visa? And this requires evidence for extraordinary ability in their fields. And what impact might Trump's previous stance on merit-based immigration have on their chances?
Yeah, I think that second piece I kind of covered in the first response, right? I think based on his rhetoric, whether it was the previous, from 2016 to 2020, or let's say 2024 or 2025 and, moving forward, I don't see an impact on merit-based applications, right? Especially not EB1As and not EB2NIWs. Again, any administration has a very high interest in keeping the best and brightest here in the US. Now, when it comes to qualifying, right, for the EB1A, for example, for product managers and software engineers, let's take the product manager profile first, right? Product managers are very interesting individuals because they sit at the intersection of IT and business, right? So one advantage that product managers have is that they can very easily and often, do very easily communicate the business outcomes that are driving their projects, right? The KPIs associated with it. What is the organizational impact? What kind of impact is my work having on the industry, right? And when you sit at that intersection, it's really important for at least two of the criteria: critical and leading role for a distinguished organization. Second one is original business contributions, right? Because we want to be able to prove that the work that somebody's doing is important at an organizational level, right? We want to be able to prove that the work that they're doing is innovative and also influential in the industry. So I think for those criteria, right off the bat, product managers are really well situated to satisfy those requirements. I recently had a product manager that I worked with. He's at Meta. He works specifically with networking technologies. Okay. And for him, we argued on 4 criteria: critical and leading role, original business contributions, um, judging the work of others, and then salary, right? And I often see for product managers, those are the 4 criteria that they are satisfying, that they are hitting, right? Most commonly. There might be others like memberships, awards, authorship, depending on the makeup of the profile. But at a baseline, those are the 4 that I typically see come across my desk, right? And, it's important, I would say, for critical and leading role to raise your projects that you've worked on to an organizational level, right? What was the organizational impact? What was the dollar amount impact? How much cost savings did you achieve? How many manual labor hours did you reduce, for example, right? And then for original business contributions, one of the things I want people to think about is raising it to an industry level. So not only, what you worked on was innovative, but how was it adapted maybe by other organizations, other companies out in the field, right? And for that, one of the best ways to showcase it is expert opinion letters. So recently, one of my new best practices is to kind of urge my clients, go and find 1 or 2 individuals out in the industry who are experts in their field. And an expert can mean many different things to many different USCIS officers. For some officers, an expert is somebody who has a Google Scholar profile with over 1,000 citations. Go find that individual. They might already be in your network. They might already be in your chain of command. An expert can also be somebody who is a thought leader, right? They pop up frequently in news media for comments about what is happening in the industry. And what I'm finding is, as my practice has scaled over the last 5 to 6 months, the individuals that, the 1 or 2 individuals that, received an RFE for whom I filed versus the individuals who had comparable profiles, right? That we filed and got approved, that was the difference. Those 1 to 2 letters of recommendations from renowned industry experts is what pushed those approvals over the edge, even though the profiles were similar, right? Didn't matter if it was a product manager, didn't matter if it was a software engineer, but that is something I'm seeing is really helping to set people apart, is having those strong letters of recommendations for your original business contributions criteria. For software engineers, it's very similar, right? We still need to prove that your work is critical at an organizational level. We still need to prove that the work you're doing and it's innovative, right? And you can do that in separate ways. Some clients of mine, they have patents. Some of them have papers, research papers or conference papers associated with those projects. Some of them have open source work, right? That they can point to and say, hey, the work I've done is laying the foundation for other developers to build on top of it, right? I sometimes have clients who come in who have done code reviews, right? Technical reviews out in the industry. I've had clients who will maybe go to freecodecamp.org and they will write blog posts about best practices, for example, in C++ programming, right? So there's different ways that you can come at the criteria that are kind of outside the box of just your traditional research, academic, PhD background. So that was kind of the TLDR of that that answer.
Thank you so much, Prashant. I mean, that was pretty detailed and what we really need. Thank you so much for walking us through all these highlights that we really need to keep in mind. And at this moment, Prashant, we've got some friends who've joined us and who are commenting. So I'll just quickly say hi to them. It's My Channel says, good morning, Prashant. And then we have Kavya's questions. We have Amarjeet. Folks out there, please stay with us. We are going to touch up on your questions very, very soon. And yeah, thank you so much. Okay, Amarjeet. No, okay. Let's head on with our questions. I have one more question for you, Prashant, and that is, what level of professional achievement or recognition is generally required for software engineers and product managers to be considered for EB1A eligibility?
Yeah. And this is kind of a sliding scales question, right? And what I mean by that is, in terms of what qualifies somebody from a recognition perspective can mean many, many different things, right? Recognition can be somebody that has multiple papers and research articles published. It can be somebody that has multiple conference papers, multiple blog posts. It can be somebody that has a very robust GitHub repository, for example. Somebody that is very much involved in the Android developer community, for example. And recognition can also be thought leadership. And I like to call thought leadership basically like your speaking engagements, right? I do have clients who are invited to speak to DroidCon, right? Or they are invited to speak to at AWS reInvent. These really big industry conferences. Cisco Live is another one of them, right? So recognition can take many different forms. Recognition can also be, how is your work being adapted in the industry? So if you don't have patents, that's fine. But if you have somebody that is talking about how they've taken, your technical work learnings from you and adapted it in their own workplace or in their own organization, all of a sudden that becomes very impactful, right? But I always recommend, like, if you want to get recognition in the field, think about in your industry, what podcasts can you be a part of, right? And for product managers, there are multiple podcasts. There's some at the product school. There's one called Exponent. There's a podcast that's done by an individual over at University of Washington. You can participate in those sorts of avenues, if you're a product manager, to really get your thought leadership and your recognition out there, right? And that will help you from a final merits perspective. If you're typically, what I see my developers, what they've done is they're typically speaking at these industry conferences, or even academic conferences about the work that they've done, right? And that will help you build your thought leadership, right? And the type of conference you present at is going to depend on your profile. For example, I had an Android developer who presented at DroidCon, right? I had a machine learning engineering manager from Pinterest who presented at AWS reInvent because he built their machine learning platform in partnership with AWS, right? So it made sense that he was presenting there. In addition to that, he had about 3 or 4 other conference speaking engagements within his industry, within his specific line of work, right? So this is going to be very relevant and kind of particular to the makeup of what your EB1A profile is and the story that you're trying to tell, right? It doesn't make sense to go and present in a conference that's about graphics technologies, for example, if you don't work in that space, right? Or if you're a data engineering doing AI/ML work on recommendation systems, right? Has to be very relevant. You have to find those opportunities that make sense for your story.
Definitely, without any doubt. Thank you so much, Prashant. And, I would really like to take it's my channel's question for now. So let's go for it. 2 design patents, one IEEE paper publication, reviewed or judged 3 technical papers. Can I still qualify in the expert category, or what is your suggestion to make this profile more stronger? And what are
Yeah.
the areas that I can add?
Yeah. So I think with the design patents, right, we would need to learn, hey, do you have any citations associated with them, right? That's going to be important. Same with your IEEE paper. If you have 2 patents and 1 paper, but you have 50, 60, 70, 100 citations, that shows that it's very impactful work, right? So your next step should be the people that have cited your work, cited your patent, cited your papers, identify the individuals that are, really renowned. And what I mean by that, are they academic experts? Is somebody there who has, cited your paper that has over 1,000 citations on Google Scholar, or has a lot of media attention, for example, for the work he's done? And can you potentially get a letter of recommendation signed from that individual, right? I think reviewing and judging 3 technical papers, that's fine. I would always urge you to do more, right? Because, I'm seeing my clients and they're reviewing 30, 40, 50 conference papers, right? So if you think about it, that is who you're going up against, right? So I would say do as much as you can when it comes to the technical review work in as many prestigious conferences as possible. And you can very easily find the prestige of a conference by going to research.com, right? And searching, for example, within the field of computer science, what the ranking is. If they're not even on research.com, you should seriously consider whether it's worth pursuing that opportunity. In addition to that, one more thing I want to mention, don't be disheartened by the fact that you only have a couple of patents, right? Because I had a CRM engineer from Salesforce, one patent, four citations. That was it, right? But what we went and did was we drafted a letter of recommendation from an individual that cited to his patent that talked about how they took inspiration from his patent and the work that he did, right? So if you can get a letter of recommendation like that, obviously the patent proves that your work is original. We also need to prove that it's influential, right? And so that letter helped us show that his one patent was influential in the industry, and he did end up getting the EB1A approval. So not somebody that had a robust patent or research background, but somebody who was able to prove that the one thing he did in the way of a patent was influential. Somebody did take inspiration from it, right? So just something to think about in terms of how you build your profile moving forward.
Yes, very much. Thank you so much for highlighting that, Prashant. And I think it's very important to make your profile stronger and as attractive as possible, I think. So thank you
Yeah.
for that tip, Prashant. And thank you. It's my channel for participating. Please keep commenting if you have any further questions. And now I think we should take up another question, and this is from Kavya. Kavya is saying, my contributions are mostly collaborative, working as part of a team rather than leading solo efforts. Can I still qualify for EB1A? And does the process amount for team based achievements, or do I need to show individual recognition? And there's
Yeah,
another
good
question,
question.
but okay, we'll take that later.
Yeah, good question. So no one is a one-man army, right? Like none of my clients have ever operated in a vacuum, right? Like you're either a software developer or a data engineer or a cybersecurity person or a product manager, but you're not everything, right? And so you have to keep in mind that what we tried to highlight in an EB1A is your specific contributions, your specific technical tasks, your specific original contributions or innovative contributions, right? Um, if you're an author on a paper, you might be a co-author, right? But that doesn't mean that you didn't contribute to it just because you were in a team-based or collaborative environment. 99% of the time, that is absolutely the case, right? And that's okay. But what we like to extract by way of letters of recommendations is your specific contribution to that project, right? And my job is to make it seem like you did everything, right? As your attorney, as somebody that's going to represent you, right? I'm not here to talk about what your team did, right? I'm here to talk about the impact you had, your specific technical contributions, and then connecting it to an organizational level impact, connecting it to any news publications, any media, anything of that sort that has, like the project you've worked on, if it's gotten that attention, then we leverage those as exhibits, right? And I'll give you an example here. I work with many clients from Meta's AR/VR team, right? Meta's Reality Labs team. You can find a lot of news publications out there about how, Mark Zuckerberg has basically created like a 10-year roadmap or a 5-year roadmap for the Reality Labs team, how it's important to Meta's organizational goals and strategies, right? So automatically we know that if you're working on a project for AR/VR at Meta, it is organizationally important. It is important at a CEO level, right? And we've got news publications to prove that. If you are working specifically, let's say, within the wearable devices vertical of Reality Labs, right? I've had a client who does that. There's news publications out there, right, about the innovative nature of the wearable devices strategy that Meta has, right? So we automatically, can connect it to something that's newsworthy, talking about the fact that your work is innovative and also influential because It's going to impact the millions of customers that are buying the Quest headsets, right? So again, none of this happens in vacuum, right? But our job, my job, is to extract the specific details related to your specific contributions, connect them to those higher level organizational goals, connect them to those news publications that are talking about how this work is important at an industry level, right? So that's what I would say. Anybody can really qualify for the EB1A. We just need to highlight your specific contributions.
Right. And what about this last part of the question that she had, that Kavya had? How can I highlight my role and impact within a collaborative setting? Any
Yeah.
tips?
Yeah. So what I do is I always send my clients a worksheet, right? So like we get on a consultation call, I learn a little bit about you. I either say you're ready to move forward or you have more work to do, right? I'm going to be very transparent about that because the last thing I want is a bad customer experience, right? I don't want you to think you qualify for something you very clearly don't, right? And in that worksheet, I extract those details, right? What were your specific contributions? What were your specific technical tasks? What was the organizational outcome that you were trying to achieve? And we draft letters of recommendations around that, right? Letters of recommendations can come from your managers, they can come from members of cross functional teams, they can come from peers. If you work with end clients, right? So, for example, I've had some clients who are management consultants, let's say at one of the big SI firms. You might get a letter from one of your end clients talking about the work that you've done and how it was impactful, right? So that's how we come at it. In addition to that, I find that my clients are very good at leveraging their performance reviews, right? So if we are talking about a specific project that you've worked on, more often than not, your work on that project is also being captured in a performance review. So we can add that as a layer of an exhibit stating, hey, here's this LOR saying what this person specifically did, how they are furthering these organizational or industry wide outcomes. And oh, by the way, here's a performance review talking about, in addition, like all the stellar work that they did for this project, right? That becomes another objective piece of evidence.
Thank you so much, Prashant, for the detailed explanation for Kavya. And Kavya, I hope you've gotten all your answers. And we have It's My Channel back again saying, perfect. Thank you so much. And we have Dan Nandan saying his explanation is very clear and sounds like a radio personality for sure. I mean, really, Prashant, for sure. Very, very clear in how you explain. And now we have another question from It's My Channel asking, I would like to ask one more question on the memberships. Do you have any suggestions other than the IEEE or BCS?
Yeah. So here's the thing about memberships. If you don't have a research background, in the sense that if you're not doing journal papers, conference papers, you're not doing blog posts, you're not reviewing conference papers or journal publications, IEEE really doesn't make sense, right? And neither does IET. IET is another technology kind of research organization. And both IEEE and IET only make sense for people if they have that research profile. Otherwise, it just looks like a check the box exercise. And when I see that with a client, I tell them, like, I'm not going to use this as a membership. You need to go do some review work, right? You need to go do some authorship. And that way, your membership is going to look good, right? In terms of professional organizations, BCS is obviously the one that I see come across my desk most often. There are others, Royal Society of Arts being one of them. There's one called Sigma G or Sigma Chi, right? XI, that I also see my clients leverage. What I'll say is this: memberships is oftentimes one of the most difficult criteria. Membership and awards is two of the most difficult criteria to satisfy, right? So if you're going after it, just make sure that the organization you're going after fits your profile. If you don't have a research profile, don't do IEEE, don't do IET. If you have a professional profile in BCS might be taking too long, go and explore the Sigma Chi, go and explore, for example, Forbes Technology Council or Royal Society of Arts. That those will help you satisfy the membership requirements. And then high level, one of the things I want to say about memberships is USCIS really cares about the organization's bylaws. Okay. Bylaws are extremely important. Don't go and join an organization that has not memorialized their process into some sort of governance document or some form of bylaws that says this is the criteria that you need to satisfy the membership, right? These are the outstanding contributions we require of our members. In addition, take it one step further. Make sure the bylaws also discuss who qualifies to make those decisions about membership, right? That's very important. Some USCIS officers like to see those details. Where in the bylaws does it say this is the selection criteria? Where in the bylaws does it say these are the people that are going to be making those decisions, and these are the qualifications required for the membership committee, so to speak? And then the third one, what are the qualifications of that membership committee, right? So that information also then needs to be publicly available. So you want to be very careful with memberships because there's many pitfalls there, right? It's not just enough to go and get it. You need to be able to support your membership with bylaws and governance documents and all of those different pieces of information.
Thank you so much, Prashant, for taking that up. And we have some more questions. Let's take up Nirvana's question now. This is next on YouTube. Nirvana is asking, when talking of high salary criteria, how much we are talking of? Does officers go with what is mentioned in the LCA?
Okay. Level 1 to 4 wage means nothing to me in EB1A, and I think it means nothing to a USCIS officer, right? I have had clients who will try to argue with me that you should, include my salary criteria as criteria number 6 or 7, because it's a level 3 or a level 4 wage. It means nothing, right? There's no point of reference, right? And what I mean by that is there is better data out there. Bureau of Labor Statistics specifically talks about what the 90th percentile of software developers, product managers who can be qualified in the SOC code of marketing managers or IT project managers, depending on your role, data scientists, for example, all of the statistics are available on government wage databases, right? So Bureau of Labor Statistics, Career One Stop, ONET. I always start there. If you are not in the 90th percentile in one of those three, salary is a no-go, right? Because on the USCIS policy manual for salary, those are the three that they list right off the bat. Like, this is the starting point, right? In addition to that, we provide commercial wage data. Glassdoor, Indeed, ZipRecruiter, Levels, PayScale, Salary.com, right? Those further substantiate the fact that from a commercial perspective, this person's in the top 10%, right? And they also have those sorts of point of references like top 10%. ZipRecruiter actually takes it a step further and can even get as granular, I think, as like top 3%, which is great. Now, the third layer of exhibits we provide for salary, and this is something I had to learn over the last 5 to 6 months, because I was only doing that level 1 and level 2, which was the government wage data, the commercial wage data. I've now turned it up a notch with the level 3 wage data, in the sense, and I use level 3 very interchangeably here. I don't mean level 3 as like the LCA, but I use level 3 as in a third tier of exhibits that we're providing is related to professional organizations, right? So, for example, there are staffing agencies out there that are well reputed. Robert Half, for example, ranked as a top 5 staffing agency by Forbes. Mondo, ranked as one of the best IT search firms in the country. These organizations, they provide wage data based on their placements, right? So now I've been starting to provide professional organizational wage data as well to further substantiate the salary criteria. I don't care what's on the LCA, right? Like baseline, you got to start with the government wage database first.
Thank you so
How
much for
much
that,
total?
Prashant. And yeah, and Nirvana is saying one more. I see a lot of PR agencies. Is it lawful to take help from them?
I laugh at this one because don't work with the PR agencies. I apologize to all the PR agencies out there, but um, the problem is they will get you posted on USA Today. They will get you posted on Tech Times. They'll get you posted on Tech Bullion, right? MSN, Benzinga, et cetera, et cetera. The problem is after every article or at the beginning of every article, they put a disclaimer that's there that says, this is not the opinion of USA Today. And that's a
Okay.
problem, right? Because all of a sudden, we're arguing on the publications about you criteria, and it automatically gets discredited by the fact that USA Today is saying, hey, I didn't put this out into the world, right? Like somebody else did. You're going to have a world of a problem, very incremental value, right? So do not pay PR agencies to get you posted somewhere because it will backfire, right? Like those disclaimers are only going to hurt you and they're everywhere, right? So save your money, spend your time elsewhere.
Okay. And what about, what he asked earlier? How much total criteria should be enough? Well, that is a question. And does too many of them pose threat of for RFE as well?
Yeah. So like here's my best practice, right? I like to go in with a minimum of 4, right? I never go in with just 3. I learned pretty early on going in with just 3 puts you at a disadvantage because if USCIS RFE is one of them, right? You don't have much background, right? If you go in with at least 4, and let's say 3 of them are very strong, right? And one of them is 50-50 or a little weak, you still have a good chance of approval, right? 4 and above, your chances of approval from what I've seen go up significantly, right? In terms of having too many criteria, what I would say is if you can comfortably argue on 6 or 7 because you qualify for them, do it, right? If you can put forth a reasonable argument for 6 or 7 criteria, that's totally, but don't try to do something underhanded, right? So, for example, don't try to make criteria number 6 or 7 salary when the government wage database clearly says you're not in the 90th percentile, right? Don't try to slip something past an officer from a criteria perspective, which is going to discredit the rest of your application because then they're going to start thinking, oh, they're trying to convince me of something that like very clearly they don't qualify for. What else are they trying to convince me of? Right. So I think the most I ever argued on was 7. And I even told the client, like, look, 2 of them are pretty weak, 5 of them are very strong, right? And I think those are the 5 that are going to carry you at the end of the day, right? And they probably did because he ended up getting the approval. And you don't know which criteria you end up satisfying when it's an approval, but um, I know pretty early on in terms of like which one's actually gonna resonate with USCIS and which ones are not, right? Argue for as many as you possibly can as long as it's within reason, right? And as long as you can put forth a good argument.
Mm-hmm. Right. Thank you so much, Prashant. And those were really insightful tips and advices. Also, thank you so much, Nirvana. I hope that you've gotten most of all your questions answered. And if you have any more doubt, you can keep commenting. Well, it's my channel also said that that's a long list, but thank you, Prashant, he says. Anyway, I have a few more questions, Prashant. I think I'll share my screen for now so that we can take them up. I was telling you about some of our Facebook groups. So this will be easier. All right. So let's go with this first one, this is an anonymous participant asking, has anyone here worked with, I'm looking for filing my EB1A petition and would like some thought. Okay, not this, this one. Is the interview backlog different for EB2NIW and EB1A? Does anyone have any idea of which dates are scheduled for EB1A interviews at the Islamabad Embassy or Abu Dhabi Embassy?
Yeah. So what I can say, like at least speaking from the perspective for individuals within the US, because that tends to be 99% of my clientele, um, you don't have an interview for the EB1A or the EB2NIW, the EB2 or EB3, right? The only time I've ever seen employment-based petitions get an interview is if, let's say, somebody changes a job, for example, right? And the USCIS officer would like to verify that they are continuing to, let's say, work for that new employer, right? But none of my EB1A or EB2 NIW clients have ever gotten an interview from within the US. Now, if you do consular processing and you're doing your interview from abroad, yes, the entire process of consular processing involves a visa interview with a visa officer, right? So it's slightly harder, I would say, when you're doing it from abroad. But in terms of specific timelines for those two embassies, would not be able to tell you.
All right. Thank you, Prashant, for taking that up. Now I have this next question. This is, please help on where to publish articles for EB1A, or let me know which journals are eligible. Thanks in advance.
Yeah. So this is dependent on a couple different things. One is just your overall profile, right? Are you a software developer that's working within the Android ecosystem? Are you a data engineer working with AI/ML, right? Are you a developer working with AR/VR technologies, right? And graphics technologies? Are you a UX designer, right? Because the answer is going to change with each of those profiles, right? I recently had a data engineer who got approved for the EB1A just this week, actually. The articles he came to me with was published in an electrical engineering journal. And when we were working on his analysis and all of his exhibits, he called it out. He said, "Hey, you missed this article." And I was like, "I'm not going to include it. It's an electrical engineering journal, right? Has nothing to do with data engineering and the work you've done, right? And it breaks the continuity of your story. So what I would suggest is if you go to the IEEE website, right? IEEE has a list of conferences that they sponsor. Research those conferences, right? Type in the conference name, type in the word ranking. Research.com will tell you its ranking if it's ranked. Those are the types of conferences or journals that you want to be publishing in, right? The ones that are known, they're reputable, they have a peer review process, for example, right? That is what I would suggest. Now, let's say you feel the journal writing process, the conference paper writing process is very tedious. I've had clients tell me that. Totally fine. There are other avenues out there to satisfy the authorship criteria. For example, freecodecamp.org. Free Code Camp is a nonprofit organization, right? And they teach people how to code for free. And in order to even qualify to be a blog writer on Free Code Camp, you have to go through a vetting process. I think they only accept 30% of their applications. But the great thing about it is if you go to their LinkedIn page, 60, 70,000 people claim that they learned coding from Free Code Camp. And they will also help promote your blog posts, right? And your technical articles. That is another way to satisfy the authorship criteria, right? Doesn't have to be journals, doesn't have to be conference papers. You can get creative with it. I've had clients from Pinterest, from Meta, from Amazon, where these organizations have channels to publish technical blogs, right? And I've had clients participate in those technical blog process, and they're able to show me that, hey, these blogs are getting viewership, right? They reach out to those marketing teams internally. They find the viewership statistics, and we provide that as an exhibit to show that, hey, this person is authoring scholarly articles. It's just not in the traditional sense, right? But it is for individuals that might be, the intended audience is a data engineer, cybersecurity professional, whatever that might be, right? Another way to think about it is trade publications. So I have had folks in cybersecurity who do co-authorship with the Cloud Security Alliance, for example, right? So there's different ways to think than your traditional, journal papers, conference papers. But if that's the route you go, just be sure that those conference papers, those journals, those conferences and journals are like reputed, they're ranked on like research.com, for example.
Awesome. Thank you so much, Prashant, for giving us that insight. And now we have Vibhor asking, my company is 1 year old in Washington. Can I apply for L1A visa via road through Canada and I'm a Canadian citizen? I think the answer is yes. Once I get L1A approved, question is, can EB1C be processed quickly by paying money? And can I get green card within a year? Do you
Yeah.
want to take this up? It's not
If you-
EB1A.
I can answer the question totally fine. So with regards to EB1C and the EB1 categories, right? One of the things you want to keep in mind is the priority dates right now, I believe, are in 2022, right? So if you are coming on an L1A, right, as an executive, you can absolutely apply for your EB1C 1 year, let's say, after you enter the country, and you continue to maintain your managerial, executive capacity and executive duties, right? Or really whenever your company is ready to apply for it. So as long as in the previous 3 years, for one of those years you were employed abroad, let's say in Canada, you come back as an executive to the US, your company can apply for an EB1C for you. Okay. Now, if your priority date, let's say, is January 1st, 2025, just hypothetically speaking, right? If it's January 1st, 2025, in the EB1 category, you are probably not going to be eligible to get your green card within 1 year because your priority date is not, 2022 and before that, right? Or whatever it might be in the future. Chances are, if you get a priority date that is 2025, for example, you might be waiting 2 or 3 years before you can even apply for your 485 applications and get your green card, right? It's just how the priority dates work. In EB1 category right now, they are not current.
Thank you so much, Prashant, for taking that up. And I have one more question from one of our previous shows with you, EB1A, building a profile to qualify for EB1A category. And we had Arjun asking, saying that it was a very good session. And he had one question. How about the applicant had suitable criteria for EB1A 15 years ago, but now he is into different job sector and current situation is not suitable for the criteria? Can this still be a valid case for EB1A petition?
Yeah. So the thing about it is USCIS wants to see it over a sustained period of time, right? If you did something 15 years ago, let's say a whole lot of research, right? A whole lot of reviewing the work of others, but then there's a 15-year gap. One of the things that some very hardline USCIS officers like to see is that the work you did was over a sustained period of time, right? So critical and leading role over a sustained period of time, judging the work of others over a sustained period of time. If there's a significant gap like that of 15 years, I think that's going to be challenging for an EB1A, right? Unless, your authorship and judging the work of others criteria, which I'm just going to assume happened 15 years ago, right? For purposes of this question, if you have 3 or 4 other strong criteria and those two are kind of weak because they happened a decade and a half ago, I think you'll probably be okay. But if you only have 3 or 4 criteria and those are 2 of them, you're going to have a problem, right? I don't think that EB1A application would get approved.
Thank you so much, Prashant, for taking that up. And we had more questions, but I think we're good for now. I think I've taken up most of them. So we'll move back to our questions, Prashant, now. And I have this next question for you. So my next question is, what role does professional networking and peer testimonials play in an EB1A application? And are there any best practices for product managers and software engineers to secure strong endorsements? You've already highlighted some of how these testimonials or recommendations play a very important role. So if you could just tell us more about the endorsement part.
Yeah, absolutely. So I think there's a few different ways, right? So one way that I use endorsements is like sometimes my clients have LinkedIn recommendations, right? 10, 15, 20 LinkedIn recommendations. And I leverage that from a final merits perspective, right? So I'll give you an example. I have had clients who have participated in those thought leadership engagements, right? So they've been invited to speak at conferences, or maybe they've been invited to speak on podcasts. In addition to that, I highlight the fact that, hey, not only are they getting this industry recognition through these speaking engagements, but they're also recognized by their peers. Look at these LinkedIn recommendations accumulated, right? So I would say if you don't already have them, start thinking about, asking people for LinkedIn recommendations, right? Specifically related to the work you've done, specifically related to the capacity in which you interacted with them, right? It can only help you, certainly will not hurt you. Okay. Another thing is, I would say, folks tend to burn bridges very quickly, right? So you leave a job, you kind of forget about your previous manager, you forget about your previous colleagues, and that's natural. It happens. One of the best individuals, one of my best clients that I've seen really do this well, he built relationships over the last decade. And he was able to go back to his manager, a couple of colleagues from his time when he was an intern at Meta from 2013, when Meta was called Facebook, right? He was able to go back to that time and get letters of recommendations from people from 2013. And it's because his relationship building and maintaining skills were just exceptional, right? So you want to make sure that you are doing them so that when the time is right, when the time comes, people that you have networked with, the people that you have worked with are willing to sign off on those letter of recommendations for you, as opposed to saying like, why are you coming back to me 10 years later? Right? Build and maintain relationships, right? If there are think tanks, if there are organizations in your industry that attract the type of professional you are, get involved, volunteer, build those relationships, make sure they get to know you and you get to know them, right? Because at the end of the day, if you can build one or two of those relationships like that from renowned experts in the field, right? Those people that have the media publication, the media attention, the people that have the Google Scholar profiles that are very reputable and very much recognized, those become very powerful LORs for you. So build relationships, maintain relationships, at least for individuals that you identify can help you with your EB1A application later on.
For sure. Thank you so much, Prashant. And do you have any success stories or anything along these lines that you would like to share with us before we leave today?
Yeah. So I send out a monthly newsletter, and in that newsletter, I like to highlight. Nowadays, it's basically just all taken up by EB1A. But I like to highlight in those newsletters, some of the success stories that I've been seeing. And of course, it encourages other people, right? They see other people's profiles who are going through the EB1A process and they become encouraged themselves, for example, right? So I will share a couple of those success stories from this month. So this month, we've gotten 3 new approvals. Those have not gone out in my November newsletter because my newsletter goes out at the end of the month. One of them is a data engineer, right? And one of the things that he did in terms of satisfying criteria for awards, he had the Business Mint Awards and the Global Recognition Awards. I don't think that's one of the reasons why he got his EB1A, though. We also argued on critical and leading role. So he had implemented certain projects, for example, in the state of California, as it related to their electric metering system and modernizing that system, right? So not only was that project important for the organization that he worked for and that he was contracted out for, but it was also innovative and influential, right? Because it was impacting millions of customers in California.
Mhm.
He had judging the work of others, right? So he had done conference paper reviews, journal reviews, in data engineering related conferences and publications. He also had authorship, right? So he had worked on papers that had accumulated over 170 citations over the last couple of years, right? Um, Salary was not one that we argued on for him, right? So based on that profile, he got approved. I had a client from Meta who got approved this month. He is a AI ML engineer, and this individual was very notable in the sense that he had about 10 patents, I believe, 10 or 13 patents that had been cited over 100 times in the industry. He also had a couple of conference papers that kind of memorialized the work he was doing at Meta. And so for him, critical and leading role, yes, right? We were able to prove that the work he was doing was important at an organizational level, right? Because if you think about it, everything within Meta, is the engine behind it is recommendation systems. So the next reel that you see, the next post that you see, it's all recommendation systems. His patents helped with original business contributions. The letters of recommendations that we drafted for him were from professionals in the industry that had over 1,000 citations each, right? And we had 3 or 4 letters like that. He had salary, he had judging the work of others, he had authorship because of those conference papers, and also original scholarly contributions because those conference papers were well cited. So we argued on about 5 criteria for him, and he also went through the process just fine, right? So
Mhm.
I think, to kind of like tie a neat little bow on it, you don't have to have a PhD. You don't need to be an academic to get an EB1A, right? And that individual who I just told you the story about, who had like the 10 or 13 patents, in our consultation call, he was like, I don't think I qualify. And I was like, no, I think you do, right? Like, I think you've been told that this is what a certain profile should be for the EB1A. I think you've been told that 100 citations don't qualify, right? But in fact, it does if we, build everything carefully, if we demonstrate your industry impact carefully, we demonstrate your organizational impact carefully, I think you're going to get this. And he did, right? So there's a lot of misconceptions out there about who qualifies for the EB1A, right? And it's really important to know that anyone can build a profile towards an EB1A. Might take you a little bit of time, but you can do it.
Thank you so much, Prashant. That was really very insightful, and thank you for sharing your. I mean, on the other hand, it's also your success story. Your client success story is also your success story. So
Right.
definitely, it was really good to hear about that. So yeah, lovely having you, by the way. It's been a while, and it was such a great and insightful discussion today we had on the topic, can product managers and software engineers qualify for EB1A? And it was great having your tips today. Prashant, do you have any end note before we wrap up? I mean, it was already great, but anything else you want to leave our audience with?
Yeah. I would say, my parting thought is, or thoughts. One, Nipasa, I told you we would only get through like 4 of our questions because I take 5
It's
minutes
true.
to answer like each of them. But I'm glad we were able to answer more questions from the audience. I think the audience definitely found value from that. So thank you, audience, for asking. Thank you to the higher IT team, right, for hosting me, and making this a possibility. And also for anybody out there that's looking to explore the EB1A. I don't care if it's you coming to me or to another attorney, right? but don't be discouraged by the fact that you don't have a certain background or you don't have a PhD or you're not an academic, you're not a researcher, because I would say 50% of my clients are not, and they are still getting the EB1A. It just takes some time. It just takes the appropriate amount of preparation. And that's okay because the EB1A, it's a marathon and it's not a race, right? You are going to save yourself decades of GC processing time if you can qualify yourself for this category.
For sure. Thank you so much, Prashant, really. And we highly recommend getting in touch with a qualified immigration attorney, and why not attorney Prashant Dubey as well. And you've got his email address, and his address is sorry. How to subscribe for the newsletter is there a URL? It's my channel is asking before we go. Yes.
No, but that gives me an idea. I think I should automate the subscription process because right now I just manually enter everybody's email into the newsletter, and it like builds up my audience. So that gave me a great idea. Just email me, please, right? And
Yes.
I will make sure you get my November newsletter and all my newsletters moving forward.
Perfect. And you can email Prashant Dubey. His email address is info@dubeylawoffice.com. You can check out the spelling on the screen and note it down. Thank you so much, Prashant. Really lovely. And since we couldn't cover up most of our questions, we would really love you to join again. And even if not EB1A, we can have many other topics to discuss. If that'll be fine. I'm hoping to have you visit us regularly again.
Yes, that's the idea. Thank you for having me.
Perfect. Thank you so much. Have a great day. Have a great weekend, Prashant.
All right, see you. Bye.
Bye-bye. Thank you, friends. Thank you so much. And before we close, just a quick reminder that if you found today's episode helpful, please do not forget to like, share, and also subscribe to us. We are Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, Twitter. We're also there on Instagram. Check us out, and it'll be really lovely to have you join us. And your support helps us bring more expert discussions like these. So hit that bell icon as well so that whenever we have webinars like these, you are notified and you can join us. And in case you have more questions on this topic, you can keep commenting because we would love to get back to you. And of course, stay tuned to our channel, Immigration and Jobs Talk Show, because we have more webinars coming up today. In fact, in just an hour. And also at 4 p.m., we have Daily Immigration Dose, which I join with my co-host, Samriddhi, and it's going to be a great discussion today as well. We just started yesterday. I hope you enjoyed it, and I hope to see you later. So thank you so much for joining us today. Bye-bye for now. It's Nipasa Pradhan signing off from Immigration and Jobs Talk Show.